It's a fresh contempt petition, my lords. Proceeding out of which this contempt is arising, my lords, are directed to be listed tomorrow.
Submission, Your Lordship. Your Lordship, I have moved two memo posting of writ appeal for today, Your Lordship. Date was given, Your Lordship, out of which only one matter is listed for today. Please.
One claimant's appeal, madam. One claimant's appeal. Claimant number 1 is aged more than 90 years, and claimant number 2 is suffering from cancer. ಹೌದು, ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದೆ ನಾನು, ಪೋಸ್ಟ್ ಆಗಿತ್ತು ಬಟ್ ರೀಚ್ ಆಗಲಿಲ್ಲ. Can leave to Friday tomorrow
for recording the compromise tomorrow.
Showcase notice has been issued. National Highway matter, there is some urgency. EP showcase notice has been issued. We have filed appeal and we are ready to abide the conditions of the court. Claim against claim. Arbitration appeal against claim. Urgency. Two matters, similar matters. Please.
My lords, claimants appeal, my lords. Now they are before the local, they have been not settling. Now before they are not doing, my lords. Kindly have all the death cases, my lords. Death cases, my lords.
Not fresh matter, my lord, on Friday, my lord. Please.
My lord, may I seek a permission, my lord?
Regardless of its scope, is which is very Then your contention that where we abolish a department, unless that is challenged, they cannot challenge their termination also. And your contention that where discharge happens as a consequence of abolition of a department, it does not have to be we exact say even that happens to we covered it the base of the sun. Then that being said, we also felt that there was requirement of obtaining your permission. Whichever you are the option that the department is independent of that umbilical cord between the department and the management remains in there. And the department is only an artificial unit. And so all department of export savings, rather those, of course, they are not expected. Rather those export savings, that every department of the government live of the law. Therefore, we had that they are employees of this one. All that having been said, we decided that it is not a matter for example, the commission. This is of the it should rest. You walk in a line, and the heat is not walk. Anyway, it's all depends. Lastly, we also did not agree with your figure. Your figure, they say it is given and they we don't give on. Therefore, we came to the conclusion instead of there are the that they should be given compensation. And how much it should be taken. The other aspect, that also cannot go. They have taken money, okay, did that, and they did not tell the board, if you go to the labor court, that they have taken money. No way. No way it is. Therefore, that policy is something in my head. Every agent coming to court has to speak truth and truth alone. Therefore, we have structured the order of judgment is operating. In a rule, for litigation above. But appeal before the appellate tribunal is above, and lot of the arbitration is decided. When management is directed to be the department and the loss of the decision department, an additional sum equal to 5 times the amount specified in the respective documents. 5 times. This you have to pay within a period of 8 weeks. Otherwise, it will carry interest at the rate of 2% for the first 3 months, 3% for the following 3 years. Then the management shall pay rupees 10,000 to every workman. The pure workman is consultant and working.
Please. But we are.
Labor law is not a slave of precedent. What is meant by that? No. It has said, in other words, to do justice, the court should have power. And it should not be much more.
Exactly.
Presidential rights.
Please. Five times.
ಅದನ್ನು ಮಾಡುವಾಗ ನಾವು ಮಾಡಿದ್ವಿ ಆ ಡೇಟಿ already around actually ಅದು ಮಾರ್ಕೆಟ್ ಆಗಿ ಅವಾಗಿನ
Please.
ಪ್ಲಸ್ ಸಾವಿರ ಕೊಡಬೇಕು ಯಾಕಂದ್ರೆ ವರ್ಕ್ನಲ್ಲಿ ಎಲ್ಲ ಮಾಡಿ ಅವಾಗೆಲ್ಲ ನೀವು ಸ್ವಲ್ಪ ರಿಲ್ಯಾಕ್ಸ್
But we are grateful. Lord, your Lordship Lord gave us not sufficient opportunity, Lord. We are grateful, Lord. Please. Please. Bless.
Claimant's appeal, madam, wherein the liability has
2 days accommodation.
my lord, only ground is that case of death, my lord, the 70% liability has been saddled on the decision on the ground that the accident occurred middle of the road. If my lord may peruse the sketch and the photograph, the road width is very less, my lord. The saddling of liability to the extent of 70%. Case
has authority to dismiss, who can take disciplinary action, whether there is continuity of service, and extent of control and supervision, whether there exists complete control and supervision. As regards extent of control and supervision, we've already taken note of the judgments and so and so. However, Ms. Jain has pointed out that contractors are frequently changed, as a result of which it can be inferred that the workmen are direct employees.
That is only fact specific.
No,
Next paragraph.
this is also one more argument which is advanced, saying the employees remain the same, but the contractors keep changing. And therefore, that is a factor which, my lord, has been argued in many cases. That's a factor, therefore, to mean that the employees are really direct employees, and it is only the contractor who changes.
There are 27.
Yes, my lord. Ms. Jain then argues, since no back wages were granted, reinstatement was ordered, we should not exercise the jurisdiction of 136. When it is found that the findings of Labour Court are perverse, it is difficult to accede to this argument. Equally, the argument that the so-called employer has not complied with Labour Court's award despite being no stay is an argument that must be rejected. In that a contempt petition could always have been moved on behalf of the workmen for implementation, no such thing was done. Argument that the contract in the facts of the present case gets 10% profit, nothing more, is again an argument that needs to be rejected in view of the clear and unequivocal evidence that has been led in this case. Workmen have themselves admitted that there is no appointment letter, provident fund number, or wage slip from BHEL insofar as they are concerned. Apart from this, it is clear from the evidence led on behalf of BHEL, no wages were ever paid to them by BHEL as they were in the service of the contractor. It was specifically pointed out, names of 29 workers were on the basis of a list provided by the contractor in a bid that was made consequent to tender notice by BHEL, and therefore it was ultimately allowed. This, my lord, seems to be the consistent view taken insofar as contract labor is concerned, because if lordship sees right from what happened was 2001, till then, Lord, the law was different. Till 2001 in SAIL, because it was a reference to a constitution bench. Considering the earlier law which existed, Lord.
This is a DB.
Which one, Lord?
The
This
one
is a
that
DB. 2001, the first judgment.
First judgment, which they have considered in this judgment.
Which they've considered. I'm not reading it, but I wanted to place all the judgments, Lord, which are there on this issue. Because the stand earlier, which stand, Lord, seems to have been uniformly followed was, if there is an abolition, it has to be a consequent regularization. If there's abolition of contract labor, then it means that there cannot be a contractor and therefore you must absorb directly.
That's not the correct position.
Supreme Court says that is not the correct position and says you must go the next step to establish a factual, make a factual finding that a particular person was employed under a sham transaction.
Where is your contract? How you entered into arrangement with the supplier of the labor?
I don't think all those records are.
Document hengide, how it is structured.
I don't think those records are here, Mala. Those
ನಮಗೆ ತೋರಿಸಿ.
ಅಲ್ಲ, ಅದು ಹಾಕಿಲ್ಲ.
ಇಲ್ಲ.
I can file a paper book then.
ಆ ಕಾಂಟ್ರಾಕ್ಟ್ ನಡುವೆ ನಿಮ್ಮ ನಡುವೆ ಯಾವ ರೀತಿ ಸಂಬಂಧ ಏರ್ಪಟ್ಟಿದೆ ಅಂತ ನೋಡಿಕೊಳ್ಳೋದು ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಆಗ್ತದೆ.
Correct. That is true.
ಬೇಕಾಗ್ತದೆ.
ಹಾಕ್ತೀನಿ. I'll file it.
ಈ ವಾಟ್ಸ್ಆಪ್ ನ ತರಿಸಿ.
May I make a submission? The
ಇದೆಯಾ
court
ನಿಮ್ಮ
has object, with permission.
ನಿಮ್ಮಲ್ಲಿ ನಾವು ಕೇಳೋ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಇದೆಯಾ?
Yes, sir.
ಎಲ್ಲಿದೆ ಕೊಡಿ.
Sir, there is no contractor and no contract. Both. ಎರಡೂ ಇಲ್ಲ. And that's what
ನಿಮ್ಮಿಬ್ಬರ ನಡುವೆ ವ್ಯವಹಾರ ಹೆಂಗೆ ಏರ್ಪಡುತ್ತೆ?
Yes, Lord.
ನಿಮ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ,
Yes.
ಎಲ್ಲಿದೆ ಡಾಕ್ಯುಮೆಂಟ್? ಇಟ್ಸ್ ನಾಟ್ ಸಮ್ private enterprise.
No, it's not. It's not at all.
Government.
As a matter of fact, the case itself has been, and the industrial tribunal has examined it length.
ಅದು ಮಾಡ್ಲಿ. ಈಗ ನಾವು ನಿಮ್ಗೆ ಕೇಳ್ತಾ ಇದ್ದೀವಿ. ನೀವು ಈ ಕಾಂಟ್ರಾಕ್ಟ್ ಲೇಬರ್ ಅನ್ಬೇಕಾದ್ರೆ ಒಂದು ಅರೇಂಜ್ಮೆಂಟ್ ಬೇಕಲ್ಲ?
Yes, ಇದು ಟೆಂಡರಿಂಗ್ process.
ಕಲ್ಲಪ್ಪ entered into agreement to sell with Mallappa is not that case.
No.
There are entities now.
There are
All
all
these entities have conducted themselves. What are the records? How records are generated? Show that to us.
Yes, I can.
Private ittu andre we would not have.
Of course.
You are an entity.
We are an entity, my lord, under the water supply.
They are an entity. Therefore, show us how government does.
I'll have to get them and place them.
Huh?
I'll have to place them. All the records I have to place them. We were.
But idiste prashne.
I understand.
Udidalla other things alla. If this trump card falls down, if you can trump the card, then rest of the things will take place.
No, how the conduct of how the employees, my lord, were paid, one, and how, my lord,
How? Not that question arises, provided you show that the vinculum juris is between the contractor.
Correct.
And yourself.
Yes, my lord.
ಅದೆಲ್ಲಿದೆ? ಅವಾಗ ಇದು ಮುಂದಿಂದೆಲ್ಲ ಪ್ರಶ್ನೆ ಬರ್ತದೆ.
May I draw attention of the verdict of industrial tribunal, page 70, kindly.
ಅದು ನೋಡಲ್ಲ ನಾವೀಗ. That is
No, it has
a challenge.
legally
We are
offered
asking
out
you, we are asking you, how? Please be seated. You are only demolishing your case. Please do not do that. How? ಈಗ ನಡುವೆ ನಾವು ಕಾಂಟ್ರಾಕ್ಟರ್ ಇಟ್ಕೊಂಡು ಅವ್ರ ಮುಖಾಂತರ ಮಾಡ್ಕೊಂಡಿವಿ ಅಂತ ನಿಮ್ ಕೇಸ್ ಇದೆ ತಾನೇ?
Yes, yes, yes.
ಆ ಕಾಂಟ್ರಾಕ್ಟರ್ ಜೊತೆ ನಿಮ್ ವ್ಯವಹಾರ ಯಾವ ರೀತಿ ಇದೆ? ಅದು ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ ಆಗ್ಬೇಕಲ್ಲ. ಅದ್ ಹಂಗ ಮಾಡಿ ಬಾಯಿ ಮಾತಿಂದ ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ. This is because it is an entity.
True.
Statutory entity.
There are work orders which are there on record, but not here. There and referred to in the labor courts.
ವರ್ಕ್ ಆರ್ಡರ್ ಆಗಲ್ಲ ಅದು.
No, the work order which is issued to the contract, which has the terms and conditions.
ಕಾಂಟ್ರಾಕ್ಟ್ ಬೇಕಾಗ್ತದೆ.
Yes, Lord.
ಅವ್ರ ಜೊತೆ ಯಾರು ಕಾಂಟ್ರಾಕ್ಟ್ ಮಾಡಿಕೊಂಡ್ರು? Who entered into contract?
ಅದೆಲ್ಲ ಇದೆ.
What were the terms of contract?
It will be there in the work order. The work order, my lord, which is issued.
Work order ಆಮೇಲೆ ಬರ್ತದೆ.
ಇಲ್ಲ, work order, my lord, is straight away issued. As a matter of fact, my lord, either a contract is issued or a work order is issued.
ಅದೆಲ್ಲಿದೆ? ಆ ವರ್ಕ್ ಆರ್ಡರ್ ಇದೆಯಾ?
ನನ್ನ ಹತ್ರ ಇವಾಗಿಲ್ಲ.
ಮತ್ತೆ ನೀವೆತ್ತು ಅಲ್ಲ ಹಂಗನಕ್ ಬರಲ್ಲ.
ಅಲ್ಲ, I don't have it right now.
You should have disclosed everything to the tribunal.
Tribunal ಹಾಕಿದೀವಿ.
ಅದೆಲ್ಲಿದೆ?
No, I'm saying the records of the tribunal, not before the lordship. That's all. I'm not saying, lord, that.
They were produced before the
Yes,
tribunal.
yes. Page 190 will refer to, my lord, the document.
Tribunal orders ಇದಾವ?
Tribunal order is there.
ನೀವು ಏನೇನ್ ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆಯಾ? ಅಲ್ಲಿ ಯಾರಾದ್ರೂ ರೆಕಾರ್ಡ್ ಇದೆಯಾ? ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ ಅವ್ರು ಏನೇನ್ ಹಾಕಿ ವರ್ಕ್ ಆರ್ಡರ್ ಇದೆಯಾ? ಕಾಪಿ? ವರ್ಕ್ ಆರ್ಡರ್ ಕಾಪಿ ಕೊಡಿ.
Lord, the work orders exhibit M2 to M8.
M2 to M8.
M2 to M8.
ಎಲ್ಲಿಂದ ಬರ್ಬೇಕಿದು? ಎಲ್ಲಿ ಟ್ರೈಬ್ಯುನಲ್?
One second.
ನೋಡ್ರಿ, ಫೋನ್ ಮಾಡಿ ಇಮಿಡಿಯೇಟ್ಲಿ ಕಳ್ಸಕ್ಕೆ ಅರ್ಜೆಂಟ್ ಕಾರಣ ಕಳಿಸ್ಬೇಕು ಅಂತ ಹೇಳ್ಬೇಕು. ಬಂದಿದ್ಯಾ? ಕೊಡಿ, ತೆಗಿ. ಬಂದಿದೆ. ತೋರಿಸಿ.
I think, well, unfortunately, it was not placed before the single judge, which is why in the writ appeal it's not come.
Anyway, we'll look into it.
May I just read one paragraph of the order of the labor court?
Page number?
Page number 164 in 100172. 1001, the lordship has 172.
Page number?
Page number 164. Para 30.
Our licensed contractors ಇರ್ಲಿಲ್ವಾ?
They also didn't have licenses.
They were not
under the
licensed contractors.
Not licensed contractors, because I couldn't, my lord, obviously, my lord, without, when there's an abolition, they couldn't have a license. Since there was an abolition of contract labor under section 10 of the Contract Labor Abolition Act, therefore, my lord, the allowing of contract labor to be employed may have been wrong. But may I just, I'm so sorry.
Yeah.
Can I request, my lord, to kindly come to 163 first? How the
163.
court, my lord, 163-29. This is where the labor court, in my humble submission, went wrong. Further, as per citation report and so, Gujarat Division Bench, Food Corporation of India versus Food Corporation of India, Lordship of Honorable Gujarat High Court held as follows. Certificate of registration obtained by principal employee issued by appropriate government. License is to be obtained by contractors under provision section 12. Workmen can be employed only through licensed contractors. Unless both these conditions comply with, provision contract labor will not be attracted. Both these conditions are required to be fulfilled if one wishes to avail provisions of the Act. Even if one of the conditions not complied, provisional contract labor will not be attracted. In such a situation, when either of these conditions is not satisfied, position would be that a workman employed by an intermediary is deemed to have been employed by principal employer. This is the finding, my lord, of the Gujarat High Court, which ultimately in sale went, because that was a subsequent judgment, which was not unfortunately noticed. Then please see para 30.
This Gujarat was not put in challenge before Apex Court.
No, my lord, I don't think this was put in challenge, but ultimately this was a 92 judgment, and sale, my lord, is 2001. Therefore, when this was decided,
What in variance with the Gujarat Apex Court has said something?
that's what, my lord.
Very.
That's what sale. The first judgment is that
Now, whatever be the, it is not your case that the Contract Labor Act is applicable.
no, I'm not saying. I'm saying, Lord, it is applicable because there was an abolition. Under section 10 of the Contract Labor Act, Lord, for this work, government had notified that you can't employ contract labor, and therefore employment of contract labor was barred. The question was, if you have a notification of that kind and you still employ contract labor, will that necessarily mean that they become the employees directly of the principal employer, namely us?
Answer has to be subject to exceptions has to be yes only, because suppose if that, like, the middleman, if he had license under the act, then it would have taken a different color.
Then, my lord, the question of absorption would never arise.
Correct.
If there was a license.
Correct.
Which is why the question arose in sale as to the abolition. If there is an abolition, is there a consequential requirement to regularize or absorb? Answer was no.
Directly may not be.
No.
Answer is no to this question. That immediately will not result into absorption is true.
No, not immediately. I'm saying whether at any point of
As
time.
a consequence.
As a consequence of abolition, will he therefore become an employee of the principal employer? Answer was held no. That is, my lord, the entire concept, because earlier judgment, which was referred, two-judge bench, my lord, referred this issue because there were two conflicting three-judge benches.
But you have violated the statute.
Considered by sale. Considered by sale.
But therefore, can you take advantage of some construction built on that statute which you have violated?
Yes.
That's another question.
That is the question, Lord, which arose for answer in this case as to what is the consequence. Because that, my lord, became the precise question in all these cases. Till then, my lord, there was a consequence of absorption or regularization. I will not go into terminology there. One of the two, in so far as those employees were concerned. And therefore, it was referred to a larger bench to answer the question as to whether it would mean the abolition would maybe as a consequence lead to absorption at some point in time. Answer was no. It does not automatically. The only way you can go into the question of absorption is that you must prove that the transaction is a sham transaction.
That itself, in those cases, there was a, there were elements of shamness, and therefore apex court said that way. But I have taken in one judgment, it need not be confined to a sham transaction. Even if it is a genuine transaction, still benefit has to be granted of regularization, absorption, etc.
In contract labor, my lord.
In contract labor.
Lord, I think your lordship may have to look at these judgments to just examine, my lord. I don't know. I don't want to say something contrary to what your lordship has held. But I would only request your lordship to examine these for a minute to see. And my lord, also.
Now question is whether there is a contractor.
There is a contractor. There is no dispute.
Where is that material? A department contract.
And my lord, the work not shall be as per the terms and conditions of the quotation. The quotation, my lord, your lordships know, in tenders, the tender has the terms and conditions. And the work order is issued whereby the terms and conditions are read into it.
Preceding this work order.
Yes.
There is no written instrument between you and the contractor. Is there?
Allah.
Everything.
Other tender conditions will be there. That will be there in the tender conditions.
Adilli there.
ಅದು ಇಲ್ಲಿ ಹಾಕಿಲ್ಲ. They have directly produced the work order to show my lord. What happened was a work for a particular purpose. Like for instance, it was not for supply of contract labor to us. As a matter of fact, the work is to carry out the valve operation. You employ certain people to carry out the valve operation.
ಅದು ಕರೆಕ್ಟ್. ನಾವು ನಡುವೆ ಒಬ್ರು ಇದ್ದಾರೆ ಅಂತ ಎಸ್ಟಾಬ್ಲಿಷ್ ಮಾಡ್ಲಿಕ್ಕೆ ವರ್ಕ್ ಆರ್ಡರ್ ಬರಲ್ಲ, ಕಾಂಟ್ರಾಕ್ಟೇ ಬೇಕಾಗ್ತದೆ. ದೇರ್ ಇಸ್ ಎ ಮಿಡ್ಲ್ ಮನ್ ಅಂತ ಹೇಳುವಾಗ that's what work order is always pursuant to tender being accepted, some contract being generated, a deed instrument being generated, then work order. This is how generally courts have treated also. Generally, I don't think, even going by what you read now,
Yes.
of course we will see it again, it is preceded by a contract if there was one.
My lord, how it reads, I'll just read this, my lord. It's to one Mr. Hulgur. Says your offer for the following works are hereby approved by the undersigned as under and amended to HTWS for the year 2009-10. One is carrying out valve operation. The price is 7,552. Maintenance of water supply in ward number so and so, 34,000. Maintenance of water supply system in ward number so and so, 15,168. The work shall be taken up as per the.
ನಿಮ್ ವರ್ಕ್ಮೆನ್ ಅನ್ನೋರು ಇಲ್ಲ, ಅವರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಕೋರ್ಟ್ ಸುತ್ತಲೂ ಒಂದ್ಸರಿ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ ಅಂತ ಹೇಳಿ, ಚಂದಿದೆ ಕೋರ್ಟ್, ಒಂದ್ ಸ್ವಲ್ಪ ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ. ಈಗ ಅವ್ರು ವಾದ ಮಾಡ್ತಾ ಇದಾರೆ, ನಾವು ಕೇಳೋಣಂತೆ. ಯಾರು ಒಂದ್ 3-4 ಜನ ಲೀಡರ್ಸ್ ಇರಿ, ಇನ್ನುಳಿದ್ರೆ ಜಸ್ಟ್ ಹಂಗೆ ನಮ್ ಕೋರ್ಟ್ ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತದೆ, ಜಡ್ಜ್ಗಳು ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ, ಲಾಯರ್ಗಳು ಹೆಂಗ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ, ಎಲ್ಲರನ್ನು ನೋಡ್ಕೊಂಡ್ ಬನ್ನಿ, ಉಪಯೋಗ ಆಗ್ತದೆ. ನಾಳೆ ಇನ್ನೊಂದ್ ಕೇಸ್ ಬಂದಾಗ ಏನೋ ಒಂದು ಹೊಸ ವಿಷಯ ತಿಳಿತದೆ. ಹೋಗಿ ಒಂದ್ ರೌಂಡ್ ಹೋಗ್ಬನ್ನಿ, ಸುಮ್ಮನೆ ಸಫಕೇಶನ್ ಸಫರ್ ಆಗೋ ಬದ್ಲಿ. Yes. How learned single judge treated this subject?
No, I know, my lord. What happened was, learned single judge followed whatever was held by the industrial tribunal as is. There is no consideration of all of this. May I just request, my lord, look at one paragraph for a minute. Para 30, page 164.
164 reproduces what Gujarat said.
But the conclusion on shamness is at page para 30. In the present case in hand, respondent board is not registered under section 7 of Contract Labor Regulation Act. For the contractors, please see this, my lord. For the contractors who have supplied contract labor to the respondent have not obtained licenses under section 12. Section 9 of the Contract Act states no principal employer of establishment is not registered shall not employ contract employees. Further, Lordship of Honorable Gujarat High Court in the above referred citation clearly held, in order to apply contract labor 1970, principal employer has to register as per section 7 of the Act, and contractors who are supplying contract labor to the principal employer have to obtain license as per section 12. Lordship in the above cited decision have held, if any one of the conditions not complied with, provisions of Contract Labor Act will not attract, have held that in a situation where either of these two conditions is not satisfied, the position would be that the workman employed by the intermediary is deemed to have been employed by the principal employer. In the present case in hand, also respondent board failed to comply both conditions, that it is not registered under section 7 and failed to prove that contractors who supplied contract labor obtained license under section 12, which attracts in the present case. Further, in the situation in view of the principle laid down in the above case, Honorable Gujarat High Court, workmen employed by the respondents be treated as employees of the respondent board. So contention of the respondent board that first party claimants are workmen of the contract and no relation to employee exists between them is unacceptable.
ನೀವು ಹೇಳೋದು ಶಾಮ್ನೆಸ್ ಫೈಂಡಿಂಗ್ ಇರೋದು ಹೊರತು ಏನು ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತಿರ್ಲಿಲ್ಲ. ಈ ಶಾಮ್ನೆಸ್ ಆಸ್ಪೆಕ್ಟ್ ಅನ್ನ ಗುಜರಾತ್ ಹೈಕೋರ್ಟ್ ಟ್ರೀಟ್ ಮಾಡಲಿಲ್ಲ. 2019 ಟ್ರೀಟ್ ಮಾಡಿದೆ, 2001 ಟ್ರೀಟ್ ಮಾಡಿದೆ, 2019 ನಲ್ಲಿ ರೀಟ್ರೇಟ್ ಆಗಿದೆ. ಅನ್ಲೆಸ್ in other words, it's a sine qua non. Without that, straightway they could not have done this case.
That is not what I'm saying.
One contention. Other contention.
Then, Lord, the second finding is Uma Devi. Now, what the industrial tribunal did is went into Uma Devi and said, because of 3 conditions are not met, therefore the question of regularization does not arise. Therefore, we succeeded before the industrial tribunal. That, my lord, was examined by this honorable court, and this honorable court, my lord, only on that contention held that Uma Devi will apply, and that therefore, since they have been employed for a long time, that therefore they should be necessarily regularized. That, my lord, is the finding. The judgment of the learned single judge, my lord, is at page 57.
Yes.
The consideration, my lord, is at page 67. Please see, my lord, at para 11, the learned single judge at para 11 says, Industrial Tribunal, after examining the evidence on record, while answering issue number 1 at para 30, in ID number so and so, which I just read to my lord, he extracts it, and then says at para 12,
ID number, so and so is
same thing. It's
para, that is page 93 of the book. The rulings which you have given, na? That one.
Allah.
Allah.
The para 30, my lord, is the Industrial Tribunal's order.
They followed Gujarat, na?
They followed Gujarat.
That's what.
They followed Gujarat. Then para 12. Then the only conclusion here is at page 71. Lord, at page 71.
7-1.
7-1. After extracting International Airport Authority of India, finding recorded by the tribunal is based on evidence on record. It cannot be said it is based on improper evidence or no evidence at all. Hence, I do not find any illegality. Abolition is equal to regularization.
Because of Gujarat.
Because of Gujarat, but did not notice the judgment of the Supreme Court in sale and subsequent till 2019, when all the principles were culled out and said, of course, in some ways we are to blame for it. We did not place it before the court. It's very easy for us to say that the court did not see it, but we should have placed it before the court. But then, my lord, I would only say that was the law which existed at that point in time. Then the question of regularization is done on the basis of Uma Devi. But Supreme Court says Uma Devi is not, my lord, relevant to the contract labor issue at all. It is ultimately, my lord, in some way service jurisprudence, of course, as to how Uma Devi has been analyzed. But if your lordship sees 2001 till 2019, on contract labor, there's been a separate set of judgments which evaluates it differently. And evaluates it on two principles. Abolition is not, if there's no abolition, my lord, and it's a licensed contractor, then there is no consequence. Then, of course, there's no consequence at all. There's no question of absorption. The question of absorption or regularization only come when there is a abolition, and still, notwithstanding that being the law, there has been some element of contract labor being utilized. And of course, not in all of this, the most interesting situation is we were under a contract with Hubli Dharwad Municipal Corporation to carry out water supply work. We ourselves were contractors. Now, my lord, Hubli Dharwad Municipal Corporation had to supply water to the entire Hubli Dharwad area. They entrusted it to us. We, my lord, engaged contractors to carry out the work. The contractors engaged laborers to carry out the work of that. Because the nature of the work, my lord, really was the carrying out of a particular action. It was not the supply of contract labor to us. If your lordship sees the work that is given, the work order is actually the
accomplishment of the work.
Accomplishment of a task.
Supply of the labor for doing the work.
It was not supply of labor. It was accomplishment of the task, which is what we were paying for. And we have produced material to show that the contractors were paying their PF, ESI, and all those payments were being made by them. All of that evidence was on record. If, my lord, BHEL is followed strictly, then not the question of them having any right to make a claim. As
in BHEL, there was an independent contractor.
Yes,
there was no much a dispute about that at all. But whether there is a contractor or not, that itself is one of the important.
But the finding of the labor code is there is a contractor. The finding your lordship saw at para 30.
But he was not licensed. Question of license also will not arise because of the notification.
I can't get a license to carry out the work. Which is why I said, not if there was no abolition, there was a license, then the question doesn't arise at all. There would have been the end of all those arguments. But there are two parts to it. One is it was not a work order issued to supply labor. It was a work order issued to carry out a work, namely wall work.
ಅದು ಆ ಕಾಂಟ್ರಾಕ್ಟ್ ನಮ್ಗೆ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ಮುಂದಿಂದೆಲ್ಲ ನಮ್ಗೆ ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ, ವರ್ಕ್ ಆರ್ಡರ್ ವರ್ಕ್
tender-
nature of the work is there.
ಅಲ್ಲಿ ಅದು ವರ್ಕ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ, that itself establishes the presence of an independent contractor ಅಂತ ನಮ್ಗೆ ಸ್ವಲ್ಪ ಅದು we have to look into is another thing. But you can come out with stronger case if you produce your independent contract, which was not produced and marked as a piece of evidence before the tribunal also.
Of course not.
No reason is given as to why.
No
that's
reason
not-
is given. There's no reason at all by the industrial tribunal.
No, you have not given any reason why that was not, it's not your case. This is the only document whereby the independent contractor came into contact with us. That's not your case.
Lord, that of course I don't want to hazard a guess right now, Lord, because the question.
Which other point you have?
Lord, this will not in my respectful submission the entirety of my argument.
That's
the argument I have, was the entire list of outsourcing, or the, I don't want to call it outsourcing, Lord, it was really contracts given over the years from the beginning till the end to various contractors to carry out various different parts of the work in different stages of the work.
Just give us brief idea, a thumbnail sketch of Contract Abolition Act.
Yes.
Contract Labor Abolition Act, how it functions.
Lord, first of all, the requirement is the requirement, Lord, that I must register myself.
The object of the act is to abolish
contract labor.
Contract. There should not be middlemen. If at all you want to hire services, you should do it on your own.
Correct.
Though the broad policy, parliamentary policy is there should be no middleman.
Correct.
Number one.
Yes.
Correct?
Yes.
Then how it operationalization of this idea?
Then Lord, 10, section 10.
10 is government issuing the notification.
Correct.
Central
It's the
government issues
prohibition.
the
It's
notification.
the prohibition. The prohibition comes by virtue of a notification issued under section 10.
Till then, act will not apply at all.
Won't apply. If there is no prohibition, you can employ contract labor, but you must follow the mechanism.
Okay. Regulatory
mechanism. But if there is a prohibition, you are not supposed to employ.
If there is prohibition, you are not supposed
to employ.
There was such a prohibition.
In this case, there was a prohibition. Now, of course, it is an argument, Lord, which is still open as to whether the work entrusted to the contractors was actually provision of contract labor, or was it simpliciter entrustment of work to the contractors. Lord, now, these things, Lord, in my humble submission, constantly will occur, where these works are valve operation works in different places, because water has to flow, and therefore the valve operation is given to a contractor. Now, the contractor, my Lord, in year 1 may not be the contractor in year 2. There may be someone else who's a contractor to whom a work order is issued.
In this case, 4 contractors are changed.
They're changed, Lord. They've been
4
changed.
contractors.
They've been changed. But the people, Lord, who carry out the work remain the same. In my humble submission, that will not make a difference, because when a contractor comes, he would rather have someone who's already carrying out the work to be engaged for the same work.
Prohibition notification is dated
2/11/2006.
Section 10 notification.
Section 10 notification.
Any other point you have? We have grasped what you have said.
Yes,
now.
Lord. Lord, of course, I had spent a lot of time on Uma Devi, but having now considered it entirely, I would respectfully say, Lord, having looked at these 4 judgments, which I think I would place them for your Lordship's consideration, the entire set of judgments from Uma Devi onwards may not be of much relevance. Because if those 3 quest principles are to be enunciated, which Uma Devi said and laid down in para 54.
Uma Devi operates on the state employment, not state industry.
Correct.
State employment nalli, alli post, sanctioned post, vacancy,
irregularity or illegality.
Idella bartade. Adra jate it is all interwoven in that. How that will be? These are all workmen.
No, it will be, because I'm now in challenge to the order. In the order that I'm challenging, my Lord, the court relied on Uma Devi and the subsequent judgments in granting relief.
No, court denied relief to them.
Industrial tribunal denied.
Relief.
This honorable court,
but single judge gave the relief on
the same
basis
principle.
of Uma Devi.
Not on the principle, my Lord, which is laid down by these 4 judgments.
Now, 2 things here. You are in appeal now.
Yes.
An appeal is a complaint against the judgment of a court below to the court above in the hierarchy.
Yes.
That judgment is wrong.
Correct.
And it is unsustainable.
Yes, ma'am.
Not just wrong.
It's in my humble
Otherwise, judgment is sustainable. Judge has said so many errors, committed so many errors. That will not add merits
Oh,
to
no,
your
no,
case.
I'm not saying that. I'm saying, Lord, it is a fundamental error which goes to the root of the issue. Because the law,
Uma Devi is excluded.
let me exclude Uma Devi, Lord, there is no judgment for regularization. There is no other finding on regularization, Lord. I'm only saying this, Lord. If either of the courts had examined these 4 judgments and had returned an answer that this transaction is a sham, or as your lordships put, not because of the length of service or otherwise, I will ignore these transactions because it has occurred in a particular fashion. Then, my lord, there is a finding of fact. Today, the finding of fact insofar as shamness or otherwise is simpliciter Gujarat High Court. And that judgment has been followed, my lord, by this honorable court, by the learned single judge, also in the same fashion, without examining as to whether Gujarat High Court still continued to be the law.
Because of 2019.
Because of 2011.
2000?
2001.
One also.
2001.
One is reiterated
In 2019. I mean, it remained, my lord, the law, because after 2001,
Gujarat is of which year?
96.
So before 2001.
Before 2001. And then, Lord, International Airport Authority was 2009, this is Ravindran's judgment. And then, my lord, was BHL, 3 judgments. According to me, my lord, these 3 judgments encapsulates the entire law with respect to contract labor, abolition, contractors, and absorption or regularization. And if your lordship look at these 3 judgments, my lord, in my humble submission, this is the law. Now, it had to be applied. In my humble submission, it is not, at least if it was applied, my lord, by the learned single judge, one can say, in the mere irregularity of applying, one cannot challenge it. But if it is not even applied, and it is not even fallen for consideration, then in my respectful submission, being a constitution bench judgment, it will become, my lord, in my respectful constitution bench, or otherwise not being the Supreme Court judgment which has answered all these questions. It couldn't have been an answer on the basis of Umar.
But your client has also violated that Contract Labor Act, Abolition Act.
Yes. That is the question which arose in BHEL as well, my lord, because central government would also issue a notification abolishing Contract Labor Act. And the question was, can you then absorb? Answer was, you can absorb only in the circumstance that you make a finding of fact. And in all these cases, my lord, that finding of fact has not been made.
Self-contained code, CLR is a self-contained code.
What the learned single judge has said in the order, operative portion of the
The
order?
operative
Let's
portion, Lord, if my Lord may kindly see how it was examined.
But you had also 4 writ petitions, 2 writ petitions.
My Lord, we filed 2 writ petitions.
Why?
Because, my Lord, the one finding was against us. The finding of employer-employee relationship was against us. We challenged that.
Only finding.
We challenged it, my Lord. The writ petition was filed. We could have, of course, simply opposed it in the other writ petition, but they filed it. They filed 2, and the workmen filed 2, my Lord, because their regularization request was rejected. Please see point number 2 at page 72, my Lord. There is a complete consideration of Nihal Singh. Lord, I must say one thing, my Lord. Between Uma Devi till Delhi University, which are the 2 ends of the spectrum in Uma Devi, there have been a large number of judgments in between which have taken oscillating views. One following Uma Devi to the hilt, the other, my Lord, deviating from it. But ultimately, Justice Lalit, my Lord, holds that all those judgments do not laid on the correct position in law, because you are bound by Uma Devi, and those 3-pronged tests must be satisfied, without which you cannot absorb.
No, what I did not understand is how Uma Devi operates in industrial jurisprudence. I do not know. In one judgment, very frugally I treated.
No, but there is
Service jurisprudence is one thing, industrial jurisprudence is another.
Correct.
How books have been, in
Yes.
fact, lot of literature has been, legal literature has been developed. How Uma Devi traveled from this compartment to that?
I'll just show you, Lordship, one paragraph, my Lord. I think I'll just find it. It is there in this 3 judgments, where they've said the consequence of contract labor and what should happen is a matter for the industrial tribunal to decide, or the labor courts to decide, and it is not covered under the writ jurisdiction of the court. It is not an Uma Devi issue at all, which is why, my Lord, though I have 2 volumes of all judgments which I got because I wanted to see if we must analyze it entirely. I'm not citing all of them because I personally think, my lord, it would be a complete waste of your lordship's time. Please see, my lord, in the judgments which I've now given.
Where are the posts for regularization?
Beg your pardon, my lord?
Where are the posts?
There are no posts for
vacancies,
regularization.
etc.?
There's no posts.
Why? Therefore, regularization of service in service jurisprudence is one thing. Regularization of services of the workmen is another.
Yes.
They are another. They are set. They are treated by 2 different statutes. For example, for regulation, etc. You have now 2012 Act.
True. That act, my lord, of
Act
daily
is
wages.
That act is there. For this, of course, it's a byproduct of Uma Devi.
It's a
perhaps,
byproduct of Uma Devi.
that way. But for this is industrial dispute.
Industrial disputes.
There are 2 different streams.
True.
Although they may go together, they may not conflict with each other.
Yes.
Nor there will be confluence of the 2, but they maintain their independent streams.
True. Which is why, my lord, the learned single judge ought not to have examined the principle underlying Uma Devi to grant relief of regularization to these employees. Now that becomes an error apparent.
Which is the leading judgment on regularization of workmen in the industry?
Yes. See, Maharashtra, if he is there, Vikram.
Vikram,
Yeah, yes, my lords, I'm sorry. I'm sorry, my lord.
Vikram.
Yes, my lord.
Lead judgment
Yes, my
on
lord.
regularization of the laborers in the industry, workmen in the industry, which is the judgment.
I'll just pull it out, my lord. There is one compilation I prepared. Not sure it carries up. I'll just look it up, my lord. There is one judgment of caste tribe, my lords, 2009.
ಅದಕ್ಕೆ Uma Devi ಬರ್ತದೆ.
May I only request one, just to show you sale, at page 49 of my judgment compilation,
Your compilation.
para 88 and 89, at page, running page 49.
Vikram, now Dhan has given you some leverage.
Yes.
You can make use
Lot
of
of
that,
food for
find out that judgment.
Yes, my lord, yes.
Which,
That page, running page 49, this is the constitution bench, para 88. If we say so, the eloquence of the CLRA system in not spelling out the consequence of abolition of contract labor, discerned in the light of various reports of the Commission and committees in the statement of objects and reasons of the Act, appears to be that Parliament intended to create a bar on engaging contract labor in the establishment, covered by the prohibition notification, by a principal employer, so as to leave no option with him except to employ the workers as regular employees directly. Section 10 is intended to work as a permanent solution to the problem, rather than to provide a one-time measure by departmentalizing the existing contract labor who may, by a fortuitous circumstance, be in a given establishment for a very short time.
No specific automatic absorption anta ಅವ್ರು ನೀವು
How? Then the approach.
ಆ ಆಕ್ಟ್ ನಲ್ಲೇ ಇಲ್ಲ ಆ ಪ್ರಾವಿಷನ್.
ಇಲ್ಲ. ಆಮೇಲೆ 105 on this beneficial legislation argument.
89 also.
Yes, 89. Yes, 89. 89, of course, is that consequence of automatic absorption. Then at 105, what is the consequence of beneficial legislation argument?
So act has itself has not provided for absorption, therefore it cannot go to
Cannot.
that extent. ಅಂತ ಒಂದು.
Then please, 105, 104 and 105. 104, my lord, they do not agree, and then 105. My lords have it.
Yes.
Page 55. Principle that a
55.
beneficial legislation needs to be construed liberally in favor of the class for whose benefit it is intended does not extend to reading in the provisions of the Act what the legislature has not provided, whether expressly or by necessary implication, or substituting remedy or benefits for that provided by the legislature. We already noted about the intendment of CLRA, regulates the conditions of service in the contract labor, authorizes it in section 10(1), prohibition of contract labor by the appropriate government on consideration so and so factors. But the presence of some or all of those factors in our view provides no ground for absorption of contract labor on issuing notification under subsection 1 of section 10 Admittedly, when the concept of automatic absorption of contract labor as a consequence of issuing notification under 10(1) is not alluded to either in 10 or at any other place in the Act, and the consequence of violation of section 7 and 12 of the Act is explicitly provided in section 23 and 25. It is not for the High Court or this court to read in some unspecified remedy in section 10 or substitute for penal consequence as specified in section 23 and 25 a different sequel, be it absorption of contract labor and the establishment of principal employer, or of a lesser or harsher punishment. Such an interpretation of provision of statute will be far beyond the principle of ironing out the creases and the scope of interpretative legislation, and as such clearly impermissible. We've already held above on consideration of various aspects. It is difficult to accept that Parliament intended absorption of contract labor on issuance of absorption notification under section 10 of the CLRA Act.
Yes.
Then 107, Manoj, on the next page. An analysis of the cases discussed above show that they fall in three classes, where contract labor is engaged in or in connection with the work of an establishment. Employment of contract labor is prohibited, either because the industrial adjudicator court ordered abolition of contract labor or because the appropriate government issued notification under section 10(1)(a). No automatic absorption of the contract labor working in the establishment is ordered. 2, where the contract was found to be a sham, nominal, rather a camouflage, in which case the contract labor working in the establishment of the principal employer were held in fact and in reality employees of the principal employer himself. Indeed, such cases do not relate to absorption of contract labor, but present instances wherein the court pierced the veil and declared the correct position as a fact at the stage after employment of contract labor stood prohibited. 3, wherein discharge of a statutory obligation of maintaining canteen and establishment, principal employer availed the services of a contractor. Courts have held contract labor would indeed be the employees of the principal employer. Next issue which arises, whether the contractor engaging contract labor in connection with the work entrusted to him by the principal employer, relationship of master and servant between him and the contract labor emerges. That, my lord, is answered.
120.
(120). 120.
We have also perused it.
All the rules and forms prescribed thereunder. It is clear that at various stages there is involvement of the principal employer. On exhaustive consideration provision of CLRA, we have held above that neither they contemplate creation of a direct relationship of master and servant between the principal employer and the contract labor, nor can such relationship be implied from the provisions of the Act on issuing notification under section 10 of the CLRA, a fortiori. Much less can such a relationship be found to exist from the rules and the forms made thereunder. Then, of course, not para 125 is
Upshot of the above
upshot above discussion outlined below. Your lordship may look at para 3 to 6.
Five also.
3 to 6, not all of them.
3 to 6.
3 to 6. Neither so and so. They overrule Air India prospectively.
There is no question of automatic absorption.
There is no automatic
in
absorption.
contention.
And the finding lot of both learned single judge as well as the industrial tribunal is that it is automatic.
They proceed on that assumption.
They proceed on that assumption, which my respectful submission was wrong. Then, Lord, please see the next judgment at page 69.
The appellate authority.
International Airport Authority. A similar issue, my lord, again, with respect to your lordship will find the facts in the first page itself.
So genuine or sham is
Genuine
the
or
question. This all came to be reiterated in 2019.
2019, my lord, actually laid
This
down
is like
those.
Bible on the subject.
19 laid it down completely. Now, my lord, the point that I'm making before your lordships is, I'm of course not saying that they should be disentitled today itself. But that is a consideration which the industrial tribunal ought to have made. And not what the answer would be as a consequence of the consideration, Lord, I'm saying has not been done, either by the industrial tribunal or by the learned single judge. And therefore, my lord, when I'm in appeal before your lordships, I have to ultimately point out to your lordship that if these are the principles of law laid down, those are the principles which must have been applied by the industrial tribunal in returning an answer on this question. And then saying whether it is sham or not. It could be not. They could say it's a sham, but I would respectfully say it was never a contract for providing employees or workmen to carry out the work. It was to achieve a particular objective. If in achieving or saying that you're achieving the objective, someone was employed regularly by different contractors over a period of time, can it then be said that it is a contract? Why? I don't even think it's a violation of the Contract Labor Act.
Yes.
I'm only trying to find that one judgment note where Supreme Court said contract labor issues have to be ultimately dealt with by industrial tribunals only and not by the constitutional courts. And therefore, a challenge on the basis of Uma Devi can't be there. I'm just trying to find it. I'll place that. But otherwise, not other than these minor variations which are there in each of these cases in terms of how the tribunal has approached it, the underlying principle is none of the courts have ever taken pains to examine the question of whether the transaction is a sham or a bogus transaction, that all of this which was done to achieve a particular objective is nothing but to get contract labor, and therefore it is a violation of Contract Labor Act. And even if it is a violation, the transaction itself is a sham. The non-examination of these questions, in my respectful submission, renders both judgments, my lord, unsustainable in law. Which is why, my lord, we are before your lordships, saying ultimately let the matter go back to the labor tribunal or the tribunal to adjudicate the question as to whether they are entitled to it or not.
ಎಷ್ಟು ವರ್ಷ ಇತ್ತು ಲೇಬರ್ ಕೋರ್ಟ್ ಮುಂದೆ?
Because they are not.
2009, my lord, is the claim petition which has been filed.
2009 ನಿಂದನೂ ಇದನ್ನ?
Yes, 2009.
Now, my lord, the additional factor is we are not carrying out this work anymore. The work, my lord, has been transferred, and after a tendering process, the Hubli Dharwad Municipal Corporation has awarded it to L&T. Government, my lord, issued a government order saying whoever were working in contract or otherwise.
When you did it? When did you do that? During the legal battle?
Which one, my lord?
This arrangement.
No, we are not the one. We are a contractor. Our principal, the Hubli Dharwad Municipal Corporation, they called for tenders in 2021.
15/4/2021.
And awarded the contract to someone else. Some of them have gone and joined. And
Learned single judge made the order when?
Learned single judge, my lord, made the order in
22, my lord. 20th November 2022.
November 22nd November 22.
22 November 2022. So there is a.
You are a contractor of the corporation.
Of the corporation.
You are government.
Yes.
No, we are
authority.
A statutory body under the Urban Water Supply Act.
An authority is?
It is
Water
Karnataka Urban Water Supply and Drainage Board under the Karnataka Urban Water Supply and Drainage Board Act.
ಇದ್ರ ಬಗ್ಗೆ ಸರ್ವಿಸ್ ಕಂಡೀಷನ್ಸ್ ಬಗ್ಗೆ ಏನಾರ ಹೇಳ್ತದ ಅದು?
ಅದೇ
ಏನಾದ್ರು ಪ್ರೊಮಲ್ಗೇಟ್ ಮಾಡಿದ್ರ ಸ್ಟ್ಯಾಚ್ಯೂಟ್ಸ್
recruitment rules are all there.
ಅದರ ಇಂಪ್ಯಾಕ್ಟ್ ಏನೇನಿದೆ?
ಅಲ್ಲ, they are not there's no such class of employees at all.
Employment ಗೆ provisions ಇಲ್ಲ ಬುದಿಯಾ? Statutes relating to service law.
Do have service regulations, please. We have the regulations.
You have, but ಒಂದ್ ಸೆಟ್ ಕೊಡಿ, ಎಲ್ಲ ಒಂದ್ ಸೆಟ್ ಕೊಡಿ. ಸರ್ವಿಸ್ ಲಾ ಹೆಂಗಿದೆ, ಸ್ಕೀಮ್ ಹೆಂಗಿದೆ, ಯಾವ ರೀತಿ ಮಾಡಿದ್ರೆ ನಿಮ್ಮ ಸರ್ವಿಸ್ ರೂಲ್ಸ್ ಏನಾರ ಇದ್ರೆ ಕೊಡಿ.
ಅದೇ ಎರಡು ಇದೆ.
ಎರಡು ಇದೆಯಾ?
The act and the regulations.
Recruitment regulations. ಅವ್ರಿಗೆಲ್ಲ ಸ್ಯಾಲರಿ ವೇಜಸ್ ಏನ್ ಕೊಡ್ತಿದ್ರಿ?
We were not paying.
ಅಲ್ಲ ಇರ್ಲಿ, ನಿಮ್ ಕಾಂಟ್ರಾಕ್ಟರ್ ಏನ್ ಕೊಡ್ತಿದ್ದ?
Must be under the Minimum Wages Act.
ಅದಕ್ಕೆ ನೀವು ಕಂಡೀಷನ್ ನಿಮ್ಗೆ ಕೊಟ್ರೆ ಎಲ್ಲ ಗೊತ್ತಾಗತ್ತೆ ನಮಗೆ. ಕಂಡೀಷನ್ ಏನೇನ್ ಹಾಕಿದ್ರಲ್ಲಿ ನೀವು ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ಅವ್ರನ್ನ ಲೇಬರರ್ಸ್ ಹೋಗ್ಬೇಕಾದ್ರೆ ನೀವ್ ಏನೇನ್ ಮಾಡ್ಬೇಕು,
ಅಲ್ಲ
ಅವರಿಗೆ ವೇಜಸ್ ಎಷ್ಟು ಕೊಡ್ಬೇಕು, ಅಲ್ಲಿಂದನೂ ನಿಮ್ ಕಂಟ್ರೋಲ್ ಏನಿದೆ ಇವ್ರ ಮೇಲೆ ಅಂತ ನಮ್ಗೆ ಗೊತ್ತಾಗ್ತಿತ್ತು. ಅದನ್ನ ಸರ್ಟನ್ ಮಾಡೋದಿತ್ತು ನಮಗೆ. ಟು ಸರ್ಟನ್ the extent of control you'd exercise on the laborers brought by your independent contractor, that generally
That my lord would have been in a scenario where I had asked for laborers to be brought. But if I have awarded a contract on a certain date to the contractor to carry out the work, then how he carries out the work with his employees is not a matter of my control.
ಆ ಕಂಡೀಷನ್ ಅಲ್ಲಿ ಇರ್ತದೆ ಏನಂತ ಇರ್ತದೆ ಅಂದ್ರೆ ಅಲ್ಲಿ ಹೆಂಗ್ ಮಾಡಿರ್ತೀರಿ ಅಂದ್ರೆ ಮಿನಿಮಮ್ ವೇಜಸ್ ಆಕ್ಟ್ ಅಪ್ಲೈ ಆಗ್ತದೆ, the abuse of sexual harassment in the workplace ಇಂತ ಕಂಡೀಷನ್ ಅಪ್ಲೈ ಆಗ್ತದೆ. ಹಿಂಗಾದ್ರೆ ಈ ರೀತಿ ಕಮಿಟಿ ಫಾರ್ಮ್ ಮಾಡಬೇಕು, ಆ ಕಮಿಟಿಯಲ್ಲಿ ನಮ್ಮಿಂದ ಒಬ್ಬರನ್ನ ತಗೋಬೇಕು, ಅವರಿಂದ ಒಬ್ಬರನ್ನ, ಇಂಥದೆಲ್ಲ ಇರ್ತದಲ್ಲಿ.
ಇದೆ ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಇದೆ, ಒಂದು ಅಗ್ರಿಮೆಂಟ್ ಇದೆ ಇಲ್ಲಿ.
ಇದೆಯಾ?
ಇದೆ.
ಏನಂತ?
It's a agreement which simply says, my lord, contractor so and so have agreed for maintenance of water supply in ward number. I'm just giving one example.
Exhibit ಏನದು?
This, my lord, is exhibit M7. M7.
ಏನೆಲ್ಲ ಇದೆ ಅದರಲ್ಲಿ?
ಇದರಲ್ಲಿ the description of the work. The agreement only has the description of the work to be carried out and the rate. And my lord, otherwise all the terms of the tender documents would apply.
Okay.
Now, how, my lord, my lord, at least, my lord, from my limited knowledge of tendering,
you have abundant knowledge in tender matters.
It's an invitation to offer, as your lordships know. A tender is an invitation to offer. And my lord, an offer is received from the contractor, and that is accepted by the tendering authority finally. Once that happens, the acceptance is the contract, is the formation of the contract. The terms, my lord, are in the tender document or in the work order. There are small works, my lord, I've seen, at least having appeared for the government, my lord. I'm sure Justice Patil also would agree. The contract, my lord, would simply.
I also agree.
But your lordships, my lord, have been on the other side of the government, my lord, not with the state. In smaller contracts, my lord, or smaller works, it is simply a work order which is issued. In larger contracts, because these are all works, my lord, which are very small. They are some, my lord, for 40,000-50,000 rupees.
ಎಷ್ಟು ಜನ ಇವರು ಎಂಪ್ಲಾಯೀಸ್?
Initially in my ID, my lord, 439, we had 150 employees. Now it comes to 119, my lord.
Employees ಅಂತ ಕರಿಬೇಕು,
workman, my lord. I'd say workman, my lord. 150 workmen were there at the time of conciliation and reference. Now 119 is there, my lord, because of death and all.
Now, what all documents we have produced, just to give an illustration, if Lord doesn't mind me interjecting, the contract is there, the agreement, the work, my lord, which is practically like a bill of quantities, and then, my lord, the running account bills. The running account bills which are produced are all bills for the work done. They are never, my lord, for actually the individuals who are to be paid. My lord, why I'm saying this is because many a times, even, my lord, when we were in the AG's office, we called for tenders for drivers.
ಅದೆಲ್ಲ ವೈಲೇಟ್ ಮಾಡಿರಲ್ಲ ಅಂತ.
There, my lord, what would happen is,
therefore,
there, my lord, what would happen is, we would get drivers to be sent by a contractor, but under the control of the contractor. If I tomorrow, my lord, find that the driver misbehaves, I will send him back, and the contractor will then deal with him in a manner that he considers appropriate. But, my lord, what happens, my lord, is there are, let us say, 5 or 6 drivers. The next contractor comes, also wants to engage the same people because he wants to maintain uniformity. The mere fact that the contractor has changed but the workmen have not changed, as Justice Nariman holds, is not a factor which will show that therefore he is a workman of the main contract employer.
You may change the contractor.
Contractor will change. And here, then there are running account bills. The running account bills, my lord, are for the work done. It is not for provision of any employee. Your lordship will see these work orders and the agreements. As a matter of fact, I'm sorry, I should have pointed that out.
Work order is exhibit.
I'm sorry, there are many of them, not large, every one of them have been produced. M7, your lordship may take M7.
Is
the agreement, the agreement itself, along with it, my lord, after that, it's all put as a compilation. M7 has the contract.
M7 is a series.
M7 has the contract. It has the running account bills, which the contractor raises on us. And then, Lord, if your lordships look at them, there is not a single mention of one employee for whom money has to be paid. It is for the work done. Now, if for work done, my lord, if he employs certain people to carry out the work, in this case,
Will make the payment to the contract.
I make the payment to the contract. I don't have to then concern myself as to how he is paid. Maybe my lord, a minimum wages argument may come that he is not paying me minimum wages, therefore principal employer becomes liable. That of course is under a different act, not under the Contract Labour Act. Similarly, my lord, there are a large number of them. Every one of these agreements were agreements for carrying out work.
ಅಲ್ಲಿ ನೀವು ಮಿನಿಮಮ್ ವೇಜ್ ಕ್ಲಾಸ್ ಎಲ್ಲ ಇಲ್ಲನೋ ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲಿ
ಇಲ್ಲ
ಇಲ್ವಾ?
ಇಲ್ಲ.
ವರ್ಕ್ ಆರ್ಡರ್ ಅಲ್ಲ, ಅಗ್ರಿಮೆಂಟ್ ನಲ್ಲೇ.
ಅಗ್ರಿಮೆಂಟ್ ಇಲ್ಲ.
ಎಂತ ವರ್ಕರ್ಸ್ ಇರಬೇಕು, ಅವ್ರಿಗೆ ಏನ್ ಪೇಮೆಂಟ್.
No, it does not even say that you have to employ these workmen.
ಅಂತಾನೂ ಇಲ್ಲ.
And every one of them, my lord, are contracts for carrying out only work. It was not, there's not a single contract which is there. As a matter of fact, thereafter, my lord, they've also produced the payments made to the workmen, the PF, ESI, all paid by the contractor. Nothing, not a single rupee has been paid directly from us to the employee, which, my lord, Justice Nariman says, is possibly the biggest indicator of whether there's a direct employer-employee relationship. I will keep this, my lord, and I'll make a short note of which are the documents, and I'll give it to your lordship so that it's easier, my lord, for your lordships to examine it.
Let us see what they say.
Yes. There is one list we have made of all the 2005 from 2005, but they are not all the records which are there. But this has all the contracts.
Contracts, the details of the contractor and the number of employees.
ಏನದು?
It's only it's not marked.
Some
of them have been marked, not all of them. It's okay. Not this.
Okay. Yes, Vikram. Thank you. Yes, Vikram.
May I respond after Mr. Nayak, Melos, because I.
Your lawyer friends can go for a coffee round now. You will take some time, na?
Yes, well, no, in fact, what I was requesting was since
be here, another 20 minutes, we have to hear our, generally he will not take much time also. Yes, Vikram.
Yes, no, yes, no, may I just make one request? After Mr. Nayak completes, I'll make my submission because my matter is down the list. All the page numbering is varying right now. And I also didn't have the benefit, my lords, of seeing those judgments. So if you're with your lordship's permission, after Mr. Nayak, I'll just take my lords through some judgments. I think in serial number 4 itself, 4 or 4.1, Mr. Nayak is there.
We can hear your voice, but not words.
I'm sorry, but can your lordships hear me now?
Yes.
Yes, well, no, what I was suggesting was, since I didn't have the benefit, in fact, I wanted to come physically there, Malas, due to some health issues, I couldn't come. But since Mr. Dhyan has relied on some judgments which I had not had the benefit of seeing, after Mr. Nayak completes, can I make my submissions then? Malas, it might be more useful because I may not be able to address all of Mr. Dhyan's arguments because I don't have the benefit of those judgments. I'll make my submissions immediately after Mr. Nayak.
Connectivity is bad, therefore, Lord, his words are getting mixed up.
I think he's in.
I'll just try logging in again.
He's not keeping well. Actually, he was supposed to travel with me today. He's not keeping well.
Yes,
Are you traveling to Dharwad now?
No.
Line Bazaar Peda is still available.
No, in fact, if your lordships can hear me, I was actually supposed to come to Dharwad with Mr. Chinnappa, but I'm most likely diagnosed with dengue, my lord. So therefore, I'm awaiting some test results.
No, at least if you assure that you are coming tomorrow, we will request Dan to stay back.
No, my lord. I'll address online. What I was suggesting was the response. I think Mr. V.S. Nayak is there.
He's not keeping well.
You are not keeping well.
No, my lord.
He had
Okay. No, that we did not know.
3 days.
That's why I said you were supposed to come. You're supposed to come with me. We were supposed to travel together, but he called me and said he's unwell.
Can you travel any day this week? Possible?
My lord, my test results are awaited by the end of the day. I've got myself tested for dengue.
Dengue, I think. You're saying he might have dengue, so
He might
dengue positive.
Not
yes,
yet.
But if you come here, all will run away. All other advocates will run away. Maybe judges also. If option is given to us.
Today evening you might.
No, I don't want to waste your lordship's point, my lord. Now, your lordship
No,
have already
tell
heard
us
the-
which date you want. Now we have heard then now. Now,
Yes, ma'am.
which date you will be able to come here and assist us?
Depending on my health, but I really can't say possibly a week from now, but I don't want to waste your lordship's time. In case I haven't recovered, I'll appear online itself, my lord. I'll just do that.
Online.
Yes, my lord.
Can you argue? Can you argue it tomorrow?
Yes, my lord. I'll do it tomorrow. I'll do it.
In the meanwhile, again, we will read these things. Today, anybody wants to say something?
Yes, I will
Yes.
comment my.
Huh. Yes, Naik? Whichever. Yes.
ನಮ್ದು
He is senior to
4.6
you.
ಅಲ್ಲಿ ನಮ್ದು
Huh?
4.6 4.4 I'm sorry.
ಏನು ಸ್ಪೆಷಲ್ ಫ್ಯಾಕ್ಟ್ಸ್ ಇದಾವೋ ಅಥವಾ ಇದೇ ಫ್ಯಾಕ್ಟ್ಸ್ ಅನ್ನ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಹಾ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಏನ ಸೇಮ್ ಫ್ಯಾಕ್ಟ್ ಮ್ಯಾಟ್ರಿಕ್ಸ್ ಸೇಮ್ ಇದೆಯಲ್ಲ he did not much dispute about other facts. What he says is,
yes,
merely because I have violated the Contract Labor Abolition Act, you cannot draw anything against me is one thing. Number two, sham transaction, finding as to sham transaction which established the independent contractor, or finding ildange. Directly there cannot be a direction for absorption, regularization. Another, for that 2001, 2019. And he says, the 97 judgment of Gujarat High Court runs counter to what the Apex Court said in 2001 and what it reiterated in 2019. This is the gist of this one. And the single judge followed Umadevi. Single judge also recorded a finding that there is no fault in the finding of the industrial tribunal when there is no finding of the tribunal at all. Single judge assumes there was a finding. That itself is wrong. These are the three submissions.
with respect with the senior counsel I am submit. The facts in my particular case are before 2003.
Whether your facts of your case differ from other case, no, same.
Maybe different.
Maybe different.
Maybe different. Maybe different. Before 2003, the entire Hubli-Dharwad water supply system was managed by Hubli-Dharwad Municipal Corporation.
Correct. Next.
As city grew, in the year 2003, this particular work was entrusted with water board, the appellant.
Water?
Board.
Water board.
Water.
Appellant.
Appellant. So they employed us. We are working with this organization last 20 years.
Through the contractor or directly?
Directly.
Who paid you the salary?
Corporation only paid the salary.
Show that.
No, we don't have a document. I'll come for that also. Assuming even taking a worst of the worst cases. Then the union raised a dispute, demanding regularization. So in this regard, a government of Karnataka brought a gazette notification.
ಏನದು 10-1 raising dispute?
Yes. Abolishing the contract as far as Hubli-Dharwad Municipal Corporation is concerned with reference to water supply. Mangaluru, Gulburga, Belagaon, Hubli-Dharwad.
All right, go to next point. We have understood now.
So
next point.
it is banned now. Now, despite ban, my lord would kindly see a letter of the water board. Sorry. Calling upon the authorities this is of the year 2012.
ಏನದು?
ಕೆಲವು ನಗರ ಮತ್ತು ಪಟ್ಟಣಗಳ ಸರಬರಾಜು ನಿರ್ವಹಣೆಯನ್ನು ನಿರ್ವಹಿಸುತ್ತಿದ್ದು ಮಂಡಳಿಯ ಕೆಲವು ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರರು ನಿರ್ವಹಣೆಯನ್ನು ಕಾರ್ಮಿಕ ಕಾಯ್ದೆ ಅನ್ವಯ ಕೆಲವು ಷರತ್ತು ಮತ್ತು ನಿಬಂಧನೆಗಳನ್ನು ಪಾಲಿಸಬೇಕಿರುತ್ತದೆ. ಕಾರ್ಮಿಕರಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ ಭವಿಷ್ಯ ನಿಧಿ ಸ್ಥಾಪಿಸುವ ಮತ್ತು ಇಎಸ್ಐ ಸೌಲಭ್ಯ ಒದಗಿಸದೇ ಇರುವ ಗುತ್ತಿಗೆದಾರ ಸಂಸ್ಥೆಗಳಿಗೆ ನೀರು ಸರಬರಾಜು ನಿರ್ವಹಣೆಯನ್ನು ವಹಿಸೋದು ಶಾಮ್ ಕಾಂಟ್ರಾಕ್ಟ್, ನಕಲಿ ಗುತ್ತಿಗೆ ಎಂಬ ಪದದ ಬಳಕೆಗೆ ಅವಕಾಶ ಮಾಡಿಕೊಟ್ಟಂತಾಗುತ್ತದೆ. ಇದೇ ಪದ
ಆಯ್ತು, ಓದಿ ಆಯ್ತು. ಈಗ ನೆಕ್ಸ್ಟ್ ಹೋಗಿ.
ಆಯ್ತು.
Yes.
Now, I have a document which we have produced. ಇನ್ನೊಂದು ಕೊಡ್ತೇನೆ. The Assistant Labor Commissioner has given a certificate.
ಇದೆಲ್ಲ
saying that right from
ಮಾರ್ಕ್ ಆಗಿದೆ ಏನು ಇದೆಲ್ಲ? ಮಾರ್ಕ್ ಆಗಿದೆ.
ಎಲ್ಲ ಮಾರ್ಕ್ ಆಗಿದೆ ಸರ್. For convenience, I misconstrued by different states.
No,
In
we are asking you.
Shiv Narayan case.
Now we are asking you.
Yes.
Umadevi presupposes civil service.
Yes. And our
At least public service.
Yes.
That way. Where sanction posts irtade, vacancies irtade.
Procedure irtade.
Irregular procedure ninda they gain entry to the post.
Yes.
Bala long service ಆದ್ಮೇಲೆ ಕೆಲವೊಂದು postulates ಮೇಲೆ regularization ಆಗ್ತದೆ, absorption. How these are the posts ಎಲ್ಲಿದಾವೆ ಇದರಲ್ಲಿ? ಉಮಾದೇವಿ ಎಂಪ್ಲಾಯ್ ಮಾಡ್ಲಿಕ್ಕೆ where are the posts?
There are posts.
Posts?
Yes, ನಮ್ಮ post ಹುದ್ದೆಗಳು ಏನು? We are working in the category of typist. Typist, computer operators, cashiers.
ಎಲ್ಲಿದಾವೆ? Posts ಎಲ್ಲಿದಾವೆ?
Sir, ನಾವು ಕೆಲಸ ಮಾಡೋ ಹುದ್ದೆಗಳವು. Last 20 years we are doing it.
ಅದೆಲ್ಲಿ ಹೇಳಿದ್ರಿ?
That is what is our pleading before the industrial tribunal. That we are working in this cadre. Last number of years, 20 years, we are doing the same work. So it is a perennial work. That is what observation of the industrial tribunal. Permanent work. Permanent work permanent.
Control him. Bring someone to control you. We cannot control you.
I am sorry, my lord. If
We are asking you.
Yes, sir.
ನಾವು ಕೆಲಸ ಮಾಡೋ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ನಲ್ಲಿ ಇಷ್ಟು ಸ್ಯಾಂಕ್ಷನ್ ಪೋಸ್ಟ್ ಇದೆ, ಇಷ್ಟು ಪೋಸ್ಟ್ ನಲ್ಲಿ ಇಷ್ಟು ವೇಕೆನ್ಸಿ ಇತ್ತು, ಈ ವೇಕೆನ್ಸಿಗೆ ನಮ್ಮನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಂಡ್ರು, ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಪ್ಲೀಡಿಂಗು, ಅದಕ್ಕೆ ಎಲ್ಲಿದೆ ಸಪೋರ್ಟಿವ್ ಎವಿಡೆನ್ಸ್?
I have got to show, sir. For that, no, for that their own document. I have their own document.
ಇಡೀ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ ಆಕ್ಟ್ ನಲ್ಲಿ ಟು ಎಂಪ್ಲಾಯ್ ವರ್ಕಿಂಗ್ ದೇರ್ ಶುಡ್ ಬಿ ಪೋಸ್ಟ್, ಇದೆಲ್ಲ ಕಾನ್ಸೆಪ್ಟ್ ಇಲ್ಲ.
ಕಾನ್ಸೆಪ್ಟ್ ಇಲ್ಲ.
ವರ್ಕ್ ಇರ್ತದೆ, ಕೆಲಸ ಮಾಡಿಸ್ತಾರೆ, ದುಡ್ಡು ಕೊಡ್ತಾರೆ ಅನ್ನೋ ಕಾನ್ಸೆಪ್ಟ್ ಮಾಡ್ಯಾರಲ್ಲ. ಇದಕ್ಕೆ ಎಲ್ಲಿ ಬರ್ತದೆ ಅದು ನಿಮ್ದು ಅಂತ?
Only 1 second. Sir, Torsi. So I got a copy, what all designations. So 1 second. Sir, there are 19 different cadres. Second page. Sir, kindly. 19 different cadres. In the form of annexure duly signed by the authority, proceedings of the government of Karnataka. So second, last page bani sir. Assistant engineer, junior engineer, work inspector, fitter, vacuum, watchman, driver, tune, pump operator, cleaner,
So sorry,
meter.
these are the list of employees that HDMC, that is Hubli Dharwad Municipal Corporation, sent to us at the time when the entrustment happened. Please see clause F. F at the bottom on the left. HDMC shall continue to be the principal employer of these employees who are deployed for operation maintenance activities under supervision and control of KUWSTB. List of employees deputed is Annexure 1. They are on deputation to us, that's all.
These employees are
These
on
employees
deputation to
are on deputation
board.
to the board. Principal employer continues to be HDMC.
Not the workmen at all.
They're not workmen at all. They are all supposed to only come and carry out work with us as deputed employees. That is a list out of 263 employees. And they say HDMC shall continue to be the principal employer.
As far as those handed over.
That's what I'm saying. Handed over employees.
Handed over.
This is not our cadres. They're on deputation to us to carry out this work. That's all.
HDMC employees put on deputation to board. For them, this has been issued.
For them, this has been issued. To say you will, but the principal employer continues to be HDMC. We only pay their wages.
Sir, this. Sir,
yes.
Now I draw Lordship's kind attention to the verdict of the Honorable Apex Court in International Airport Authority India Limited, which I desire to solely bank upon. And it would cater my all needs. May I kindly draw attention of this Honorable Court to page 385.
385.
385. Para 30. The legal background and questions for decision. When the learned single judge considered the matter, the legal position was governed by the decision in Gujarat Electricity Board, partly modified by Air India. By the time the division bench decided the writ appeal, the decision of the Constitution bench in Steel Authority had been rendered, but on account of a short gap between the two dates, the division bench did not notice the decision in sale. Sir, para 31. In Gujarat electricity case, the exclusive authority to decide whether the contract labor should be abolished or not is that of an appropriate government under the said provision. It is further not disputed before us that a decision of the government is final, subject, of course, to judicial review on the usual grounds. However, as stated earlier, the exclusive jurisdiction of the appropriate government under Section 10 of the Act arises only where labor court contract is genuine and question is whether contract is genuine or not can be examined and adjudicated upon by the court of industrial adjudicator, as the case may be. Hence, in such a case, the workman can make a grievance that there is no genuine contract and that they are in fact employees of the principal employer. My lord, in my case, the government has declared ban on engaging employees through contract.
Section 10.
Yes. So, question of this also is not arising in my case. It is solved. Next, sir, kindly, very next paragraph. If the contract is sham or not genuine, the workman of the so-called contractor can raise an industrial dispute for declaring that they are always the employees of the principal employer and claiming appropriate service conditions.
Otherwise, he will reject, the industrial tribunal, labor court shall reject the claimant. The next.
Sir, when the dispute is raised, and we have raised a dispute, it is not a dispute for abolition of contract, and hence the provision of Section 10 of the Act will not bar either raising or adjudication of the dispute. When such a dispute is raised, what we have done, the industrial adjudicator has to decide whether the contract is sham or genuine, and it is answered. It is only if the adjudicator comes to conclusion that the contract is a sham that he will come to conclusion that the contract is sham, that he will have a jurisdiction to adjudicate the dispute.
Now, what I am saying is,
Yes.
to decide whether a transaction is sham or bogus,
Yes.
there are principles.
Yes.
On those principles, we have to arrive at, not otherwise. Those principles, the learned, the industrial tribunal drew under 97 Gujarat judgment. That Gujarat judgment is it runs counter to 2001, 2019. That is error of law anta our contention.
Sir,
ಎಲ್ಲಿ ಪೇಮೆಂಟ್ ಯಾರು ಮಾಡಿದ್ರಿ ಈಗ ಅದು ಬೋಗಸ್ ಅನ್ಲಿಕ್ಕೆ ನಿಮ್ದೇನು ನಿಮ್ಮ ಎವಿಡೆನ್ಷಿಯರಿ ಮೆಟೀರಿಯಲ್ ಹೇಳಿ.
That was a point we urged before the industry tribunal.
All right, now you are urging before
Yes.
us now.
Yes.
Tell which are the points.
No, for that, I will go to the claim statement, what we have filed before industrial tribunal and what we were urging before the industrial tribunal.
Evidence ತೋರಿಸಿ.
Evidence ತೋರಿಸಿ.
ನಿಮ್ಗೆ ಅವ್ರು ಯಾವುದೇ ಪೇಮೆಂಟ್ ಡೈರೆಕ್ಟ್ಲಿ ನಿಮಗೆ ಮಾಡಿಲ್ಲ ಅವ್ರು?
ಯಾರಿಗೂ ಮಾಡಿಲ್ಲ. ಇಲ್ಲ.
ಯಾವ್ದಾದ್ರು ಡಿಸಿಪ್ಲಿನರಿ ಎನ್ಕ್ವೈರಿ
ಯಾರಿಗೂ ಆಗಿಲ್ಲ. ಇಷ್ಟು ವರ್ಷ ಆದ್ರೂ ಯಾರಿಗೂ ಆಗಿಲ್ಲ. ಯಾರನ್ನು ನೌಕರಿಯಿಂದ
ಪೇಮೆಂಟ್ ಯಾರು ಮಾಡ್ತಿದ್ರು?
ಇವರೇ ಮಾಡ್ತಿದ್ರು. ಆಫೀಸ್ನವರೇ ಮಾಡ್ತಾ ಇದ್ರು. That is what is our evidence to the effect.
ತೋರಿಸಿ.
Only 1 minute.
ಬಟ್ ಅವ್ರು ಹೇಳೋದೇನು ಅಂದ್ರೆ, ನಾವು ಚೆಕ್ ನಿಂದ ಕಾಂಟ್ರಾಕ್ಟ್ರಿಗೆ ಕೊಡ್ತಿದ್ವಿ, ಕಾಂಟ್ರಾಕ್ಟರ್ ನಿಮ್ಗೆ
ಅವ್ರಿಗೇನು ತೋರಿಸಿದ್ರಲ್ಲ M7, it is a civil work plus certain work they have entrusted with the contractor. ಈಗ when we have entire Hubli, Dharwad, 2 big city which could not be managed by the HDMC, how many contracts they are producing before?
ಅದು ಹೋಗ್ಲಿ, ನಿಮ್ದು ತೋರಿಸ್ರಿ. ನಿಮ್ಗೂ ಅವರಿಗೂ ನಮ್ಮ ಇಬ್ಬರಿಗೂ ಎಂಪ್ಲಾಯಿ ರಿಲೇಶನ್ಶಿಪ್ ಇದೆ ಅಂತ
ನಾನು ತೋರಿಸ್ತೀನಿ. I'll show it.
ಆ ಮಟೀರಿಯಲ್
ತೋರಿಸ್ತೀನಿ. I'll show it. Definitely I'll show it.
ಒಂದ್ಸರಿ 2019 ಜಜ್ಮೆಂಟ್ ಬನ್ನಿ. 2019 ಜಜ್ಮೆಂಟ್
ಸರ್ ಅವ್ರು ನಮ್ಗೆ ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ ಸರ್.
ಹೌದಾ? ಕೊಡ್ರಿ.
ಕಾಪಿ ಕೊಡ್ಲಿಲ್ಲ.
ಕೊಡ್ರಿ 2 ಕಾಪಿ ಕೊಡ್ರಿ.
ನನಗೂ ಕೊಟ್ಟಿಲ್ಲ, ನಾಯಕರಿಗೂ ಕೊಟ್ಟಿಲ್ಲ. ಇಲ್ಲಿ
ರೂಲಿಂಗ್ಸ್ ಪಾರ್ಟಿ ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ಲ, ನೀವು ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕದ್ನ. ಅವ್ರು ನಿಮ್ ಕಾಪಿ
ಇಲ್ಲ ಅಲ್ಲ ಸರ್, I went and asked him twice.
ಅವ್ರು ಕೊಡೋ ಅಗತ್ಯ ಇಲ್ಲ. There is no such rule. They need not give tuition to you.
ಇವರಿಗೆ ಸಿಕ್ತಿಲ್ಲ.
ನೀವು ಕೊಡ್ರಿ ಅಂತ ಕೇಳ್ಕೋಬಹುದು, ರಿಕ್ವೆಸ್ಟ್ ಮಾಡಿದ್ರೆ ಕೊಡ್ಬೋದು ಅವ್ರು ಅಷ್ಟೇ. ಅಲ್ಲಿ ಇದಕ್ಕೆ 2019 ಬನ್ನಿ. 2019 ಜಜ್ಮೆಂಟ್ ಬನ್ನಿ.
1 second sir.
Page 75. 74, 75 ಬನ್ನಿ.
Yes.
ಆಯ್ತಾ? ಅದರಲ್ಲಿ ಇದು
ಸರ್ ಇಂಟರ್ನ್ಯಾಷನಲ್ ಏರ್ಪೋರ್ಟ್ ಅಥಾರಿಟಿ ಸೇಮ್ ಅವರು ರೆಫರ್ ಮಾಡ್ತಾ ಇರೋದು. ಪೇಜ್ 70 ಓಕೆ ಸರ್.
94 ಟೆಸ್ಟ್ ಇದೆ ಅಲ್ಲ 24
ಪೇಜ್ ನಂಬರ್ ಇಲ್ಲ ಸರ್.
ಲಾಸ್ಟ್ ಪೇಜ್, ಲಾಸ್ಟ್ ಬಟ್ 1 ಪೇಜ್ ಬನ್ನಿ, ಕೊನೆ ಪೇಜಿಗೆ ಬನ್ನಿ. ಇಂಟರ್ನಲ್ ಪೇಜ್ 93 ಇದೇನೋ ಜಜ್ಮೆಂಟ್ ಇದ್ದು ನಾಯಕರೇ, 93 ತೋರಿಸಿ.
ಅದೇ ತೆಕ್ಕೊಳ್ತಾರೆ. ಜಜ್ಮೆಂಟ್ ಪೇಜ್ 9 ಅವ್ರು ಇದ್ರ ಹೋಗ್ತಾರೆ. ಪ್ಯಾರಾ ಎಷ್ಟು? 24
ಪ್ಯಾರಾ 24 ಓದಿ.
ಎಸ್ ಸರ್, ಎಸ್ ಸರ್.
ಅದ್ರಲ್ಲಿ 65 ಇದೆ ನೋಡಿ.
ಎಸ್ ಸರ್.
ಆ 65 ಕೆಳಗಡೆ ಏನೇನ್ ಇಂಡಿಷಿಯಾ ಬೇಕು
ಸರ್? ಇವೆಲ್ಲ ನೋಡಿದ್ದೀನಿ ಸರ್. ಇವನ್ನೆಲ್ಲ ನೋಡೇ ನಾವು ನಮ್ದು ಎವಿಡೆನ್ಸ್ ಮಾಡಿದ್ದು.
ನಮ್ಮ ಪ್ರಶ್ನೆಗೆ ಉತ್ತರ ಕೊಡಿ.
ಆಯ್ತು ಸರ್.
ಹೂ ಅಪಾಯಿಂಟ್ಸ್ ದಿ ವರ್ಕರ್ಸ್?
It is the principal employer who has appointed us. He has entrusted the work. ಸರ್ ಕೊಡ್ತೀನಿ ಸರ್. ಸರ್ ಸ್ವಲ್ಪ ಲೋವರ್ ಕೋರ್ಟ್ ಫೈಲ್
ಕೊಡಿ.
ಲೋವರ್ ಕೋರ್ಟ್ ಫೈಲ್
ತೊಳಿ.
ಎಸ್, ಲೋವರ್ ಕೋರ್ಟ್ ಫೈಲ್ ಇಂಡಸ್ಟ್ರಿಯಲ್
ತೊಳಿ ನೋಡ್ಕೊಂಡು ಹೇಳಿ.
ಎಸ್,
ನಿಧಾನವಾಗಿ ಹೇಳಿ, ಏನು ಅವಸರ ಇಲ್ಲ. ತುಂಬಾ ಜನರ ಲೈಫ್ ಪ್ರಶ್ನೆ ಇರ್ತದೆ, ಹಂಗಾಗಿ ಅವಸರ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಸ್ವಲ್ಪ ನಿಧಾನವಾಗಿ ಎಲ್ಲ ನೋಡ್ಕೊಂಡು ಹೇಳ್ಬೇಕು. ಅಲ್ಲಿ 6 ಐಟಮ್ಸ್ ಇದಾವೆ. ಈ 6 ಐಟಮ್ಸ್ ನಲ್ಲಿ ನೀವು ಹೇಗೆ ಏನೇನ್ ಮಟೀರಿಯಲ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿರಿ ಪ್ರೂವ್ ಮಾಡ್ಲಿಕ್ಕೆ ತೋರಿಸಿ. ಬೇರೆ ಲಾಯರ್ಸ್ ಎಲ್ಲ ಮೋಸ್ಟ್ಲಿ ಮಧ್ಯಾಹ್ನ ಬರ್ಬೇಕಾಗತ್ತ, ನಾವು ನೋಡೋಣ. ಪ್ರಿನ್ಸಿಪಾಲ್ ಎಂಪ್ಲಾಯರ್ ನಿಮ್ಮನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಂಡ್ರು ಅನ್ನೋ ಬಗ್ಗೆ ಒಂದು ಪುಟ್ಟ ಕಾಗದದ ಪತ್ರ ತೋರಿಸಿ.
Sir, in para 9 of my claim statement before the labor court, proper is industrial tribunal, I have specifically pleaded.
Pleading ಬೇಡ, ಪ್ರೂಫ್ ಬೇಕು.
ಬರ್ತೇನೆ ಸರ್. ಅದಕ್ಕೆ ಅದ್ರ ತಕ್ಕಂಗ ನಾನು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸಿದ್ದೆ. ಸಪೋರ್ಟಿಂಗ್ ದಿಸ್ ಪರ್ಟಿಕ್ಯುಲರ್ ಪ್ಲೀಡಿಂಗ್ ವಿ ಹ್ಯಾವ್ ಲೆಡ್ ಎವಿಡೆನ್ಸ್.
ಆ ಪ್ಲೀಡಿಂಗ್ ಇದ್ಬಿಟ್ಟಿದೆ, ಅದಕ್ಕೆ ಬೇಕಾಗೋ ಪ್ರೂಫ್ ಕೊಡಿ, ಎವಿಡೆನ್ಸ್ ಕೊಡಿ.
Yes.
ಅವ್ರ ಅಪಾಯಿಂಟ್ಮೆಂಟು, ಸ್ಯಾಲ್ರಿ ಯಾರು ಕೊಟ್ಟರು, ಯಾರು ನಿಮ್ಮನ್ನ ಡಿಸ್ಮಿಸ್ ಮಾಡೋ ಪವರ್ ಇತ್ತು, ಡಿಸಿಪ್ಲಿನರಿ ಆಕ್ಷನ್ ಪವರ್ ಯಾರಿಗಿತ್ತು, ಇಂಥದ್ದೆಲ್ಲ ಬೇಕಾದ್ರಲ್ಲಿ. ಸೂಪರ್ವಿಷನ್ ಆಫ್ ವರ್ಕ್ ಯಾರು ಮಾಡ್ತಿದ್ರು ಅಂತ ತೋರಿಸ್ಬೇಕು.
can only say this, if they were direct employees, then section 10 notification would never arise. The argument of contract would never arise. Why would the argument be there? Then there's nothing left.
No, they are saying that we are appointed through contractor. That is what is
ಈ ಒಳ್ಳೆ ಬಾಂಬ್ ಹಾಕಿ ಕುತ್ಕೊಂಡಾರ ಅವ್ರು, ಅದು ಉತ್ತರ ಕೊಡ್ಬೇಕೀಗ ನೀವು.
ಕೊಡ್ತೇನೆ ಸರ್, ಡೆಫಿನೆಟ್ಲಿ. So in para 10 of my evidence of WW1.
ಬಾಯಿಂದ ಹೇಳೋದಾತು, ಇದು ನಮ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಂಡಾರೆ ಅಂತ ಅನ್ಕೊಂಡು ಹೇಳಲಿಕ್ಕೆ ಬಾಯಿಂದ ಏನ್ ಬೇಕಾದ್ ಹೇಳಿಕ್ ಬರ್ತದೆ. ಮಟೀರಿಯಲ್ ಎಲ್ಲಿದೆ?
No material documents are parted by the management.
ನೀವು ಸಮನ್ ಮಾಡಿದ್ರಾ?
ಡಾಕ್ಯುಮೆಂಟೇ ಇಲ್ಲ ಸರ್.
ಇಲ್ಲದ್ರೆ ಹೆಂಗ್ ಕೊಡ್ಬೇಕು? ನೀವು ಸಮನ್ ಮಾಡಿದ್ರ ಇಂತಿಂತ ಡಾಕ್ಯುಮೆಂಟ್ ಇವ್ರ ಹತ್ರ ಇದೆ ನೋಡಿ ಕಳ್ರಿ, ಕೊಡಕ್ ಹೇಳ್ರಿ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರೈಬ್ಯುನಲ್ ಮುಂದೆ?
Sir, I may be permitted to read the evidence.
ನಿಮ್ಮ ಓರಲ್ ಎವಿಡೆನ್ಸ್ ತಗೊಂಡು ನಾವ್ ಏನ್ ಮಾಡೋಣ? ಇದು ಮರ್ಡರ್ ಕೇಸ್ ಅಲ್ಲ. ಎಂಪ್ಲಾಯ್ಮೆಂಟ್ ನಿಮ್ಮನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿಕೊಂಡಿದ್ದು ಇವರು ಅಂತ ಹೇಳುವಾಗ ಒಂದು ಬಸ್ ಟಿಕೆಟ್ ಸೈಜ್ ಒಂದು ಪೇಪರ್ ಬೇಕಾಗ್ತದೆ. ಇದಾದ್ರೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದ್ರೆ ನಾವು ಓರಲ್ ಎವಿಡೆನ್ಸ್ ನೋಡ್ಬಿಡ್ತಿದ್ವಿ. ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಒಂದು ರೋಲ್ ಇರ್ತದೆ ಅಷ್ಟೇ, ಒಂದು ಲೆವೆಲ್ಗೆ ಅದು. ಯಾಕಂದ್ರೆ ಅದು ಪ್ರೈವೇಟ್ ಪರ್ಸನ್ ಮಾಡ್ತಾ ಇಲ್ಲ, ಗೌರ್ಮೆಂಟ್ ಎಂಟಿಟಿ ಅದು, ಬೋರ್ಡ್ ಅದು. ಯಾವಾಗ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ರಪ್ಪ? ಯಾರಿಗೆ ನಿಮ್ಗೆ ಲೆಟರ್ ಆಫ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಯಾವಾಗ ಕೊಟ್ರು? ನಿಮ್ ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಏನ್ರ ಇದೆಯಾ?
ಯಾರಿಗೂ ಕೊಡ್ಲಿಲ್ಲ. Sir, for a second, they say we are employees of the contractor for last number of years. Whether they have engaged, they have brought any of the contractor, examined before the court. But other hand, I have examined a contractor alleged to have been performed the work of this.
ನಿಮ್ಗೆ ಸ್ಯಾಲರಿ ಯಾರು ಕೊಡ್ತಿದ್ರು?
Sir,
ಕೊಡಿ, ಏನಾರ ಒಂದು ಹೇಳ್ಬೇಡಿ.
ನಾನು ಆಫ್ ರೆಕಾರ್ಡ್ ಏನು ಹೇಳೋದಿಲ್ಲ.
ರೆಕಾರ್ಡ್ ಪ್ರಕಾರ
that the second party junior executive engineer, assistant executive engineer and office superintendent control the work of all 124 employees.
ಅದು ಕರೆಕ್ಟ್. ಯಾಕಂದ್ರೆ ನಿಮ್ಗೆ ಅಲ್ಲಿ ವರ್ಕರ್ಸ್ ಅನ್ನು ಕರ್ಕೊಂಡ್ ಬಂದಿರ್ತಾರೆ, ಅವಾಗ ಇಲ್ಲಿ ನಿಮ್ಮನ್ನ ಕಾಂಪೌಂಡ್ ಒಳಗೆ ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾನೆ. ಮುಂದೆ ಏನ್ ಕೆಲಸ ಮಾಡ್ಬೇಕು?
And we are under total control of the second party.
ಅದು ನೀವೇನ್ ಬರ್ದಿಲ್ಲ, ಅದು ಎವಿಡೆನ್ಸ್ ಬಂದದೆ, ಅದು ಉಪಯೋಗ ಇಲ್ಲ ನಮ್ಗೆ. ನಿಮ್ಮನ್ನ ಅಪಾಯಿಂಟ್ ಮಾಡಿದ್ಲಿಕ್ಕೆ ಒಂದು ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್ ತೋರಿಸಿ.
There is no letter whatsoever. Fairly
counsel appearing for the workmen on being repeatedly asked answers that no appointment letter has been ever given by the appellant board. ನಿಮಗೆ ಸ್ಯಾಲರಿ ಯಾರು ಕೊಡ್ತಿದ್ರು?
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಕೊಡ್ತಿತ್ತು.
ಎಲ್ಲಿದೆ?
That is what is the evidence coming forth.
ಓರಲ್ ಎವಿಡೆನ್ಸ್ ಬೇಡ
sir.
ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಗೆ ಏನಾದ್ರು ದುಡ್ಡು ಹಾಕ್ಯಾರ?
ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಇಲ್ಲ, ಕ್ಯಾಶ್ ಪೇಮೆಂಟ್.
ಸ್ಯಾಲರಿ ಸ್ಲಿಪ್ ಇದೆಯಾ?
No salary slip is coming forth.
When specifically asked,
yes,
the counsel for the workmen submits the salary amount was not credited to his bank account, nor any salary slip is generated. Next.
Then further I have said, not a single disciplinary action is taken by any of the contractor against any of us.
You know?
ಯಾವುದೇ ಕಾಂಟ್ರಾಕ್ಟರು ನಮ್ಮ ಮೇಲೆ ಯಾವುದೇ ಡಿಸಿಪ್ಲಿನರಿ ಆಕ್ಷನ್ ತಗೊಂಡಿಲ್ಲ.
ಹೌದು, ನೀವು ಚಲೋ ಕೆಲಸ ಮಾಡಿದ್ದಕ್ಕೆ ತಗೊಂಡಿಲ್ಲ ಅವರು. ಕೆಲಸ ಒಳ್ಳೇದ್ ಮಾಡಿಬಿಟ್ರಿ ನೀವು, ಹಂಗಾಗಿ ಅವ್ರು ತಗೊಳ್ಳಿಲ್ಲ.
ಆಯ್ತು ಸರ್.
ಇವ್ರು ತಗೊಂಡಿದ್ದು ತೋರಿಸಿ ಅರ್ಥದ ಏನ್ರಿ ಇದು? ನಿಮ್ಗೆ ಮೆಮೋ
ಅವ್ರು ನಮ್ಗೆ ತಾವೇ ಹೇಳಿದ್ರಿ ನಮ್ ಕೆಲಸ ಚಲೋ ಇತ್ತು, ಮೆಮೋ ಕೊಡೋ ಪ್ರಶ್ನೆನೂ ಹುಟ್ಲಿಲ್ಲ.
ಯಾವ್ದಾದ್ರು ನಿಮ್ಗೆ ನೀವು ತಡಾಗಿ ಬಂದಿ ಇವತ್ತು ಕೆಲ್ಸಕ್ಕೆ ನೋಡು ನಾಳೆ
ಆ ತರದ್ದು ಯಾವ ಇವು ಬಂದಿಲ್ಲ.
When specifically asked, the counsel says at no point of time any memo has been issued
and no orders are passed in writing by the management.
All right. ಈ ರಜೆ ಹಾಕುವಾಗ ನೀವು ರಜೆ ಹಾಕುವಾಗ
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಗೆ ಹೇಳ್ತಿದ್ವಿ, they used to
ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಹೆಂಗೆ ಹೇಳ್ತಾರೆ?
ಅಸಿಸ್ಟೆಂಟ್ ಇಂಜಿನಿಯರ್ ಜೂನಿಯರ್ ಇಂಜಿನಿಯರ್ ಗೆ ಹೇಳ್ತಾ ಇದ್ವಿ.
ರಜಾ ಚೀಟಿ ಇದೆಯಾ?
ರಜಾ ಚೀಟಿ ಇಲ್ಲ.
He admits that never any leave application was given to the management seeking sanctioning of the leave.
ಸರ್ ಇದೇ ಇತ್ತಲ್ಲ, ಇದೇಗಿನ ಇದಲ್ಲ,
ಅದನ್ನೇ ಓದ್ತಾ ಇದ್ದೆ.
ಕೊಡಿ ಸ್ವಲ್ಪ.
ನಿಮ್ಮ ಹತ್ರ ಇದೆ ಅದು? ನಿಮ್ಮ ಹತ್ರ ಇದೆ?
However, he loudly reads out the oral deposition of his client who was examined as WW?
MW1, WW1.
WW1. ಪಾಟೀಲ್ ಇದು ಎಫ್ ಇ ಪಾಟೀಲ್ ಇದು ಸ್ವಲ್ಪ ಹೊತ್ತು ಆಗ್ಬೋದು ಇದು ಅಲ್ಲ ನೀವು ಬೇಕಾದ್ರೆ ಕುತ್ಕೊಳ್ಳಿ ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ
Preliminary hearing matter 20, day after tomorrow.
20 ನೋಡಿ ಅದೇ ಇರಿ ಯಾರು ಮಾತಾಡ್ಬೇಡಿ ನಡುವೆ
ನಾವೇ petitioner.
ನೋಡಿ
So now in this particular case, it's appropriate on my part to draw the Lordship's attention to evidence of MW1 management witness, who is Assistant Executive Engineer.
MW1
MW1.
ಏನಂತಾರೆ ಅವರು ರಿಲೆವೆಂಟ್ ಇರೋದನ್ನ ಓದಿ
Sir, relevant cross examination within, sir.
ಓದಿ.
It is true that the maintenance of pipelines, revenue collection, attending the grievance of the customers is our responsibility. It is true that ours is an essential and perennial
It is covered under ESMA. All right, next.
It is true that to look after all these works, we require services of wallmen, meter readers, ledger writers, computer operators, leakage laborers, fitters, and pumpmen. It is also true that we have a watchman to watch our tanks round the clock, and the so-called fumes and drivers. Now, the witness is constricted to a photograph of the copy of Karnataka Government Gazette published on 10/11/2006.
ಯಾವುದು?
It is sir, government
Section 10 notification.
Section 10 notification. The same is marked as Exhibit W2. It is false to suggest that this Gazette notification applies to our department. The Assistant Executive Engineer, when this particular
Whether a notification applies to department or not, it cannot be subject matter of oral evidence at all. You have to see the document.
No, to what extent he
cannot. Evidence section 5 of the Evidence Act says evidence can be led to prove the fact in issue or the fact relevant to the facts in issue and nothing else. And
but he was
one second without preparation. Section 10(1) notification is treated as a delegated legislation.
Yes.
To prove law, no evidence except one case where in English history we read whether Magna Carta is law or not. Attorney General had given evidence. That is the only one case. Another is in African country, evidence was permitted to be led to prove law. Except these two, which one treats in Salmon treats it, the another is treated by Tony Honor. There is no other. You cannot say. Just
Sir,
go to next point.
he further says,
Go to next point.
we have accepted the contractor for respective contractors on verification of necessary qualification and the amount of bid tendered by them. We give the contract to the lowest bidder. It is true that we submitted a report with a list of contract workers recommending equal pay, equal work. Now, the witness is contradicted with 6-page list of contract workers working in South Subdivision, and witness admits that it was the last list prepared by his office and bears his signature. As such, this document is marked as a Exhibit W3. And so also witness identifies another 6 pages list of contractual workers of North Subdivision which bears his signature, and same is also marked as Exhibit W4. Let me look into W3 and W4.
Whether it can applies or not cannot be subject matter of evidence at all.
Sir, the W3 is a list of employees, the names given, containing different cadre, different category.
Exhibit ಏನದು?
W3. ಇಲ್ಲ sir.
32. ಏನದು 32? ಯಾವ ವರ್ಷದ್ದು ಹೇಳ್ಬೇಕು? ಆಲ್ ರೈಟ್. ಮಾಡಿ ಆರಾಮಾದ್ರೂ ಅರಿ ಆಲ್ ರೈಟ್ ನಾವು. ಯಾಕೆ ಏನಾಗಿತ್ತು? ಯಾವತ್ತು? ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕೋಣ. ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಕೊಡ್ಲಿಕ್ಕಾಗಲ್ಲ. ನೆಕ್ಸ್ಟ್ ವೀಕ್. ಹಾ ಹಾ. They are not taking time. Now we are in the mid of the hearing. He asked, otherwise also we would have taken time from you. Yes, I am giving. ಮಂಡೇ ಅಂದ್ರೆ ಅವರು ಮಂಡೇ ಮಾಡ್ಲಿಕ್ಕಾಗಲ್ಲ, ಈಗಾಗಲೇ ಜಾಸ್ತಿ ಪೋಸ್ಟ್ ಆಗಿದೆ. 20 ಅದು ಇದು ಏನಿದು ಹಾ ಹಾ ಕರೆಕ್ಟ್ ಅಗ್ರಿ US. Right, in the immediately after vacation, one date ಕೊಟ್ಟು. Okay. Okay. ಹಾ ಹಾ 3-5. ಹಾ
ನಿಮ್ದಷ್ಟೇ ಅಪೀಲ್ ಸರ್?
ಅವ್ರ ಅಪೀಲ್ ಇದೆ? ಇಲ್ಲ.
ಕಾಮನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಇಷ್ಟ ಅಂತ ರಿಕ್ವೆಸ್ಟ್ ಆಫ್ ಕೌನ್ಸಿಲ್.
ಹಾ ನೋಡ್ರಿ, ಒಂದು ಡೇಟ್ ತೊಗೊಂಬಿಡ್ರಿ, ಎಲ್ಲ ನೋಡ್ಕೊಂಬರ್ರಿ ಇನ್ನೊಂದ್ಸರಿ. ಇವೆಲ್ಲ ಅವಸರ ಮಾಡಂಗಿರಲ್ಲ. ನಂಬರೆಲ್ಲ ನೋಡ್ಕೊಳ್ಳಿ. ಮತ್ತೆ ಇವರು ಏನೋ ಹುಷಾರಿಲ್ಲ ಅಂತಲ್ಲ, ಯಾರು ವಿಕ್ರಮ್ಗೆ. ವಿಲ್ ಹ್ಯಾವ್ ಇಟ್ 25th 25th ಬರ್ತಾರಾ? ಆಲ್ ರೈಟ್ 25th ಹಾಕೋಣ. ನೋಡ್ಕೊಂಬರ್ರಿ ಎಲ್ಲ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಎಲ್ಲ ನೋಟ್ ಮಾಡಿಕೊಂಡು. ಓಕೆ, ಫಾರ್ ಫರ್ದರ್ ಹಿಯರಿಂಗ್. ಎಸ್. ಹಾ, ಕುರುಮಟ್ಟೆ ಅವ್ರದ್ದು 5 ಕರಿ. ನೋಟ್ಸಿಗೆ ಹಾಕಿಡ್ಬೇಕು. ಹಾಕಿದ್ಯಾ?
This is not order. Copies. Notice ಅಲ್ಲಿ ತಗೊಳ್ಳಿ. ನಾನ್ ಪೇಮೆಂಟ್ ಕಾಸ್ಟ್ ಅಂತ ಏನೈತೆ? Where is Mr. Hatti? Password. Ask him to pay the cost other.
Subject to payment of cost.
Week's time is granted. Further week's time is granted to pay cost of ₹2,000. Stop. Sri Mallikarjun V. Swami Raymond. Undertake to appear for
landowner. First respondent.
For claimant, sir. For claimant, sir. HA accepts notice for R2. Meanwhile, appellant to apply office objection.
On ಮಾಡ್ಕೊಳ್ಳಿ ಅದು.
Writ appeal itself is not maintainable, my lords. In view of the resolution passed by the KIDB, they say that the award.
matter may be connected with along with other matters.
Cost payment.
2000 rupees cost. During the course.
KIDB itself has passed a resolution. KIDB itself has passed a resolution saying that it would pass orders, awards in terms of the new accumulates in the year 2016. Award in
ಅವ್ರ ಇನ್ನೊಂದು ಮ್ಯಾಟರ್ ಇದೆ ಅಂತಲ್ಲ.
short date millets.
Stay has been granted.
Millets in those matters millets.
Matter may be tied along with these other matters.
Identical matters are stayed.
Millets.
The issue is
Now
whether
mistake.
the compensation has to be paid under the new act or KIDB.
Old act ಅಂತ, correct.
Those acquisition were initiated prior to 2014 millets. In this matter.
No, that requires consideration. We have granted stay in other matters.
Please.
Identical matter, the coordinate bench has granted interim order of stay. In view of the same, there shall be interim order of stay of the interim order of the learning executives so and so. List along with. I think contempt of the contempt of the in view of the interim granted by
us
by us in WA number so and so A number. Okay. The contempt proceedings are closed. It will effect to revive after the disposal of the writ appeal.
Please.
Comply of smart. My appeal. Cost. Next. Just 1 minute. Just.
So the application for recalling delay is there. In the similar matter, already order has been passed. Same notification, a common judgment was passed by the reference court.
Covered by judgment ಆಗತ್ತೆ no?
Already MFP another we have made the payment. And we in this section we have paid only first payment has been paid.
7.
ಅದರಲ್ಲಿ ಪೇಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ ಬಟ್ ರಿಕಾಲ್ ಆಗಿ ಆಮೇಲೆ
Recall ಮಾಡದ except in the cost shown delay of 337 days filing an application to recall the order dated 28/6/2013 is allowed by denying the interest if the appellant succeeds in the appeal from 28/6/2013 to till date. Appeal is restored.
Notice
is allowed. Sri Venkatesh Karve accepts notice for respond number 2. That is, if accepts notice for
Respond number 2.
1.
Okay, 1.
And counsel appeal for the appellant submits that it is covered by the judgment of the coordinate bench dated 16/6/2020 passed in MFA 21048 of 2012, which is not disputed by the land council appealing for the respondent. In view of the same, the present appeal is disposed of in terms of the aforesaid judgment, and the market value of the subject land is redetermined based on the aforesaid judgment at rupees 1,79,390 per guntas along with all statutory benefits and interest as per the provisions of 1894 Act. Yes. Disposed of. The interest, it is made clear that the appellants are not entitled. Main appeal to interest less not entitled interest for registered to draw the decree to dispose and deposit the said amount within a period of 8 years. Yes.
Yes.
The appellant's counsel minutes. It's a land acquisition matter where the very short point involved in this is the basis on which the announcement is claimed is that admittedly it's an NA potential land. The reference court did not grant it on the ground that the location between the land
acquired by the Karnataka Housing Board. And this is, one is at southern side and another is at eastern side. Therefore, it cannot be compared. That's the only ground on which, my lord, NA potentiality was not considered in my case. And the exemplar on the basis of which the appellant's claimed enhancement was, my lord, the sale deed executed by the Karnataka Housing Board, where, my lord, 140 rupees was paid per square foot. Here, my lord, it will be some 3 rupees or something by the LAO and 6 rupees by the reference court per square foot of land.
Enhancement ಗೆ ಬೇರೆ material ಏನಿದೆ?
My lord, the admission by the executive engineer RW1 that the lands acquired in these cases, in these two cases, are within the town of Saudati. They are located within Saudati town, my lord. There is a clear-cut admission by the respondent's witness himself, RW1.
Google map ಮಾಡ್ಕೊಡಿ. Get the Google map.
We have produced, my lord. We have filed an application to the municipality to give a sketch of the location of all the three lands.
ಬೇಡ Google map ಕೊಡಿ. 5 ನಿಮಿಷದಲ್ಲಿ ಮಾಡ್ತೇವೆ ಕೊಡಿ.
Please.
sketch ಎಲ್ಲ ಯಾಕೆ ಬೇಕು? Google ಕೊಡಿ, Google location.
I'll get the help of some colleague, my lord. I'm not conversant with that. I'll get it done. It may kindly be passed on.
Pass over ಮಾಡಕ next week ಹಾಕೋಣ. ತೋರಿಸ್ತೀರಾ?
Subject to lordship's convenience, my lord.
Google map ಕೊಡ್ಲಿಕ್ಕೆ ನೋಡ್ಕೊಂಡು ಮಾಡೋಣ. Next week. Senior advocate signed so for furnishing the
Next week, to furnish the Google location, indicating the distance of the acquired land and the
town municipal limits.
Municipal limits of Saudati.
Please, publish to you. Yes, I will do that. We'll do that.
ನೀವು ಮಾಡ್ಕೊಂಬನ್ನಿ. ನೀವು ಮಾಡ್ಕೊಂಬನ್ನಿ, ಅವರು ಮಾಡ್ಕೊಳ್ಳಿ. ಅದೇ ಬೇರೆ ಇರ್ಲಿಕ್ಕಲ್ಲ. ಅದೇ. Okay.
Please, for the respondent.
Yes.
Delay application there. I have produced 17 years synopsis along with my appeal memo, my lord. Filing the appeal. Please. 17 ವರ್ಷ.
17 years.
6,000 days delay, my lordship.
ಏನು explanation?
Please, my lord. I have filed.
Delay control ಮಾಡಿದ್ರೆ ಮುಂದೆ.
The appellant died in the year 2013, my lordship. Appellant died in the year 2013, my lordship.
2013.
Please. And they were suffering from financial constraints, my lordship. Therefore, they could not file within time, my lordship. The present appeal is filed in the year 2016, my lordship. And I have produced a synopsis along with my appeal memo, my lordship.
Explain ಮಾಡಿ.
Please.
ಇಲ್ಲೇ ಏನಪ್ಪಾ ಒಂದು 6 ತಿಂಗಳ ಒಂದು ವರ್ಷ ಇದ್ರೆ we can.
Please. Therefore, I have produced synopsis, my lordship, along with the memo, my lordship.
Read the paragraph in the accompanying affidavit.
Please. Number 3, my lordship, that the appellants are owners page number 32, my lordship.
Delay is not explained even online also.
Par number 4, 5, 6, my lordship. 6 ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. The connected matter, my lordship, I have produced a synopsis, my lordship, along with the appeal memo, my lordship. I have produced the judgment of Supreme Court, my lordship. There is a, for condonation of delay, my lordship. I have cited 3 citations, my lordship.
Proposition ಹೇಳಿ.
My lordship, may I read, my lordship, page number 1, along with my synopsis, my lordship, I have produced.
Where is the explanation for the delay? ಇಷ್ಟು ಲಾಂಗ್ ಡಿಲೇ ಕೆಲ ಮಾಡ್ಲಿಕ್ಕೆ ಬರ್ತದಾ?
In the year 2013, my lordship, the appellant died.
2 ವರ್ಷ ಇದ್ರು ಮಾಡಿ ಹಾಕ್ಬಿಡ್ತಿದ್ವಿ.
Please. I have produced the judgments, my lordship, along with my, wherein, my lordship, 4,000 days delay is condoned, my lordship.
It depends upon all facts.
Subject to waiving of interest, my lordship, in identical matters, my lordship.
ಈ ವರ್ಷದ MFAಗಳು ಸ್ಟಿಲ್ ಪೆಂಡಿಂಗ್ ಇದಾವ 2016 ಬರಲ್ಲ.
Please.
That hashtag you don't apply.
Apply
by waiving of interest.
Justice Velatri Vidi of the judgment.
Whereas, in this case, what happened, my lordship? It is in respect to LAC number 118, my lordship. But in respect of 117, my lordship, they have awarded 4,13,000, my lordship, in the Lok Adalat, my lordship. Subsequent to this honorable court, my lordship, it is enhanced up to 7,98,000, my lordship.
ಎಷ್ಟು ಡಿಲೇ ಎಷ್ಟು ವರ್ಷಪ್ಪ?
Delay, there is also delay, my lordship.
ಎಷ್ಟು ವರ್ಷ ಆಯ್ತು?
There is a 5,000 days delay, my lordship. In the present case, my lordship, there is 6,000, my lordship. Therefore, I have produced, along with my synopsis, my lordship, 3 judgments of Supreme Court, my lordship, and 3 judgments of our own High Court, my lordship, wherein 5,000 days delay is condoned, my lordship, waiving the interest of
Lord, I got the instructions, Lord. Would your lordship take up MFA?
ಬರ್ಲಿ ನಿಮ್ ಫ್ರೆಂಡ್ ಬರಲಿ, ವಿದ್ಯಾವತಿ ಬರಲಿ. ಅವ್ರ ಅಬ್ಸೆನ್ಸ್ ತೊಳಿಕ್ ಬರಲ್ಲ. ನೆಕ್ಸ್ಟ್.
Two weeks ಆಗಿರೋದು.
For the appellant's concern, this is that matter, my lord, where your lordships were pleased to refer the matter for mediation on the previous date of hearing, and your lordships are also pleased to keep, my lord, the directors to keep the parties present. The appellant is present before your lordships. She is the unfortunate second wife. My lord, the professor of philosophy is fat for multiple marriages, where for the first wife he got a divorce, third wife he wants, my lord, he got it legalized, second wife he left high and dry. The third marriage was contracted admittedly after the marriage with the second wife.
ಏನ್ ಸೆಟ್ಲ್ ಮಾಡಿಕೊಳ್ರಿ ಅಂತ ಹೇಳಿದ್ವಿ ನಾವು.
ನಾವು ಅದನ್ನೇ ಹೇಳ್ತಾ ಇದೀವಿ, ಬಟ್ ಅದೇನು ಅಂದ್ರೆ the offer that was given by the respondent, now that my lord, the husband is no more, it's only between the third wife and the second wife. He has not only, my lord, not granted me the status of a wife, but he has denuded me of all the properties that he owned by selling away all the properties during the pendency of the proceedings, and separate 2 RSAs are pending about that, and I will not trouble your lordships with that. So, my lord, it's a very piquant situation, both the human and also socio-legal.
ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೋಬೇಕು. ಇವೆಲ್ಲ ಫ್ಯಾಮಿಲಿ ಇಶ್ಯೂ ಇದೆ. ಇವು ಒಂದು ಮನವಿ ಇದೆ ನಮಗೆ.
Please, my lords.
ಈ ಕೌಟುಂಬಿಕ ವ್ಯಾಜ್ಯಗಳೇನ್ ಬರ್ತಾವ, ಅವುಗಳನ್ನ ಎಲ್ಲಾ ವಕೀಲರು ಕನ್ನಡದಲ್ಲೇ ನಡೆಸ್ತಕ್ಕದ್ದು. ಯಾಕೆಂದ್ರೆ ನೀವ್ ಏನ್ ಆರ್ಗ್ಯೂ ಮಾಡ್ತೀರಿ ಅಂತ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗಲ್ಲ, ಅವ್ರು ಹಿಂದಿರ್ತಾರೆ. ನೀವ್ ಹೇಳೋದು ಸರಿ ತಪ್ಪು ಫ್ಯಾಕ್ಚುಲಿ ಇಂಟೆನ್ಷನಲಿ ಅಂತಲ್ಲ, ಒಂದೊಂದ್ಸರಿ ನೀವ್ ಹೇಳೋದು ತಪ್ಪಿರ್ತದೆ. ಅವಾಗ ಅವ್ರು ಹಿಂದಿದ್ದವ್ರು ಹಂಗಿಲ್ಲ, ಅದು ಈ ರೀತಿ ಇದೆ ಅಂತ ಹೇಳಿಕ್ ಬರ್ತದೆ. ಅಟ್ ಲೀಸ್ಟ್ ನಮ್ ಪ್ರಕಾರ ಎಲ್ಲದನ್ನೂ ಕನ್ನಡದಲ್ಲೇ ಮಾಡಬೇಕು. ಎನಿವೆ ನಮ್ ಸಂವಿಧಾನದಲ್ಲಿ ಇಂಗ್ಲಿಷ್ ನಲ್ಲಿ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತದೆ, ಮಾಡೋಣಂತೆ. ಕನ್ನಡದಲ್ಲಿ ಮಾಡಬಾರದು ಅಂತ ಏನು ಹೇಳಿಲ್ಲ ಅವರು.
ಹೌದು ಆಗ್ಲಿ ಸರ್.
ಹಾಗಾಗಿ ಕೌಟುಂಬಿಕ ವ್ಯಾಜ್ಯದಲ್ಲಿ ಎಲ್ಲ ವಾದ ವಿವಾದಗಳು ಕನ್ನಡದಲ್ಲೇ ಆಗತಕ್ಕದ್ದು ಅನ್ಕೊಂಡು ನಿಮ್ಮಷ್ಟಕ್ಕೆ ನೀವೇ ಒಂದು ಆಶ್ವಾಸನೆ ಕೊಟ್ಟುಕೊಳ್ಳಿ.
ಆಗ್ಲಿ ಸರ್.
ನಾವು ಕನ್ನಡದಲ್ಲೇ ನಡೆಸ್ತೀವಿ.
ಆಗ್ಲಿ ಸರ್.
ನಮಗೆ ತೀರ್ಪನ್ನು ಕನ್ನಡದಲ್ಲಿ ಬರ್ಲಿಕ್ಕೆ ಸಾಧ್ಯ ಇದೆ, ಆದ್ರ ವ್ಯವಸ್ಥೆ ಇಲ್ಲ. ಹಾಗಾಗಿ ಅದನ್ನ ಅಂಗ್ರೇಜಿಯಲ್ಲೇ ಕೊಡೋಣಂತೆ. ಆದ್ರೆ ಅಟ್ಲೀಸ್ಟ್ ವಾದ ವಿವಾದಗಳು ಎಲ್ಲರಿಗೂ ಗೊತ್ತಾಗ್ಲಿ, ಮತ್ 4 ಜನರಿಗೆ ಎಜುಕೇಶನ್ ಆಗ್ತದೆ, ಅದು ಉಪಯೋಗ ಆಗ್ತದೆ.
ಆಗ್ಲಿ ಸರ್.
ಕನ್ನಡದಲ್ಲೇ ಮಾಡೋಣ. ಕನ್ನಡ ಭಾರಿ ಸುಂದರ ಭಾಷೆ ಅದು. DVG ಅವರೆಲ್ಲ ಹೇಳಿದ್ ನೋಡಿ ಏನ್ ಹೇಳ್ಯಾರ, ಸಂಸ್ಕೃತದಕ್ಕಿಂತ ಸುಂದರವಾದ ಭಾಷೆ,
ಸುಲಿದ ಬಾಳೆಯ ಹಣ್ಣಿನಂದದಿ
ಅಂತ ಭಾಷೆ ಅದು.
ಏನ್ ಸಾಹೇಬ್ರ, ಒಂದ್ ಮನೆ ಇದೆ, ಆ ಮನೆಗೆ ಅವರು 15 ಲಕ್ಷ ಕೊಡ್ತೀವಿ ಮನೆ ಬಿಟ್ಟು ಹೋಗಿ ಅಂದ್ರು. ನಾವು ನಮ್ಮ ಕ್ಲೈಂಟ್ ಮಗ, ಹಿ ಇಸ್ ಆಲ್ಸೋ ಅನ್ ಅಡ್ವೊಕೇಟ್, ಸಾರಿ ಅವರು ವಕೀಲರಿದ್ದಾರೆ ವೃತ್ತಿಯಲ್ಲಿ, ಅವರು ನಾನು 1.5 ಕೋಟಿ ಕೊಡ್ತೀನಿ, ನನ್ನ ಪ್ರಾಪರ್ಟಿ ನಮಗೆ ಬಿಡಿ, ನಮ್ಮ ತಂದೆದು ಅಂತ ಹೇಳಿ ಇಷ್ಟಕ್ಕೆ ಬಂದು ನಿಂತಿದ್ದೆ ಸಾಹೇಬ್ರೆ. ಅದಕ್ಕೊಂದು ರೀಸನಬಲ್ ಆದ್ರೆ ಆಯ್ಕೆ ನಾನು ಅವರಿಗೆ ಒಂದ್ ಸ್ವಲ್ಪ ಅವ್ರಿಗೆ ಮನವೊಲಿಕೆ ಮಾಡಕ್ ಪ್ರಯತ್ನ ಮಾಡ್ತೇನೆ.
ಏನೋ ಒಂದು ಕಾಂಪ್ರಮೈಸ್ ಮಾಡ್ಕೊಂಡು ಒಂದು ರಾಜಿ ಮಾಡ್ಕೋಬೇಕು.
ಅಲ್ಲ, ಈ ಕೇಸಲ್ಲಿ ಅದು ಒಂದೇನೆ, ಯಾಕೆಂದ್ರೆ ಕಾನೂನಾತ್ಮಕವಾಗಿ ತುಂಬಾ ನನಗೆ ನ್ಯಾಯ ಕೊಡ್ಲೇಬೇಕು ಅಂದ್ರೆ ನಾನು ತಮ್ಮನ್ನು ಒತ್ತಾಯ ಮಾಡೋದು ಕಷ್ಟ ಆಗುತ್ತೆ. ಆ ಪರಿಸ್ಥಿತಿಲಿ ನಾನಿದ್ದೀನಿ.
ಅವ್ರು ನೀವು ಇಬ್ರು ಮಾಡದೇ ಇದ್ದಾಗ ನಮ್ಮ ಆದೇಶವನ್ನ ನಿಮ್ಮ ಮೇಲೆ ಹೇರುತ್ತೇವೆ, ಅದು ಖುಷಿಯ ವಿಷಯ ಅಲ್ಲ ಅಷ್ಟೇ. ನಮ್ಮ ಆದೇಶವನ್ನ ಹೇರುವ ಅಧಿಕಾರ ನಮಗಿದೆ. ಆದ್ರೆ ನಿಮ್ಮಷ್ಟಕ್ಕೆ ನೀವೇ ರಾಜಿ ಮಾಡ್ಕೊಂಡ್ಬಿಟ್ರೆ ಅದಕ್ಕೆ ಆಸ್ಪದ ಇರಲ್ಲ.
ಒಳ್ಳೆಯ ತೀರ್ಪು ಕೆಟ್ಟ ಮಧ್ಯಸ್ಥಿಗಿಂತನೂ.
One sincere apologies, my lords. Respondent number 2 inform ಮಾಡಿದೆ my lords over phone, but since yesterday she did not lift my call, my lords. So she could not be present. I don't know what is the situation over there.
ಡೇಟ್ ನಾವು ದಿನಾಂಕ ಕೊಟ್ಟಿದ್ವಲ್ಲ, ನಿಗದಿ ಮಾಡಿದ್ವಲ್ಲ.
ಇವತ್ತೇ ಐತೆ ಸಾಹೇಬ್ರೆ.
Prior only I have informed, my lords. What is her situation over there? I don't know. I think she resides somewhere in Bangalore or Mysore. I don't know.
ಯಾವ ಊರವರು ಅವರು?
ಧಾರವಾಡದಲ್ಲೇ ಅವರು ಸಾಹೇಬ್ರೆ. ಅವರು ಟೀಚರ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು. ನಮ್ಮ ಪತಿಯವರ ವಿದ್ಯಾರ್ಥಿ ಆಕೆ, ಆ ವಿದ್ಯಾರ್ಥಿಯನ್ನ 3ನೇ ಮದುವೆ ಆಗಿದ್ರು. ಅವ್ರು ಇಲ್ಲೇ ಇದಾರೆ ಅಂತ ಮಾಹಿತಿ ಇತ್ತು, ಅದು ನಾನು ಕರೆಕ್ಟ್ ಆಗಿ.
She is not residing in Dharwad.
ಧಾರವಾಡದಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ಲ, ಮೈಸೂರು ಅಥವಾ ಬೆಂಗಳೂರು ಎರಡು ಊರಲ್ಲಿ ಬಂದು
ನಾನು
ನಾನು ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್. ನಾನು ಆಲ್ರೆಡಿ ಪ್ರಿವಿಯಸ್ ಡೇಟ್ ಆದ್ಮೇಲೆ ವೆರಿ ನೆಕ್ಸ್ಟ್ ಡೇನೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೆ ಸ್ವಾಮಿ. ನಿನ್ನೆ ನಾನು ಫೋನ್ ಹಚ್ಚಿದ್ರೆ ಲಿಫ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. That is my.
ಯಾವತ್ತು ನಾವು ಪೋಸ್ಟ್ ಮಾಡಿದ್ದನ್ನ 10/9 ಆಗಿದೆ ಆದೇಶ.
On the same day I informed her. ಬರ್ಬೇಕಾದ್ರೆ ತಿಳಿಸಿದೀವಿ. ಈಗ ಏನ್ ಪರಿಸ್ಥಿತಿ ಐತಿ ಗೊತ್ತಿಲ್ಲ ಸ್ವಾಮಿ. ಹಿಂಗ ಫೋನೇ ಎತ್ತಲಿಲ್ಲ ನಿನ್ನೆಯಿಂದ. Just to know whether she is coming or not, I was calling her. She did not answer my call. That's the problem.
This court-wide order dated 10/9/2024 had said as under. First stop. In terms of the said order, the counsel for appellant and her counsel are personally present before the court, and evince interest to settle the matter amicably, provided that the other side cooperates. First stop. Next paragraph. Learned counsel appearing for the respondent submits that her efforts to have communication with her client ended in vain, and on the next date of hearing, the respondent shall be personally present before the court for trying an amicable settlement. Full stop. In view of the above, call this matter day after tomorrow, next week.
Please, next week.
On date query. But registry to send a copy of this order by speed post immediately to the respondent for information and needful action. On compromise, you know, ಮಾಡ್ಕೋಬೇಕು.
Please.
ಇವನ್ನೆಲ್ಲ ಕೇಸ್ ಮಾಡಿಸೋದಲ್ಲ ಇದು.
Grateful, my lord.
Next.
ಲಾಸ್ಟ್ ಡೇಟ್ ಆಫ್ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ಇವರಿಗೆ ಅರಿಯರ್ಸ್ ಆಫ್ ಮೇಂಟೆನೆನ್ಸ್ ಪೇ ಮಾಡಿ ಆಮೇಲೆ ದೆನ್ ದೇ ಶುಡ್ ಆರ್ಗ್ಯೂ ಅಂತ. ಪೇ ಮಾಡಿಲ್ಲ ಅಂತ ನಾನು
ನೋಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್ಸ್ ಏನ್ ಮಾಡಿದ್ವಿ ಲಾಸ್ಟ್ ಟೈಮ್.
Filing the memo of calculation, your lordships.
ನಿಮ್ ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಪ್ರಕಾರ ಎಷ್ಟು ಕೊಡಬೇಕು?
2,09,000 ಕೊಡ್ಬೇಕಾಗುತ್ತೆ.
ಅದನ್ನ ಕೊಡಿ. ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಅರೆಸ್ಟ್ ಮಾಡೋಕು ಅಂತ ಆರ್ಡರ್ ಬಂದೇವು ನಾವು. ಮೆಮೋ ಮೊದ್ಲೇ ಕೊಡ್ಬೇಕು ಅವೆಲ್ಲ. ಇಲ್ಲಿ ಕೋರ್ಟ್ನಾಗ ಕೊಟ್ರೆ ಹೆಂಗ್ ಮಾಡ್ಬೇಕು? ಮೊದ್ಲೇ ಕೊಟ್ರೆ ಅವ್ರು ಕೇಳ್ಕೊತಾರೆ, ಮಾಡ್ತಾರೆ ಅಲ್ವಾ?
ಪ್ಲೀಸ್ ಅದ್ರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ
ಎಷ್ಟು ಈಗ ಅಮೌಂಟ್ ಎಷ್ಟು ತುಂಬಿದಿರಿ ಈಗ?
today is ready to pay 50,000 your lordships.
50 ಏನಂತ ಆರ್ಡರ್ ಇದೆ ಅವರಿಗೆ ಓದಕ್ಕೆ ಕೊಡ್ರಿ, ಹೇಳ್ರಿ ಅವರಿಗೆ. ಅರೆಸ್ಟ್ ಆರ್ಡರ್ ಮಾಡ್ತೇನೆ ನಾನು. ವಿ ಆರ್ ಡೈರೆಕ್ಟಿಂಗ್ ಅರೆಸ್ಟ್ ಅಂಡ್ ಡಿಟೆನ್ಷನ್. ಹೇಳಿ ಹೇಳಿ ಅವರಿಗೆ, ಅವ್ರನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆರ್ಡರ್ ಮಾಡ್ತೇವೆ ನಾವು. ಲೇಡಿ ಹೆಂಗ್ ಜೀವನ ಮಾಡ್ಬೇಕು, ನೀವು ಒಪ್ಕೊಂಡಂತ ಅಮೌಂಟ್ ಆದ್ರೂ ಕೊಡ್ಬೇಕಲ್ಲ, ಅದು ಕೊಡೋದು ಬೇಡ.
Today is ready to pay 1 lakh rupees. Remaining 2-3 days ಅಲ್ಲಿ he will pay it today.
ಕೊಡಿ, ಹಂಗೆಲ್ಲ ಮಾಡಬಾರ್ದು. ಕೋರ್ಟ್ ಆದೇಶ ಇದ್ದಾಗ ಆ ಪ್ರಕಾರ ನಡ್ಕೋಬೇಕು.
ಪ್ಲೀಸ್
ಕೊಡಿ, ದುಡ್ಡು ಕೊಡಿ.
ಚೆಕ್ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ.
ಚೆಕ್ ಏನ್ ಗ್ಯಾರಂಟಿ ಇದೆ? ನಾಳೆ ಎನ್ಕ್ಯಾಶ್ಮೆಂಟ್ ಆಗ್ತದಾ?
ಆಗ್ತದೆ, ದುಡ್ಡು ಇದೆ ಬ್ಯಾಂಕ್ ಅಲ್ಲಿ ಇದೆ ಅಂತ ಅವ್ರು ಹೇಳಿದ್ರು. ಕೇಳ್ಕೊಂಡೆ ಮಾಡ್ತಾರೆ.
ಎಷ್ಟಿದೆ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ, ಅಕೌಂಟ್ ನಲ್ಲಿ? ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಿಮ್ ಬ್ಯಾಂಕ್ ಯಾವ್ದು ಕೊಡ್ರಿ, ಅವರಿಗೆ ಒಂದು ಕರೀರಿ, ರಿಜಿಸ್ಟ್ರಾರ್ ಜನರಲ್ ಫೋನ್ ಮಾಡಿ ಮ್ಯಾನೇಜರ್ಗೆ ಅವ್ರ ಅಕೌಂಟ್ ನಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ ಕೊಡ್ರಿ. ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಕೊಡಿ, ಅಥವಾ ನೀವೇ ಹೇಳ್ತೀರಾ?
1.5 ಲಕ್ಷ ಇದೆ ಅಂತ ಸ್ವಾಮಿ. 1.5 ಲಕ್ಷ ತನಕ ಇದೆ, ದುಡ್ಡು ಇದೆ ಅಂತ.
ಎಷ್ಟು ಲಕ್ಷ ಇದೆ ಬ್ಯಾಂಕ್ ನಲ್ಲಿ? ಈಗ ಮತ್ತೆ ನಾನು ಅದು ಅಲ್ಲಿಂದ SP ಆರ್ಡರ್ ಮಾಡಿ ತರಿಸ್ತೇನೆ ನಾನು ಎಲ್ಲ ಡೀಟೇಲ್ಸ್. ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಲ್ಲಿ ಎಷ್ಟಿದೆ ಅಂತ ಕೇಳಿ, ಅವರೇ ಹೇಳ್ತಾರೋ ನಾ ಪೊಲೀಸರಿಂದ ತರಿಸ್ಕೋಬೇಕು?
1.5 ಲಕ್ಷ ತನಕ ಇದೆ ಅಂತೆ. 1.5 ಲಕ್ಷ ಇದೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಬ್ಯಾಂಕ್ ನಲ್ಲಿ 1.5 ಲಕ್ಷ ಮಾತ್ರ ಇದೆಯಾ?
ಇದೆ.
ಏನ್ ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ಬರ್ಕೊಡಿ, ಚೆಕ್ ಕೊಡಿ. ನೋಡ್ರಿ, RGಗೆ ಫೋನ್ ಮಾಡಿ, ಆ ಬ್ಯಾಂಕ್ ಮ್ಯಾನೇಜರಿಗೆ ಫೋನ್ ಮಾಡಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಅನ್ಕೊಂಡು ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ ತರಿಸೋಬೇಕು. ಓಕೆ, RG ಡೈರೆಕ್ಟೆಡ್ ಟು ಸೆಕ್ಯೂರ್ ದಿ ಬ್ಯಾಂಕ್ ಬ್ಯಾಲೆನ್ಸ್ ಆಫ್ ದಿ ರೆಸ್ಪಾಂಡೆಂಟ್ within 10 minutes from the concerned bank. Full stop. This order shall be treated as an assurance against privacy violation. Okay. Good. That's ಕೂತ್ಕೊಳ್ಳಿ.
ಪ್ಲೀಸ್
ನೋಡ ಎಷ್ಟು ಅಮೌಂಟ್ ಇದೆ ಅಂತ. ಅಲ್ಲಿ ಜಾಸ್ತಿ ಇತ್ತು ಅಂದ್ರೆ ಅವ್ರ ಮನೆಗೆ ಹೋಗಲ್ಲ. ಈಗ ಹೇಳಿ ಇನ್ನೊಂದ್ಸರಿ ಅವರಿಗೆ, ಅವ್ರಿಗೆ ಹೇಳಿ, ಅಮೌಂಟ್ ಏನಾದ್ರು ಜಾಸ್ತಿ ಇತ್ತು ಅಂದ್ರೆ, ನಮ್ಗೆ ಏನಾರ ಸುಳ್ಳು ಹೇಳಿದ್ರಿ ಅಂತ ಗೊತ್ತಾಯ್ತು ಅಂದ್ರೆ ನೋಡಿಲ್ಲ, ಆಯ್ತು, ನಿಮ್ ಬ್ಯಾಂಕ್ ಅಕೌಂಟ್ ನಿಂದ ಕೇಳ್ಕೊಂಡು ಹೇಳ್ರಿ, ನಾವು ಸಪರೇಟ್ ತರಿಸ್ತೀವಿ, ನೀವು ಕೇಳ್ಕೊಳ್ಳಿ. ಇದ್ ಕೊಡಿ, ಇಮಿಡಿಯೇಟ್ಲಿ RGಗೆ ತರಿಸಿ. ಅವ್ರು ನೀವು ಹೇಳ್ಬೇಕೀಗ, RG ಟು ಫೈಲ್ ದ ಇನ್ಫಾರ್ಮೇಶನ್ ಇನ್ ಸೀಲ್ಡ್ ಕವರ್ ತರಿಸಿ. ಅದು ನಿಜ ಇರಲಿದ್ರೆ ಮಾತ್ರ ನಾವು ಹಂಗ ಬಿಡಲ್ಲ. ಆಯ್ತು, ಈಗ ಕೊಡಿ, ದುಡ್ಡು ಕೊಡಿ. ಎಷ್ಟು ದುಡ್ಡು ತಂದಾರ ಈಗ ಅವ್ರು?
ದುಡ್ಡು ಅದೇ ಇದು ಚೆಕ್ ಕೊಡ್ತಾರೆ, ದುಡ್ಡು ತಂದಿಲ್ಲ ಸ್ವಾಮಿ ಅವರು. ಅದಕ್ಕೆ ಚೆಕ್ ಕೊಡುವಂತ ಇದು ಮಾಡ್ಕೊಂಡು ಬಂದಿದ್ದಾರೆ.
ಕಾಲ್ ದಿಸ್ ಅಲ್ಲಿ ಪಾಸ್ ಔಟ್. ಇಷ್ಟು ಆರ್ಡರ್ ಮಾಡಿದ್ರು, ಅರೆಸ್ಟ್ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ರು, ಏನಪ್ಪ ಭಾರಿ ಧೈರ್ಯ ಬಿಡಿ.
ಚೆಕ್ your lordships by way of.
ನಾಳೆ ತಂದು ಕೊಡ್ತೀರಾ ಉಳಿದಿದ್ದ ಅಮೌಂಟ್?
ಪ್ಲೀಸ್ your lordships
ಕೊಡಿ, ಇಸ್ಕೊಳ್ಳಮ್ಮ, ಬಂದ್ ಕೊಡಿ.
ಚೆಕ್ ಅಂತ
recall that order. Counsel, the respondent husband personally present before the court
1 ಲಕ್ಷ
has handed a check dated so and so, drawn on so and so bank for a sum of rupees 1.5 lakh in favor of the appellant wife, with the assurance that there is sufficient balance in the bank account, and on due presentation the check shall be honored, failing which the act may amount to contempt of this court. Full stop. Kodi, check kodi.
ಕೊಟ್ಟಿನ ಸಮಯ ಚೆಕ್
ಕೊಡಿ. Call this. The balance amount shall be paid tomorrow. Call this matter tomorrow.
Today the matter will listed for the payment of permanent alimony ಸಲಾಗಿ ಇವತ್ತು ಲಿಸ್ಟ್ ಆಗಿತ್ತು ಮ್ಯಾಟರ್. ಅದು
ಮೊದಲಿಗೆ ನೀವು ಪೇಮೆಂಟ್ ಮಾಡಿ, ನೀವು ಮೊದಲಿಗೆ ಕೋರ್ಟ್ಗೆ ಮಾನ್ಯ ಮಾಡ್ತೀರಿ, ಆದೇಶ ಪಾಲನೆ ಮಾಡ್ತೀರಿ ಅಂತ ನಮ್ಗೆ ಅನಿಸ್ಲಿ, ಆಮೇಲೆ ನಾವು ಏನಾರ ಒಂದು ಮರ್ಸಿ ತೋರ್ಸೋಣ. ಪಾಲನೆ ಮಾಡಿದವರಿಗಿಲ್ಲ. ನಾಳೆ ನಿಮ್ ಬ್ಯಾಂಕ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ತೊಗೊಂಬರ್ಬೇಕು. The respondent husband is directed to bring the bank statement of his account till this day.
My submission of the respondent is government employee lordship. Tomorrow there is no leave your lordship. Leave ಹಾಕಿಲ್ವಂತ ಅವ್ರು, ಅದಕ್ಕಾಗಿ ಇವತ್ತು ಬಂದ ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ
ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ. ಆಯ್ತು, ಅಷ್ಟೇ. has handed check for 1.5 lakh with assurance 77%. ಅಷ್ಟೇ. ಅಲ್ಲ.
Please.
Appear for minutes. Respond. Notes. On previous occasion, question was arose before this honorable court, whether we are ready to hand over the land to the complainants. Let's we verified the records that road is yet to be handed over by the Smart City Corporation to City Corporation. Smart City Company is not yet handed over that entire road to the City Corporation Belagavi yet, my lords.
ರೋಡ್ ಅವ್ರು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ಮೇಲೆ ನೀವು ಅದನ್ನ ಇವ್ರಿಗೆ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ತೀವಿ.
ಅವ್ರು ಮಾಡ್ಬೇಕಾಗತ್ತೆ. ಅಂಡ್ ಅದರಲ್ಲೂ ಏನಾಗಿದೆ ಇಲ್ಲ
ಬರ್ಕೊಡಿ. ನೀವು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡ್ಲಿಕ್ಕೆ ರೆಡಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ, ನಮಗೆ
ನೀವು ಕ್ಲೇಮ್ ಬಿಡ್ತೀರಾ?
ನಮ್ಗೆ ಅವ್ರು ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದ್ರೆ
ಅವ್ರು ಬಿಡಿ. ಇಲ್ಲ ನಾವು ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ತೀವಿ ಕೊಟ್ಟು ಬಿಡಿ ಅಂತ. ನೀವು ಬೇಡ ಅಂತ ಅನ್ಕೊಂಡ್ರೆ ಅವ್ರಿಗೆ ಹೇಳ್ಬಿಡ್ತೀವಿ.
ಅದರಲ್ಲಿ ಮತ್ತೊಂದು ಒನ್ ಮೋರ್ ಪ್ರಾಬ್ಲಮ್ ಈಸ್ ದೇರ್. ಆ ಕಂಪ್ಲೀಟ್ ರೋಡ್ ಇನ್ನ ಕಂಪ್ಲೀಟೇ ಆಗಿಲ್ಲ. ಅಲ್ಲಿ ಒಬ್ರು ಆಲ್ರೆಡಿ ಸ್ಟೇ ತಗೊಂಡು ರೋಡ್ ವರ್ಕ್ ಕೂಡ ಅಲ್ಲೇ ನಿಂತಿದೆ. Since Smart City is also party to this. Smart City ಅವರು party ಇದ್ದಾರೆ.
There is order against Smart City also. Even he is a party in this contempt proceedings also.
Proceedings.
And keeping him in behind, they themselves came and filed affidavit stating that we will acquire and pay the money. Smart City ಅವರು
on behalf of
they are also party. They are appeared through advocate also in this contempt.
Smart City ಗೆ ಯಾರು appear ಆಗ್ತಾರೆ?
I am for Belgavi Smart Cities. As per the order passed in the earlier contempt, sir, there was a government order dated 18/9/2022, Your Lordship. There was a direction given to the corporation.
ಬಿಡಿ.
Yes.
ದುಡ್ಡು ಕೊಡಬೇಕು ಇಲ್ಲ ಲ್ಯಾಂಡ್ ವಾಪಸ್ ಕೊಡಬೇಕು, ಎರಡೂ ಬೇಕು ಅನ್ನಂಗಿಲ್ಲ. ಐ ವಾಂಟ್ ಟು ಹ್ಯಾವ್ ಕೇಕ್ ಅಂಡ್ ಈಟ್ ಇಟ್ ಅಂತಾರಲ್ಲ, ಹಂಗ್ ಮಾಡಕ್ಕೆ.
As a special
ಲ್ಯಾಂಡ್
purpose
ಬೇಕಾ?
vehicle,
ಅನಾವಶ್ಯಕವಾದ
please,
ಮಾಡಬೇಡಿ.
please.
ಲ್ಯಾಂಡ್ ಅನ್ನ ರಾಬರಿ ಮಾಡಕ್ ಬರಲ್ಲ. ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳದಿದ್ರೆ ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡಬೇಕು, ಇಲ್ಲ ಲ್ಯಾಂಡ್ ವಾಪಸ್ ಕೊಡಬೇಕು. ಇದು ಮಾತುಕತೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಆಗಿದ್ದು. ಇದೇ ಮಾತುಕತೆನೂ ಒಂದು 5 ವರ್ಷ ಮಾಡಕ್ ಬರಲ್ಲ ನಮ್ಗೆ. ಈಗ ಹೇಳ್ಬೇಕು ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ.
As Belgavi Smart City is a special purpose vehicle, Your Lordship. There is a board. We have to put a proposal before the board, Your Honor, Lordship. And under the said meeting, there will be a resolution passed, Your Lordship. As per the resolution, if these are all new facts which have been incorporated now, we have to hand it over back to the corporation. Therefore, there will be a meeting.
20 guntas. 20
guntas. Separate ಇದೆಯಾ? ತಗೊಳ್ಳಿಕ್ ಬರಂಗಿದೆಯಾ?
If your lordship
ಬರಲ್ಲ.
Your lordship is pleased to see this map.
ರೋಡ್ ಮಾಡಿಬಿಟ್ಟಾರ ಈಗ.
Road is formed. They are using it.
ಯಾವುದು ಇದರಲ್ಲಿ ಮೆನ್ಷನ್
Road is under the black mark ಮಾಡಿದ್ ನೋಡಿ ಸರ್. This black portion. Black portion belongs
326.
Yes.
26, 325.
326 part. 326 ಏನಿದೆ ಸರ್, ಬ್ಲಾಕ್ ಮಾರ್ಕ್ ಮಾಡಿದ್ರು.
ಇದು ರೋಡಿನ ಆ ಕಡೆ ಈ ಕಡೆ ಎರಡು ಕಡೆ ಬರ್ತದೆ.
ಇದು ಎರಡು ಕಡೆ ಬಂದ್ರೆ ಅವ್ರಿಗೆ ಈ ರೋಡ್ ಪೂರಾ ಕಟ್ ಆಗುತ್ತೆ.
ಆ ಕಡೆ ಈ ಕಡೆ ನಿಮ್ದೇ ಇದೆ.
ಹೌದು.
ಆ ರೋಡಿಗೆ ಹೋದಂತದ್ ಮಾತ್ರ ನಿಮ್ಗೆ ಕೊಡ್ಬೇಕು.
ಹೌದು, ಅದು ಕೊಟ್ಟರು ನಮಗೆ ಈಚೆ ಕಡೆ ಏನ ಇದೆ ಅದು ಉಳಿತೆ. ಅದು ಕೊಟ್ಟು ಇವನ್ ರೋಡ್ ಇಟ್ ಸೆಲ್ಫ್ ಇಸ್ ಟೋಟಲಿ ಡ್ಯಾಮೇಜ್.
ಈ ರೋಡ್ ಬಂದ್ ಮಾಡಿದ್ವಿ ಅಂತ ಕೊಟ್ರಿ ನಿಮ್ಗೆ ಲ್ಯಾಂಡ್ ವಾಪಸ್ ಕೊಟ್ಟು, ಅವಾಗ ಏನಾಗ್ತದೆ?
ನಮಗೆ ಫಾರ್ ದೆಮ್ ಟು ಫೇಸ್ ದ
ಬೇರೆ ಯಾವ ರೋಡ್ ಇದೆ ಅಲ್ಲಿಗೆ?
There is no any other way to go on the other side. There was earlier at Mahadwa Road, but that is a very narrow road right now, sir.
ಕಾರ್ ಎಲ್ಲ ಅಡ್ಡಾಡ್ತದ ನ್ಯಾರೋ ರೋಡ್ ನಲ್ಲಿ?
Certainly.
ಕಾರ್ ಅಡ್ಡಾಡ್ತವೆ.
But
this road,
ಈ ರೋಡ್ ಅಕ್ಯುಪೈ ಮಾಡಿಕೊಳ್ಳಿ ಕೊಡ್ತೇವೆ ಅವ್ರಿಗೆ. ಅದು ರೋಡ್ ನಲ್ಲಿ ಬಿಲ್ಡಿಂಗ್ ಕಟ್ಟಿಕೊಳ್ಳಿ ಅವ್ರೀಗ. ಬೇರೆ ದಾರಿ ಇಲ್ಲ ನಮ್ಗೆ.
ಈ ತರ ಸ್ಟ್ರಿಪ್ ಇದೆ, ಅಲ್ಟರ್ನೇಟ್ ರೋಡ್ಸ್ ಅಲ್ಲಿ
ಹೋಗಕ್ ಬರಕ್ ಬರ್ತದೆ.
ಮತ್ತೆ ಆ ರೋಡ್ ಇಷ್ಟು ವರ್ಷ ಈ ರೋಡ್ ಇರ್ಲೇ ಇಲ್ಲ. ಅಪ್ ಟು 2016.
ಅಲ್ಲ, ಈಗ ನಾವು ಆರ್ಡರ್ ಮಾಡಿರೋದು ಏನಂತ ಅಂದ್ರೆ ಇದೊಂದು ಎಕ್ಸ್ಟ್ರಾರ್ಡಿನರಿ ಕೇಸ್ ಅಂತ ಟ್ರೀಟ್ ಮಾಡ್ತೀವಿ. ಗವರ್ಮೆಂಟು ಮತ್ತು ನಿಮ್ ಗವರ್ಮೆಂಟಲ್ ಬಾಡೀಸು ದುಟಾಯಿಗಿರಿಯಿಂದ ಲ್ಯಾಂಡ್ ತಗೊಂಡು ಕಾಂಪನ್ಸೇಷನ್ ಕೊಡ್ತಾ ಇಲ್ಲ. ಹಾಗಾಗಿ ನಾವೊಂದು ದುಟಾಯಿಗಿರಿಯ ಆದೇಶ ಮಾಡಬೇಕು ಅಂತ ಬರೀತೇವೆ ಅದರಲ್ಲಿ. ಈ ರೋಡನ್ನು ಈ ಜಾಗ ವಾಪಸ್ ಕೊಟ್ಟು ಬಿಡ್ರಿ ಅವರಿಗೆ. ಅವ್ರು ಏನಾರ ಅಲ್ಲಿ ಹೋಗಿ ಮನೆ ಕಟ್ಟಿಕೊಳ್ಳಿ, ಇನ್ನೊಂದು ಏನಾರ ಮಾಡಿ ಬರ್ಕೊಳ್ಳಿ.
ರೋಡ್ ಎಲ್ಲ ತೆಗೆದು ಸೆಟರೇಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು ಸರ್. ಈಗ ಅಲ್ಲಿ ರೋಡ್ ಮಾಡಿಬಿಟ್ರೆ ಅದನ್ನ ತೆಗೆದು ಸೆಟರೇಟ್ ಮಾಡಿ ಕೊಡ್ಬೇಕು, ಇಲ್ಲಾಂದ್ರೆ ಮತ್ತೆ ತೆಗಿಯಾಕ ನಮ್ಗೆ ಕಂಡಪ್ಪ
ಅದು ಮಾಡಲ್ಲ. ಅದನ್ನ ನೀವೇ ಮಾಡ್ಕೊಳ್ರಿ. ಆ ಖರ್ಚು ಏನ್ ಬರ್ತದೆ ಅವರಿಂದ ರಿಕವರ್ ಮಾಡ್ರಿ ನೀವು ಒಂದು ಸೂಟ್ ಹಾಕೊಂಡು.
15 days time may kindly be granted because this company being incorporated with the ULB board members, there has to be a meeting and resolution passed, Your Lordship. Under the resolution only, we can hand it over back to the corporation.
ಕೂತ್ಕೊಳ್ಳಿ. A learned single judge of this court in complainants WP number 102732 of 2021 LB Res had rendered a judgment dated 31 August 2021 wherein relevant part of the operative portion thereof reads as under. Para 3 है. Para 3 thereof reads as under. Next. The mandate of the learned single judge having not been complied with, the complainants had moved CCC 10005 of 58 of 2022 and the coordinate bench of this court wide order dated 6/7/2023 had said in para 3 thereof as under, 3 and 4 thereof as under. The above order was made in terms of the affidavit sworn to by the assistant commissioner who was party another.
Never. He was not a
Who was
party.
not a party eo nominee to the said proceedings, but it was handed for being acted upon. First, the corporation too had filed an affidavit through the commissioner.
Through the commissioner, stating that government has granted permission to acquire the land.
Stating that the government had permitted sanctioned acquisition of the subject land belonging to the complainant. Paras 6 and 7 of the said affidavit read as under. Next paragraph. Even the undertaking given through the affidavits and the order structured on that basis having not been complied with, the complainant with no option instituted this fresh complaint in seeking revival of the complaint in the complaint hearing. First off, too many rounds of arguments and counter arguments were advanced in this matter, and it was disgusting to this court to hear them without a leaf being turned. First off, we alerted the respondent accused persons that right to private property is constitutionally guaranteed under Article 300 capital A, more particularly in the light of Apex Court decision in KT Plantations versus State of Karnataka and others. So. First, at some time, the assurance was given to us that something would be done in the matter. First, when that assurance was given by the counsel appearing for the respondents, the land acquisition assistant commissioner of the jurisdictional revenue division and the commissioner of the local body were personally present as they are present this day too. First off, The court exists for doing justice and not for endlessly quoting jurisprudential theories. Full stop. Having extensively heard this matter again and again, comma, we have reached a conclusion that no amount of hearing the respondents would result into rendering justice to the complainant. First off, it is open to the state to acquire private land for public purpose, provided that the compensation is paid to the landowner. First off, this having not happened, despite order of the learned single judge, comma, despite assurance being given in the contempt proceedings earlier and now in the revived contempt proceedings, comma, we are left with no option than to direct the respondents to put the complainant in exclusive possession of the subject property immediately. First off, it is open to the complainants to take physical possession of the subject property immediately and make use of it as they please. And for that purpose, the jurisdictional police shall give full protection on seeing a copy of this order. First off, if the respondents or anyone claiming under them obstruct implementation of this order, comma, the jurisdictional police shall arrest them and keep them in detention without leaving with sans permission of this court. First, ordered accordingly, it is open to the complainants to seek damages from the concerned quarters, and in that connection, all contentions are kept open. First off, accordingly, this complaint is disposed of, levying
We don't have money and we are unable to pay the compensation. In view of they non-depositing amount, state is not able to proceed. Acquisition, it shows that there are authorities are on the land. No, rate order in case set aside.
This extraordinary order is made since extraordinary circumstances of the case so warranted. ಅಲ್ಲೊಂದ್ ಕಡೆ ಸರಿ ಮಾಡ್ಕೊಂಡು ಆಮೇಲೆ ಇನ್ನೊಂದು ಒಂದು ಪ್ಯಾರಾಗ್ರಾಫ್ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಮಾಡಿದೇವೆ ನಾವು. ಎಷ್ಟು ಲಕ್ಷ ಹಾಕ್ಬೇಕು ನೀವು ಪರ್ಸನಲಿ ಕೊಡ್ಬೇಕು ಅಂತ ಮಾಡ್ತಾ ಇದ್ದೇವೆ ಆರ್ಡರ್. ಏನಾರ ಹೇಳೋದಿದೆಯಾ? ಬನ್ನಿ, ಏನಾರ ಹೇಳೋದಿದ್ರೆ ಹೇಳಿ. ಆಮೇಲೆ ನೀವು ನಮ್ದು ಹಿಯರ್ ಮಾಡಿಲ್ಲ ಕಾಸ್ಟ್ ಹಾಕುವಾಗ ಅಂತ ಹೇಳಂಗಿಲ್ಲ. ನಿಮ್ ಕೇಳ್ತಾ ಇದ್ದೇವೆ ಈಗ ನಾವು
Assistant Commissioner is concerned. Although he is not a broad party in the matter, but as per earlier direction,
but affidavit ಹಾಕಿದ್ರಲ್ಲ ಅವರು.
What the affidavit says, we will complete the acquisition. For that, we already initiated and 11 passed.
Complete the acquisition ಅಂದ್ರೆ ಬರೀ ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳೋದಲ್ಲ.
No.
ದುಡ್ಡು ಕೊಡಬೇಕು.
Up to the level of passing the award. Now we not up to come to the award, we requested the beneficiary to deposit the amount, the award amount. Since they have paid to deposit the amount, therefore the other is not completed.
Cost plus one entry, adverse entry in the service record. He should not get from that. Bad entry will gain.
AC role ಏನಿಲ್ಲ. The reason is not.
Affidavit ಹಾಕಿದ್ರಲ್ಲ ಅವರು. He had filed affidavit.
That we are completed,
ಏನ್ complete ಮಾಡಿ?
Till the passing of the award, since they have not deposited the amount.
ತೆಗೀರಿ ಅದನ್ನ ತೋರಿಸಿ, ಏನು ಅಫಿಡೇಟ್ ತೋರಿಸಿ. ಏನ್ ಬೇರೆ ಸಿಟಿಜನ್ ಬೇರೆ ಇದನ್ನ ಮಾಡ್ಕೊತ ಹೋಗ್ಬೇಕಾ ಏನೋ? ಕೋರ್ಟ್ನಿಂದ ಕೋರ್ಟಿಗೆ ಒಂದು ರಿಟ್ ಅಪೀಲು, ಒಂದು SLP, ಆಮೇಲೆ ಒಂದು ಕಂಟೆಂಪ್ಟು, ಡ್ರಾಪಿಂಗು, ರಿವೈವಲ್ಲು, ಏನು ಹುಡುಗಾಟಿಗೆ ನಡೆಸಿದಾಗ ನಿಮ್ಮ ಆಫೀಸರ್ಸ್ ಎಲ್ಲ.
Further submit that in view of elaborate procedure involved in the act for completion of the final notification and passing the award, it requires a minimum period of 6 months. Hence, I undertake to complete the acquisition proceedings initiated in the matter within a period of 6 months from today. Since my lord, we completed, my lord, since
ಕಂಪ್ಲೀಟೆಡ್ ಅಂದ್ರೆ ಏನರ್ಥ? ಲ್ಯಾಂಡ್ ತಗೊಳ್ಳೋದು ಅಷ್ಟೇ ಅಲ್ಲ, ಅದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ ದುಡ್ಡು ಕೊಡಬೇಕು.
and since they have
ಕಾಂಪ್ರಿಹೆನ್ಸಿವ್ ಇದು ಸ್ಕೀಮ್.
my role, my lord, complete. I am only SLO, my lord. I have nothing to do in the only, my lord, acquisition proceedings, my lord. I have to initiate 4-1, and if they pay the, my lord, award amount, then only, my lord, I will pass the award.
Let us see. ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ?
It is there, my lord. They agreed to pay the amount. They have agreed to pay the, my lord, award amount. They have failed to pay the amount.
ಕೇಳಿ ಅವ್ರಿಗೆ, ನಾವು ಒಂದು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಮಾಡಿ ಕೇಳಿ ಅವ್ರಿಗೆ. ಮತ್ತು ಒಂದು ಬ್ಯಾಡ್ ಎಂಟ್ರಿ ಇನ್ ದ ಸರ್ವಿಸ್ ರೆಕಾರ್ಡ್. ಆಸ್ಕ್ ಯುವರ್ ಕಮಿಷನರ್.
He has taken.
Tell him.
Yes.
Do you understand English ಬರ್ತದಾ?
Yes.
ಬರ್ತದೆ. 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕಾಸ್ಟ್ ಹಾಕ್ಬೇಕು ಅಂತ ಮಾಡಿ ನೀವು ಕೈಯಿಂದ ಕೊಡಬೇಕು. ಪ್ಲಸ್ ಒಂದು 2 ಅಡ್ವರ್ಸ್ ಎಂಟ್ರಿ in your service register, so that you should not get promotion to the next level.
One request. He took charge. He was on last occasion as a incumbent officer. He was impleaded in the contempt, my lords, and he took the charge as a commissioner on June 2024. My lords. He was June 2024.
June ಎಷ್ಟು ತಿಂಗಳಾಗಿ? ನಾವು ನಿಮ್ಗೆ ತಾಜ್ ಮಹಲ್ ಕಟ್ಟಕ್ಕೆ ಹೇಳಿವಾ?
ಇಲ್ಲ.
ಇದಕ್ಕೆ ಲ್ಯಾಂಡ್ ತಗೊಂಡಿರಪ್ಪ, ದುಡ್ಡು ಕೊಡಿಸು ಅಂತ ಹೇಳಿದ್ವಿ ಅವರಿಗೆ.
ಹೌದು.
ಮತ್ತೆ
June 2024 he took charge, my lord.
ತಗೊಂಡು ಆಯ್ತಲ್ಲ.
I have one request is, insofar as cost, my lords, I request to reduce it. Insofar as
ನಾಳೆ ಅಫಿಡವಿಟ್ ಯಾಕೆ ಹಾಕಿದ್ರು?
ಇಲ್ಲ, insofar
ಆಫೀಸರ್ಸ್ ಅಫಿಡವಿಟ್ ಯಾಕೆ ಹಾಕಿದ್ರು? ಹೇಳ್ಬೇಕಿತ್ತು.
ಇಲ್ಲ,
ನಾವು ಅಫಿಡವಿಟ್ ಹಾಕೋಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಕಿತ್ತು ಮೇಲೆ.
He did not. ಇಲ್ಲ, he is not Rudresh.
He continues in his successor in office.
I understand.
He is successor in
insofar as I request this honorable court to reduce the cost.
ಎಷ್ಟು ಮಾಡೋಣ? ನೀವು ಹೇಳಿದಷ್ಟು ನಾವು ವಿಚಾರ ಮಾಡೋಣ. ಹೇಳಿ, ಒಂದು ರೀಸನೇಬಲ್ ಹೇಳಿ, ಕೇಳಿ ಅವರು ಎಷ್ಟು ಲಕ್ಷ ಕೊಡ್ತಾರೆ. ನಾವು 5 ಲಕ್ಷ ರೂಪಾಯಿ ಹಾಕ್ಬೇಕು ಅಂತ ಮಾಡಿದೀವಿ. ಎಷ್ಟು ಸರಿ ಅಡ್ಡಾಡ್ಬೇಕು ಇವರು ಇಲ್ಲಿಗೆ? ಕೋರ್ಟ್ ಅಂದ್ರೆ ಏನು ಅಷ್ಟೇನು ಖುಷಿ ವಿಷಯನ ಇದು? ಕೋರ್ಟಿಗೆ ಬರೋದು ಯಾರಾದ್ರೂ ಖುಷಿಯಿಂದ ನಕ್ಕೋತ್ ಬರೋದು ನೋಡಿದಿರಾ ನೀವು? Nobody comes to court with happiness. Inevitably they come, ಇದೇನಪ್ಪ ಇದು ಪೀಡಾ ಬಂತಿದ್ದು ಅನ್ಕೋತೇನೆ ಬರ್ತಾರೋ ಹೊರತು ಯಾರು ಖುಷಿಯಿಂದ ಕೋರ್ಟಿಗೆ ಬರಲ್ಲ. ಯಾಕಂದ್ರೆ ಕೋರ್ಟು ಇದು ಖುಷಿ ಕೊಡೋ ಸ್ಥಳ ಅಲ್ಲ, ಅಂತದಲ್ಲ. ಎಷ್ಟು ಸರಿ ಏನು there is a limit.
I understand.
ಮತ್ತೆ ನಮ್ಗೆ ಬೇಸರ ಬಂದದ್ದು ಎಷ್ಟು ಸರಿ ಟರ್ನ್ ಮಾಡೋದು ಪೇಜಸ್ ನಾವ್ ಇವ್ರದ್ದು.
On a lighter note,
ಹೇಳಿ ಎಷ್ಟು ಹಾಕ್ಬೇಕು ಹೇಳಿ. ಏನ್ ಲೈವ್ಲಿಹುಡ್?
Notes 50,000. 50,000.
ಎಷ್ಟು?
50,000.
50,000 ಹೆಂಗೆ ಎದಕ್ಕೆ ಬರ್ತದೆ 50,000? He is a senior advocate. How many times Mr. KL Patil has appeared? 50,000 ಏನ್ ಬರ್ತದೆ?
1 lakh. 1 lakh. And insofar as entry is, my lords, I request.
Entry ಬೇಕಾದ್ರೆ ಇದು 1 ಲಕ್ಷ ಬಿಡ್ತೇವೆ ನಾವು.
ಇಲ್ಲ, entry
ಪ್ರಮೋಷನ್ ಸಿಗಬಾರ್ದು. ಏನ ಅದರಿಂದನೇ ಇಫೆಕ್ಟ್ ಆಗದು.
ಇಲ್ಲ,
ದುಡ್ಡಲ್ಲಿ ಯಾರು ಗೊತ್ತಿದೆ ಎಲ್ಲಿಂದ
one request, my lords.
ನಮ್ಗೆ ನೋಡಿ, ನಾವು ಇಷ್ಟಕ್ಕ ಟ್ರೆಡಿಷನಲಿ
I understand.
ಒಂದು ಸಭ್ಯವಾಗಿ ನಾವು ಆದೇಶ ಮಾಡ್ತಾ ಇದ್ವಿ.
I understand.
ಕೋರ್ಟ್ ಈಗ ಸ್ವಲ್ಪ ದುಷ್ಟತನವನ್ನು ಮೆರೆಯಬೇಕಾಗಿದೆ. ಆ ಪರಿಸ್ಥಿತಿ
I understand, my lords.
ನಮ್ಮ ನ್ಯಾಯಾಲಯದ ಒಳ್ಳೆತನವನ್ನ ದುರುಪಯೋಗ ಮಾಡ್ಕೊಳ್ತಾ
Certainly
ಇದ್ದೀವಿ.
not.
ಅದರಿಂದ ನಾಗರಿಕನಿಗೆ ಬಹಳ ತೊಂದರೆ ಆಗ್ತಾ ಇದೆ. ನಾವು ಅದನ್ನ ಒಪ್ಪಲ್ಲ.
My lords, one
ಕಾಸ್ಟ್ ಕೊಡಬೇಕು, ಪ್ಲಸ್ ಅವ್ರಿಗೆ ಪ್ರಮೋಷನ್ ಸಿಗಬಾರ್ದು.
My lords, insofar as that is concerned, my lords.
ನೀವು ಚಾಲೆಂಜ್ ಮಾಡ್ರಿ. ಇಟ್ಸ್ ಎ ಗುಡ್ ಆರ್ಡರ್ ಫಾರ್ ಚಾಲೆಂಜ್ ಆಕ್ಚುಲಿ.
The reason is, my lord, he is also tried level because of there is a elected body council is there, my lord. Whatever the council decide, my lord, he is only.
They have resolved to pay deposit 20 lakhs.
20 crores
ಹೇಳಿದ್ರು.
20 crores
ರೆಸಲ್ಯೂಷನ್ ಆಗಿದೆ ಕಾರ್ಪೊರೇಷನ್ ಜನರಲ್ ಬಾಡಿ ಸ್ಪೆಷಲಿ ಅಂತ ಹೇಳಿದ್ರು.
ನೀವು ತೋಡಿ ಹೋಗಿ ನಿಮ್ದು ಎತ್ತು ಕತ್ತೆ ಎಲ್ಲ ಒಯ್ದು ನಿಲ್ಸಿ ಅಲ್ಲಿ ಆ ಲ್ಯಾಂಡ್ ನಲ್ಲಿ ಅವಾಗೇ ಬುದ್ಧಿ ಬರ್ತದೆ ಸರ್ಕಾರಕ್ಕೆ, ಇಲ್ಲಪ್ಪ ಅಂತ ಬರಲ್ಲ ಈಗ. ಈಗ ಅಂತ ಸಭ್ಯತೆ ಇರುವಂತ ಸರ್ಕಾರಗಳು ಅಧಿಕಾರಿಗಳು ಇಲ್ಲ. ನಾವು ಬಹಳ ಮನಸ್ಸಿಗೆ ಕೆಟ್ಟ ಅನ್ಸ್ಕೊಂಡಿದ್ ಹೇಳ್ತಾ ಇದೀವಿ. ನಾವ್ ಇಂಥ ಆರ್ಡರ್ ಎಂದೂ ಮಾಡ್ಲಿಲ್ಲ. ಈ 6 ತಾವೆಂದೂ ನೋಡ್ಲೂ ಇಲ್ಲ ಇಂಥ ಆರ್ಡರ್ಸ್ ಮಾಡಿದ್ದು. ಆದ್ರ ಪರಿಸ್ಥಿತಿ ಹಂಗಿದೆ, ಹಂಗಾಗಿ ಇಂಥ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ನೋಡಿ ಅಲ್ಲಿ ಎಷ್ಟು ಅಮೌಂಟ್ ಮತ್ತು ಎಂಟ್ರಿ ಬಗ್ಗೆ ನಾವು
ಇಲ್ಲ ಎಂಟ್ರಿ ಇಸ್ ಕನ್ಸರ್ನ್ ನೋಟ್ಸ್
ಕೆಲಸ ಆಗತ್ತೆ.
ಇಲ್ಲ ಐ ರಿಕ್ವೆಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್ ಎಂಟ್ರಿ ಇಸ್ ಇನ್ ಸೋ ಫಾರ್ as entry is concerned notes since he
ಆಯ್ತು ಇದನ್ನ ಹಂಗೆ ಇಡ್ತೇವೆ ಆರ್ಡರ್. ಇನ್ನ ಥರ್ಸ್ಡೇ ದಿವಸ ಅಮೌಂಟ್ ತರಕ್ ಆಗ್ತದಾ?
ಕಾಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ಸ್
ಕಾಸ್ಟ್ ಅಲ್ಲ, ಇದು ಎಂಟೈರ್ ಪೇಮೆಂಟ್ ಮಾಡೋದು. ಇದನ್ನ ಸಸ್ಪೆಂಡೆಡ್ ಅನಿಮೇಷನ್ ಆಗಿ ಇಡ್ತೀವಿ. ಥರ್ಸ್ಡೇ ದಿವಸ ಅಮೌಂಟ್ ತಗೊಂಡು ಅವ್ರ ಜಾಬ್ ನಲ್ಲಿ ಇಡ್ಬೇಕು.
ನೋಟ್ಸ್ ಅಮೌಂಟ್ ಇಟ್ ವುಡ್ ನಾಟ್ ಬಿ ಮೈ ಲಾರ್ಡ್ಸ್
ಆಗಲ್ಲ, ಅದು
ಅಮೌಂಟ್ ಆಗಲ್ಲ. that is there are several constraints my lords.
ಬಿಡಿ ನೀವು ನೋಡಿ, ನೀವು ನಮ್ಗೆ ನಮಸ್ಕಾರ ಮಾಡಿದ್ರೆ ಅಂಥವೆಲ್ಲ ನಾವು ಕೇಳಲ್ಲ. ನೀವು ನಾಗರಿಕನಿಗೆ ಆದಂತ ಅನ್ಯಾಯ ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು ಇವನು ಇವ ಕಂಪ್ಲೇನೆಂಟು ಬಾಬಾ ಸಾಹೇಬ್ ಎಷ್ಟು ಸರಿ ಬರ್ಬೇಕು, ಇದನ್ನ ಮಾಡ್ಕೊತ್ ಕೊಡ್ಬೇಕಾ?
Certainly not. I request my lords insofar as entry is concerned,
money spent by the government over this which they are returning now is in crores.
ಆಯ್ತು,
that has to be recovered against the concerned officers.
ಅವರನ್ನ ಪೊಸಿಷನ್ ಕೊಟ್ಟು ಮಹಾಜರ ಡ್ರಾ ಮಾಡಿ ನಿಮ್ಗೆ ಪೊಸಿಷನ್ ಕೊಟ್ಟಿವಿ ಅಂತ ಮಾಡ್ತೀರಾ? ಹಂಗ್ ಮಾಡಿದ್ರೆ ನಾ ಕಾಸ್ಟ್ ಹಾಕಲ್ಲ. ಎಸಿ ಡಿ6 ಎಸಿ ಅವರು ಎಸಿ ಮಾಡಂಗಿದ್ರೆ ನಾವ್ ಎಂಟ್ರಿ ಮಾಡಲ್ಲ. ಅಡ್ವಾನ್ಸ್ ಎಂಟ್ರಿ ಈಗ
ಎಸಿ
ನಾವು ಅಡ್ವಾನ್ಸ್ ಎಂಟ್ರಿ ಮಾಡೇ ಬಿಡ್ತೇವೆ.
ಎಸಿ ಅಂಡ್ ಮೈ ಲಾರ್ಡ್ಸ್
ಈಗ ಕಾರ್ಪೊರೇಷನ್ ಇಬ್ರು ಸೇರ್ಕೊಂಡು ಅವ್ರನ್ನ ಗೌರವಯುತವಾಗಿ ಕರ್ಕೊಂಡು ಹೋಗಿ ಅಲ್ಲಿ ಅವ್ರನ್ನ ಸ್ಥಾಪನೆ ಮಾಡ್ಬೇಕು ಆ ಜಗದಲ್ಲಿ.
ಸ್ಮಾರ್ಟ್ ಸಿಟಿ ಇನ್ಫ್ಯಾಕ್ಟ್ ಸ್ಮಾರ್ಟ್ ಸಿಟಿ ಇಲ್ಲ ಇಲ್ಲ ಅವರು ಪಾರ್ಟಿ ಇದಾರೆ. ಇಟ್ ಮೇ ಬಿ ಡೈರೆಕ್ಟ್
ಅವರು ಇದ್ದಾರಲ್ಲ, ಈಗ
ಅವರು ಇದಾರೆ,
ಅವರು ಮಾಡಿ ಈಗ ಅದಕ್ಕೆ ಅಂತ ಆರ್ಡರ್ ಮಾಡಿವಿ. What action should be taken against the officers who have sworn to this affidavit is not considered in this matter. However, would be considered in an other appropriate matter if and when it is brought before us. All right. ಅವ್ರನ್ನ ಅಲ್ಲಿ ಪೊಸಿಷನ್ ಕೊಟ್ಟು ಬರ್ಬೇಕು, ನೀವು ಹೋಗ್ಬೇಕು ಜೊತೆಗೆ. ಅದನ್ನ ಒಪ್ಪಿದ್ರೆ ಮತ್ತೆ ಈ ರೀತಿ, ಇಲ್ಲಪ್ಪ ಅಂದ್ರೆ ಕಾಸ್ಟು ಎಂಟ್ರಿ ಅಡ್ವಾನ್ಸ್ ಎಂಟ್ರಿ ಎರಡು
ಮೇಸಿಕೊಂಡು ಮಂಡೇ ಮಂಡೇ
ಅದಕ್ಕೆ
ಅಂದ್ರೆ ವಾಟ್ ಹಸ್ ಹ್ಯಾಪನ್, ನಾಳೆ ನಾಡಿದ್ದು ಎಲ್ಲ ಗಣಪತಿ ವಿಸರ್ಜನೆ ಇದೆ. ದೀಸ್ ಪೀಪಲ್ ಹ್ಯಾವ್ ಟು ಟೇಕ್ ಕೇರ್ ಆಫ್ ದಿ ಥಿಂಗ್ಸ್ ದೇರ್. ಅದಕ್ಕೆ ಒಂದ್ 2-3 ದಿನ ಟೈಮ್. ದಟ್ ಈಸ್ ವೈ
ಇದನ್ನ ಹಂಗೆ ಒಂದು ಟೈಪ್ ಮಾಡಿಡು. ಮಂಡೇ ಕರಿ ಮಂಡೇ ದಿವಸ
one more request only my lord.
ಅಲ್ಲ ಅಲ್ಲಿ ಗಣಪತಿ ಇದು
ಅದ್ ಮಾಡಿ ಸರ್, ಅದ್ರ ಬಗ್ಗೆ I have no objection. ಎಲ್ಲ ಆರ್ಡರ್ intact ಇರಲಿ. Public money which they have spent on this project illegally by smart city officers, ಈಗ they give back, we are taking our property is intact. Public money ನಮ್ದೆಲ್ಲ ಹೋಗಿದ್ದು nearly in crores is being wasted. ಅದಕ್ಕೆ government has to take action against them.
ಈಗ ಮಂಡೇ ಬರಲಿ, ಮಂಡೇ ಸಬ್ಮಿಷನ್ ಮಾಡಿ.
Yes
ಪ್ಲೀಸ್ ಈ ಆರ್ಡರ್ ಅನ್ನ ಹಂಗೆ ಟೈಪ್ ಮಾಡಿ ಸೈನ್ ಮಾಡೋದು.
This is the matter, my lord, where we had moved an application to transpose and then it was subsequently withdrawn. But we are the beneficiary of the acquisition. Although, my lord, I think in all fairness, we must correct ourselves. One mistake which I think last time we made was in saying that our name is there in the notification.
Your name is there.
It is not there. Illa. It's not there.
ನಿಮ್ಮ ಹೆಸರಿಲ್ಲ ಅದರಲ್ಲಿ.
That I think last time, my lord, Viresh made a submission that it was there, but it is not there.
But you can argue, since you are a party, you can argue as the respondent, argue. We'll hear you.
Yes.
Why you want to be on the appellate side? Because other day Archana madam said, you are not a beneficiary at all. ಅದು ಮಾಡ್ಲಿಕ್ಕೆ ಬರಲ್ಲ, ಬೇರೆ ಪ್ರಾಬ್ಲಮ್ ಆಗ್ತದೆ. ಈ ಕೇಸ್ನಲ್ಲಿ ಬೆನಿಫಿಷರಿ ಅಂತ ಮಾಡಿದ್ರೆ ಬೇರೆ ಯಾರಾದ್ರು ಒಂದು 50,000 ಜನರಿಗೆ ಸೈಟ್ ಕೊಟ್ಟಿರ್ತಾರೆ, 50,000 ಜನ ಬರ್ತಾರೆ ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು. ಕಾನ್ಸಿಕ್ವೆನ್ಸ್ ಇದೆ, ಇಂಪಲ್ ಇಲ್ಲ. ಬಟ್ ಯು ಆರ್ ಎಂಟೈಟಲ್ ಟು ಬಿ ಹರ್ಡ್ ಇನ್ ದ ಮ್ಯಾಟರ್.
Yes, yes.
ಹೇಳಿ, ಸ್ಟಾರ್ಟ್.
Lord, if your lordship looks at the order, this is 18 reference.
18 reference.
The reference court note rejects the entire evidence and says no material has been placed before the court of any value to determine the market value of the property.
Where is that point?
Yes, lordship may kindly take.
ಇದ್ರಾಗೆ ಡಿಲೇ ಗಿಲೆ ಕಂಡೋನೆಲ್ಲ ಆಗಿದೆಯಾ?
Your Lordship,
Yes.
in this case, the appellant KIDB has filed applications for amendment, my lord. That copy has not been served on.
All right, argue ಮಾಡಿ.
Ad
ಅದನ್ನ ಅಮೆಂಡ್ಮೆಂಟ್ ಇಗ್ನೋರ್ ಮಾಡ್ರಿ, ಆರ್ಗ್ಯೂ ಮಾಡಿ.
Ad
No time will be granted. Yes.
No, my lord, that amend.
Start.
Lordship may kindly come to page 151. 151. That reasons start there. One common judgment. Paul, as a matter of fact, not what the learned judge does.
Yes, which is that finding?
My Lordship, may, from 151 onwards, the finding starts. I won't read everything. Please come straight away to 193.
193.
193. At para 42. And this is the conclusion that the learned judge draws. It is pertinent to note here, my lord, has that para 42.
Yes.
It is pertinent to note here that the claimant's petition did not produce any evidence before the court to establish the exact market value of the acquired lands on the basis on which the compensation can be enhanced under except Exhibit P27 and P28. As I've already discussed about, without there being examination of either vendee or the vendor, contents of P27 and 28 cannot be accepted as genuine. More particularly in the background of the description of the alienations referred to by the LAO in Exhibit P1 to P3 on the basis of the report. Except the entry at column number 12(9) of the extract, nothing has been forthcoming before the court to come to a conclusion that the acquired land is a fertile land. It has been mentioned by the competent authority regarding cultivation of sunflower, chili, jawar, spice, etc. in the acquired lands in turn, which shows regarding the existence of some source of water in the acquired lands. It is also pertinent to note lands were acquired for the purpose of establishing industry. During the course of argument, learned counsel respondent vehemently argued 80% of beneficiaries have accepted the award passed by LAO. Award appeared passed by LAO presumed to be genuine. But on the other hand, counsel has addressed the argument. Some of the beneficiaries have preferred a writ petition before High Court of Karnataka, Dharwad. Mere preferring writ petition does not suffice to prove award passed by LAO is not genuine. Per contra, argument advanced by counsel respondent number 2 is not suffice that there is a bar to file petition by claimants, those who have not agreed to the award passed by LAO. Therefore, the argument addressed that both sides hold no water. I've gone through various decisions of Honorable Supreme Court of India cited by the learned counsel. The claimants do not fulfill any of the factors laid down by Honorable Supreme Court in the above decisions to determine the market value of acquired land on the comparable sales method of valuation of land. Hence, the above cited decisions are not helpful to case of petition of claimants, considering the above morphological features, potentiality of acquired land to grow sunflower, masala, chili, jawar, which establish some source of water in respect to acquired land. Also, on the basis of above discussed evidence in the absence of proof to consider P27 28. I am of the view, if the compensation awarded by the LAO is enhanced by adding 5 lakhs per acre to the compensation already awarded, it would meet the ends of justice. Hence, compensation awarded by LAO is enhanced for lands fixed at 5 lakhs to 10 lakhs per acre, 6 lakhs to 11 lakhs per acre, 8 lakhs to 13 lakhs per acre. It would meet the ends of justice. Appears to be appropriate. This was corrected.
What is that?
This was then corrected, my lord, because the original award was 1,50,000, 1,80,000, and 2,15,000. Then a review was filed, and this judgment was corrected.
Adeli the order.
That order, my lord, is along with the amendment application, which I think KIDB has filed.
ಈ ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಅಮೌಂಟಿಗೆ 5 ಲಕ್ಷಕ್ಕೆ 1.5 ಲಕ್ಷ ಅಂತ ಹೋದಕ್ಕ
1.5 ಲಕ್ಷ, correct.
Come to page 195 bottom, rock bottom.
195, yes, my lord.
This
it is a gratuitous
5 lakhs.
Yes.
5 lakhs ಗೆ 1.5 ಲಕ್ಷ.
5 lakhs ಗೆ 1.5 ಲಕ್ಷ.
1.5
ಇಲ್ಲ, ಎಲ್ಲದಕ್ಕೂ 5 lakhs across the board.
No. The award made by the SLAO
was 1.5.
1.5 in all matters?
No,
1.5
per lakhs per acre in one case. 2.3 lakhs per acre in another case. Where's the correct? 2.31 lakhs per acre.
ಅದು 6 ಲಕ್ಷ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಅದ
ಅದಕ್ಕೆ ಅವರು
ಕರೆಸ್ಪಾಂಡಿಂಗ್ ಹೇಳಬೇಕು.
ಹೌದು. This, your lordship may not look at this. Actually, look at the review order, my lord, where the correction has been made.
ಅಲ್ಲ, ಈಗ P27, P28 ಕಾಲಮ್ 12 ಅದರಲ್ಲಿ ಏನಾದರೂ ಮಟೀರಿಯಲ್ ಇದ್ದು ಕೊಟ್ಟಿದ್ರೆ
ಇಲ್ಲ, that's just the entry in the revenue.
ತೋರಿಸಿ ನಮಗೆ 12(9) ಕಾಲಮ್
27 and 20. I'm sorry,
ಹಂಗೆ ಹೆಂಗ್ ಕೊಡ್ತಾರೆ? ಏನೋ ನೋಡ್ಕೊಂಡು ಕೊಟ್ಟಿರ್ತಾರ. ತೋರಿಸಿ ನಮ್ಗೆ.
give me the document.
How he will award without basis, any basis? There will be something.
No, there is none.
ಕೊಡಿ.
P27 and 28 he rejects.
Huh?
P27 and 28 he rejects as there being no evidence. Please see this, my lord. He can't consider P27 and 28. He says in the absence of proof to consider P27 and 28.
ಏನು ಅಂತ?
So two sale deeds, my lord, which are there.
ನೋಡೋಣ ಅವೇನು ಹೇಳ್ತಾವ ಅಂತ. ಏನು ಇಲ್ದಂಗೆ ಹೆಂಗ್ ಕೊಡ್ತಾನೆ? ಏನೋ ಒಂದು ಕಾರಣ ಇದ್ದೇ ಇರ್ತದೆ. You give that 27, 28 ಕೊಡಿ.
Volume, please. Good. 132, the volume, sir.
132.
132.
ಅವ್ರು ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದು.
They produced it. We said, my lord, without the vendors or the vendee coming before the court, it can't be a document relied upon. And it is a document seems to have been come into existence.
ಆ ಬೇರೆಯವರಿಗೆ ಏನ್ ಮಾಡಿದಿರಿ ನೀವು?
ಬೇರೆಯವರಿಗೆ the 88% of all landowners did consent award, took 5 lakhs all inclusive per acre.
5 lakhs.
5 lakhs per acre all inclusive, including solatium, interest and all.
ಇದ್ರಾಗ ಎಷ್ಟಾಗ್ತದೆ?
In this becomes not 20 lakhs.
ಎಷ್ಟು ಜನ ಅವರು ಅದನ್ನ ಕನ್ಸೆಂಟ್ ಅವಾರ್ಡ್ ಅಕ್ಸೆಪ್ಟ್ ಮಾಡಿದ್ರು? ಎಷ್ಟು?
88% of the total landowners.
ಎಷ್ಟು?
That totally
950 acres. Out of that 88% agree.
Extent ಎಷ್ಟು?
ತೋರಿಸಿ ನೋಡೋಣ.
About 500.
P27, P28 ಕೊಡಿ ನಮಗೆ.
Yes, P27 is a sale deed. Please see the date of the sale deed. P27.
Preliminary date ಏನು?
The preliminary notification.
2010. ಇದು ಫೆಬ್ರವರಿ 2010 ಇದೆ.
ಹೌದು.
ಏನಿದು ಎಕ್ಸ್ಟೆಂಟ್ ಎಷ್ಟಿದೆ?
One most important thing is 134. It says the payment was made only in cash. This sale deed seems to have not come into existence for a particular reason. Please see page 134, third line. 134. Your lordship is at 132, P27.
ನಗದು ತೆಗೆದುಕೊಂಡು.
ನಾನು ನಗದು ತೆಗೆದುಕೊಂಡು ವಿಕ್ರಯಿಸಿದ ಶೆಡ್ಯೂಲ್ ಆಸ್ತಿಯನ್ನು ಇಂದಿನಿಂದ ನೀವು ನಿಮ್ಮ ವಾರಸುದಾರರು
ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ ಆ ಡೇಟಿಗೆ?
Guideline value is not on the basis of the general award.
Exhibit P21.
Whichever is more.
One acre land. P27 is 1 acre land.
1 acre of land. 25 lakhs.
ಅಲ್ಲ ಅದಾಯ್ತು. ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಏನಿದೆ?
Exhibit P21. ಅವ್ರು ಕಂಪೈಲೇಷನ್ ಕೊಟ್ಟಿಲ್ಲ.
P21
P21.
ಅದೇ ನನ್ನ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ Exhibit P21.
ಬೇಸ್ ನಂಬರ್ P21 ಎಷ್ಟ್ರಿ?
Page 90. Yes.
25/2011.
These are lies. This is not.
Compilation has not been given.
Allah, 21 I have. Exhibit P21 is the same document. Page 90, but that is
90. ಇದನ್ನ ತೆಗಿರಿ, ನಿಮ್ ಗೂಗಲ್ ನಲ್ಲಿ ತೆಗಿರಿ, ಆ ಡೇಟ್ ಆ ಇಯರ್ ಗೈಡ್ಲೈನ್ ವ್ಯಾಲ್ಯೂ ಕೊಡಿ. ಎಲ್ಲ ಇದೆ ನೋಡಿ.
Pass on this. This is the guideline which has been given for Mittal company.
Not for Mittal, guideline values.
Irrespective of 2009 and 10 notification, 2009 and 10 for NA land.
Non-agricultural.
Mine is NA potential land.
1,40,000. ಕುಡುತಿನಿ ಗ್ರಾಮನ?
Kurtini, Veni Virapur, all adjoining lands.
Yeah, which is she showing? I'm not have it here. P21 she's
ಇವ ಮಾಡಿಕೊಂಡ.
Acquisition index.
856 ಇದೆ. 910
Now, salary, your salary consider 1.5.
This is award.
Adralli,
What is this document?
That is ಮೇಲ್ ನೊಂದಣಿ ಅಧಿಕಾರಿ.
ಅಧಿಕಾರಿ ಬಿಟ್ಬಿಡಿ ಅವ್ರೇನೋ ಬರ್ಕೊಳ್ಳಿ. What is the document you are showing?
Your lordship.
It is award only.
It is award.
ಭೂಸ್ವಾಧೀನ ಅಧಿಕಾರಿಗಳ so award.
You want,
Your lordship.
Even award ನಲ್ಲಿ 1,72,000 ರೂಪಾಯಿ ಇದೆ.
How can it later do, but they produce?
At exhibit P 179,
the-
that is the judgment which is produced by me before the reference court,
Relating to this land only.
adjoining lands of Kurtini village, wherein my lord 4,000 acres of land has been acquired for the purpose of Mittal.
I exhibit in
179, just 3 months prior notification.
That is the guideline market value, I have it here. Man. I have it here.
ಎಲ್ಲಿದೆ?
It is signed by.
ಅದ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಂತ ಹೇಳ್ತಾರಲ್ಲ ಮತ್ತೀಗ ಅವರು.
No, that judgment, my lord, is also an order by the reference court. In the case, my lord, of Mittal. Now, what happened?
Court.
Same court. They fixed a particular rate. The beneficiary did not challenge it. And therefore, my lord, they are referring to it. Now, what happened was the challenge was in a writ petition.
ಇದು ಗವರ್ಮೆಂಟ್ ಕೊಟ್ಟಿದ್ದು.
This is given to us. Yes.
exhibit mark ಆಗಿದೆ.
It's marked ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ. We have got it off late, my lords. It has not been marked, my lords. But
75,000 ರೂಪಾಯಿ ಇದೆಯಾ? ಅದೇಂಗ್ರಿ?
It is dated. It, of course, not, it depends on the location, and depending on the location, the amounts vary.
Government statistics.
this was not like the exhibit and run by this.
ಎಕ್ಸಿಬಿಟ್ P 27, 28 ಮತ್ತು ಕಾಲಮ್ 12, 9 ಅಂತ ಹೇಳ್ತಾರಲ್ಲ, ಏನದು? ಅದರಿಂದ ಏನು ವಾಟ್?
P 27 and 28 are two sale deeds, which, my lord, have come into existence. And we believe, my lord, it was only for the purpose of creating some market value for it, for the land at that point in time. Because no, it's all paid in cash. Therefore, no one knows whether there's a. Yes.
ಅಲ್ಲಿ 25 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ರ ಒಂದ್ ಎಕರೆಗೆ.
It seems not incredulous because there's no other sale deed other than these two around that time which comes into existence. And the vendor went in, no one comes.
Another one is 30,000, that is small extent.
There is a small extent of land. That is also paid in cash. Page 140. Now Nagudu Tegidukondu.
ಅವ್ರದ್ದು ನಗದ?
ಹೌದು ನಗದೆ. ಯಾರು? These sale deeds seem to have been not by someone very smart who knew that this issue will arise with respect to compensation.
30,000 ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟಿಗೆ ಎಷ್ಟಿದೆ?
ಇದು
ಈ 30,000 ಎಷ್ಟು ಎಕ್ಸ್ಟೆಂಟಿಗೆ?
It's a plot, 1,245 square feet.
1,245
square feet.
ಇದನ್ನ ಮಾಡಿ ಇದೇನ ಸೈಟ್
30 lakhs.
Developed plot.
Developed plot.
Developed plot.
In the layout.
Actually, 1,245 into is 1,245 divided 30,000 divided by 1,245 into 44, 350. I'm just giving the calculation so that I can tell you how much it is per acre then.
43,000.
43,000.
ಅದರಲ್ಲಿ 55% ಮಾತ್ರ ಸೈಟ್ ಆಗ್ತದೆ.
ಹೌದು.
ಆ 55% ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ? 43,350 1 ಎಕರೆನ ಆಗ್ತದೆ. 43,350 approximately that way. ಅದರಲ್ಲಿ as the law now stands 55% is the maximum land that can be utilized for formation of site.
30,000 divided by 1,284.
30 lakh.
So it is 25 rupees per square foot.
Plus, plus. 1089 square feet is 1 gunta.
One
33 into 33 is 1 gunta.
1 gunta.
1089 plus the 100 odd.
30,000 into 40. 12 lakhs. If you take it for the entire extent.
Entire extent.
11 ಲಕ್ಷ ಆಗ್ತದೆ.
ಎನ್ನಿ. ಇದು ಎನ್ನೆ ಆಗಿದ್ದ?
ಇಲ್ಲ ಇಲ್ಲ.
ಈ ಸೈಟ್.
They all
ಎನ್ನೆ
NA potential lands.
ಅಲ್ಲ ಈ ಸೇಲ್ ಡೀಡ್.
But the second sale is for a developed plot, my lords. Mediation.
That's what.
Is it converted?
It's a
Is it
layout.
converted? Convert ಆಗಿರೋ ಏನು details ಇಲ್ಲ.
142 page number, my lords, schedule, my lords.
Then it will come to 5 lakhs, not actually.
NA or the survey.
If this is the correct value, for it will be about 11 lakhs for the entire acre. 55% of that will be about 5 lakhs, 5.5 lakhs.
For NA land.
For any land, for converted developed land.
Per acre ಎಷ್ಟು ಬರ್ತಾ ಇದೆ?
I did a calculation, 1089 1 gunta. So I took that plot as the value, 30,000 rupees for 1 gunta of, into 40 is 12 lakhs. So about 6 lakhs.
ಅಲ್ಲ 1 gunta. 1 gunta plus ಇದೆ.
I'm just saying, approximation,
on an
approximation, coming as close as possible. It's converted, developed, which means there's actually cost spent on development, and then taking at least 50% loan. It is
P28, P29 either.
P28 and P29, 27 and 28. Those only two.
728.
Yes.
132. Page number 132.
ಇಲ್ಲ ಇದು ಇನ್ನೊಂದು ಎಂಟ್ರಿ ಎಲ್ಲಿದೆ?
23.
ಅದು ಇನ್ನೊಂದು ನಗದು ಅಂತಾನೆ ಇದೆಯಾ?
ಅದು ನಗದು. That entry to show source of water ಅಂತ ಇದೆಯಲ್ಲ. Morphological feature. Except entry department number 12.9 of RTC extracts.
ನಗದು ತೆಗೆದುಕೊಂಡು. 140.
Consent is always a different scheme. 29A के area है. There you are given everything, stated and interest. You are not selling any creation that undertaking or giving. There is an extra amount is an issue. Sole basis. Sir, crores.
ಕೇಳ್ತಾರಿಲ್ಲ.
ನೋಡೋಣ.
What is happening there? ಆಯ್ತು ಅವ್ರು ನಮ್ಗೆ
The 12.9 ತೋರಿಸಿ ಏನು why he said 12.9?
12.9 to show, my lord, that there is some source of water apparently. There's nothing else. There's no valuation. In the RTC extract, he looks at the 12 entry column 12 and says there seems to be some indication there's some source of water.
ತೋರಿಸಿ ನಮಗೆ ತೋರಿಸಿ.
That my lord will find entry is at P140. This is a complete guesswork, my lord. There's nothing in this. P140 at page 541. Entry 12. Where is he was pointing on an artifact that mask.
ಖುಷ್ಕಿ ಅಂದ್ರೆ ಡ್ರೈ ಲ್ಯಾಂಡ್ ಅನ್ನು.
Dry. Kushki is dry. Kushki is dry. I don't know, my lord, where that entry the learned judge has found.
ಅದು ಯಾವುದೋ ಒಂದು ಅವಾರ್ಡ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
Now that award, my lord, was in the case of ArcelorMittal.
ಅದನ್ನೆಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾನೆ?
There's no reference to it in the
No
order.
reference at
There's no
all.
reference. As a matter of fact, now they're pointing it out, saying there is all that has become final. The reason it became final, my lord, was an interesting scenario. The award was not challenged from the reference code.
But that becomes one factor ಆಗ್ತದೆ.
One factor, my lord. But then, so far as I am concerned, I am still entitled to show that that order is also not right. Because in my case, I am there. In someone else's case, my lord, I can't demonstrate that it is right or wrong. Had it been upheld by this honorable court, on that principle, it was different. But what happened was, the ArcelorMittal, my lord, did not challenge it despite being a beneficiary. A writ petition came to be filed by KIDB saying, I was not made a party in the reference proceedings and therefore you must set aside. It was set aside. Matter went to Supreme Court. Supreme Court said when ArcelorMittal, who shown as a beneficiary, did not challenge it, why should the KIDB challenge, CEO of KIDB challenge it, and therefore dismiss that writ petition. And therefore, my lord, the order attained finality because no one challenged it. But ultimately, it's an order of the reference court itself.
It is not part of the record?
That is not part of the record.
Not part of.
Not part of the record.
179 itself is
Exhibit.
exhibited.
Sorry, which one?
Exhibit?
179.
170.
171.
179.
Aslam.
And today I have produced the order of the Honorable Apex Court arising out of this exhibit 179.
Yeah, sorry, I'm sorry. 644.
Very same accusation.
On this judgment, my lord,
Sit down. Why are you troubling her? Yes.
claimant, on the basis of the judgment of exhibit 179, there was an appeal before this honorable court.
Give me the order. Supreme Court order.
ಅಲ್ಲ ನೀವು ಯಾವುದೋ ಒಂದು
Exhibit
award ಆಗಿದೆ
one.
ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. Which award it is?
Exhibit 179, that is your lordship, I'll demonstrate the judgment of that. Your lordship, that land has been acquired on 5/2/2010. Just 3 months prior to my land acquired, my lord.
ಅದೊಂದು ಇದನ್ನ ಕಾಪಿ ಕೊಡಿ. ಇದರಲ್ಲಿ ಇದೆಯಾ?
Please.
ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ರೆ ನೀವು.
Yes, it's there.
Page number?
It's there. It's at page 644. 644.
ಯಾವುದು ರಿಲೆವೆಂಟ್ ಪಾರ್ಟ್ ಇಲ್ಲಿ?
Relevant part, my lord. Your lordship, before that, my lord, the one which I have produced that time, that exhibit P21, that has been stated at page number 50, my lord. Page number 50, 50, of the
ಅಲ್ಲ ಇದ್ರದ್ದು
interpage.
ಧ್ಯಾನ ಇದ್ರದ್ದು ಎಲ್ಲಿದೆ? ವ್ಯಾಲ್ಯೂಯೇಷನ್ ಇದೆ ಇದರಲ್ಲಿ? ರೀಸನ್ಸ್ ಹೇಳಿ.
In which one? Sorry.
Exhibit 644, you said it was not part of the record. Now they are showing that it is part of the record.
Yes. Yes.
It is part of the record.
It is part of the record. Yes, I made a mistake.
What it says, show that.
Yes, no. Please come to page 692.
692.
Para 30. Something about this sale deed as well. 2 lakhs, 25 lakhs. This is also a mistake.
692.
Page 692.
Paragraph 29.
Para 30. The court had considered the sale deed of 1 acre for 2,50,000. I think it is 25 lakhs.
It's 25 lakh.
From Annapurna, but the claimants have not chosen to examine either the vendee or vendor. It is actually 25 lakhs, not 2,50,000.
Huh? 2,50,000 is it?
I'll barridare, but actually it's that same sale deed. The sale deed which I showed you lordships for 25 lakhs, that same sale deed was exhibited in the other case. 25 lakhs.
This is 25 lakhs.
25 lakhs. 25
Same sale deed which you have shown to me.
Which I showed you
You
lordship.
have seen, na?
Further.
Therefore, as per principles laid on aforesaid decision, considering the circumstances of the, I'm sorry.
Reasons for this.
Really,
Your Lordship.
ultimately, my lord.
Subsequent.
707.
707.
Page number 51, interpage 51.
707, page number 64, line 4, please, my lord. The only document that is relied upon is P13. 707, please.
Page 51 bani.
Yes.
Come to 51.
Yes.
Internal page 51.
Yes, I have it.
Table is given. Idna you produce ಮಾಡಿದಾಗಲೇ.
Ida.
Which you had given.
Please, Milo.
Read that.
Kuditini Jaminu 7888,000, 89 1,66,000, 910 172.
Correct. 78, 89, 910.
Yes.
ಮೂರು ಅಂತ ತಗೊಂಡಾರೆ 910 ಗೆ 1,72,856 ಇದೆ.
Correct.
That is agriculture.
Yes.
This is a yours is 2010 acquisition.
2010.
February acquisition. Same bರ್ತದೆ.
May.
Prepare the average value of the property for the year 7, 8, 8, 9 to 10, considering the sale date of 3 years and so on. So he has considered that aspect.
Arrived at 1,42,000.
1,42,458.
But how he makes that correct average? But how he makes it to find that?
ಇಲ್ಲಿ ನೋಡೋದು 30 ಲಕ್ಷ ಮಾಡಿದ್ದಾರೆ ಇದು ಕನ್ಸಿಡರ್ ಮಾಡ್ತಾರೆ ಮಿತ್ತಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಸರ್ 30 lakhs ಮಾಡಿದ್ದಾರೆ to save lives on this how then say 1,42,000 30 lakhs how it has
NA land has been treated, this land is an agriculture land wherein to consider it as NA potentiality, NA land will be considered and deduction will be made towards development charges. Here, my lord, in this case, considering NA potential land, NA land document has been considered and 40% has been deducted.
In this order, they take
That
it
is
as
the observation made at para 56, 57.
Yes.
the finding, my lord, is at page 725, para 57.
25.
725.
Para 57.
57. To sum up, this court has not accepted the method of determination of market value by special land acquisition officer. Court is unable to accept the belting system followed by special land acquisition officer by awarding compensation. Compensation awarded is against the documents. It is inadequate, unfair. It is the considered view of this court of getting fair and adequate compensation to the constitutional right of the claimants. At the same time, vendors may have sentimental value in excess of its market value. Compensation must not be awarded by reasons such considered. Vendors be treated as a vendor willing to sell at a market price. Therefore, it may be appropriate and expedient to award compensation at the rate of 50 lakhs with 40% deduction. And therefore, they arrived at 30 lakhs 20,000 with statutory benefits as contribution. They consider it non-agricultural land.
in this case it is not
It is agricultural land.
it is
Agriculture.
Agricultural land actually is dry land. There are,
irrigation because total reference
they said there's some reference there, therefore I'm considering it there.
ಆಗಲ್ಲ ಅದು.
But ultimately,
Schedule 1 of land reforms act ಬರಬೇಕು. ಅಲ್ಲಿ A, B, C, D ಇದೆಲ್ಲ ಅಲ್ಲಿ ತಗೊಂಡ್ಬರ್ಬೇಕು.
Correct. Now, Lord, please see the scenario which the court has created. It has not accepted this order. It has not accepted this order as correct. That is, the order in the ArcelorMittal case has not been accepted. Though it has been exhibited, it said, I will determine it independently. Court simply says on whatever the land acquisition officer determined as compensation, I'll add 5 lakhs to it. Now, that is not a method of determining market value.
ಅವರಿಗೆಲ್ಲ ಎಷ್ಟು ಕೊಟ್ರಿ ನೀವು ಬೇರೆ
The 88%, which is about 4,000 acres of land, 3,000 acres of land, were paid 5 lakhs per acre overall.
ಈಗ ಸಪೋಸ್ ನೀವು ಹೇಳಿದ ಪ್ರಕಾರ ಮಾಡಿದ್ರೆ ಇದನ್ನ ಸೊಲೇಶಿಯಂ ಎಲ್ಲ ಸೇರಿ ಎಷ್ಟಾಗ್ತದೆ?
ಅದೇ ಎಲ್ಲ ಸೇರಿ ಸೊಲ್ಯೂಷನ್ ಎಲ್ಲ ಸೇರಿ 5 lakhs per acre.
ಅದು ಅವ್ರಿಗೆ ಆಯ್ತು.
ಹಾ
ಈಗ ನಿಮ್ ಕಂಟೆನ್ಷನ್ ನಾವು ಒಪ್ಪಿದ್ವಿ ಅಂದ್ರೆ
ಕರೆಕ್ಟ್.
ಇವ್ರಿಗೆ ಎಷ್ಟು ಸಿಗ್ತದೆ?
Each one my lord gets about 20 lakhs an acre.
20 lakhs.
20 lakhs an acre, which makes it varies my lord. It varies from 25
Depending upon that.
on that because interest at 15%, solution of 30% on it. Therefore, everything adds on to make it about 25 to 30 lakhs per acre. So 5 on the one hand, my lord, and 25 to 30 on the other is going to make this entire project itself unviable.
Correct. ಅವ್ರು ಬರ್ಲಿದ್ರೆ ನಾನೇನ್ ಮಾಡೋಣ? ಪಾಪ ಇವ್ರು
ಅಲ್ಲ.
If they do not come to court and if they enter into such, why these people should be deprived?
No, I'm not saying that. I'm saying, Lord, if they are entitled to it, then it's a matter of evidence and proof. They have to prove the market value of the property.
5 lakhs ಫಿಕ್ಸ್ ಮಾಡಿದ್ರಲ್ಲ, ಅದೇನು ಯಾವ ನಾರ್ಮ್ಸ್ ಇಟ್ಕೊಂಡು ಮಾಡಿದ್ರಿ?
It was consent. It was the agreement.
What consent?
Average sale deeds. Average sale deeds.
Average sale.
They got the transaction sale deeds, my lord, and then they sell it at fast.
No, we are really speaking of about 11.5% of people, half of whom are before this court now. The other half is still pending in the reference court.
ನಿಮ್ದಾಯ್ತಲ್ಲ, ನಾಳೆ ಮಾಡಿ ಸುಮಾರು.
Shall I come online? I'll come online.
ಅಲ್ಲ, ಈಗ ಏನೋ ಒಂದು ಲ್ಯಾಂಡ್ ಎಕ್ವಿಷನ್ ಆಫೀಸರ್ ಒಂದು ಕ್ಯಾಲ್ಕುಲೇಷನ್ ಇಟ್ಕೊಂಡು ಮಾಡ್ತಾನೆ. ತೀರಾ ಇರೇಟಿಕ್ ಅಂತ ಹೆಂಗ್ ಹೇಳೋದು ನಾವು? ಹಂಗೆ ಹೇಳಕ್ ಬರ್ತದ?
Well, this order, my lord, in my humble submission is there's no basis for fixing 5 lakhs over everything. That can't be. Maybe, my lord, it is 30, maybe it's 25.
ಹುಬ್ಳಿದ ಏರ್ಪೋರ್ಟ್ ಅನ್ನೋದು
one of the case, Kumar Patil has appeared, he was telling that consent award is also one of the basis to.
One of the factors,
provided shouldn't be below that.
On normative, it cannot be below
Can't
that.
be below that.
If it is acted upon on some normative basis itಗೊಂಡು fix ಮಾಡಿದ್ರು ಅಂದ್ರೆ that becomes a relevant
Yes,
factor.
as a matter of fact, I think one judgment of the Supreme Court also says that if more than 50% have accepted the award as correct, then that becomes one principle on which to go.
Factor. But ಅವ್ರು ಹೇಳ್ತಾರೆ, ಅವರು ಒಪ್ಕೊಂಡ್ರೆ ನಾನೇನ್ ಮಾಡ್ಲಿ, ನನ್ನ ಲ್ಯಾಂಡಿಗೆ ಕೊಡಿ ಅಂತ.
That I agree with. But I'm saying if the court rejects every single contention and simply adds 5 lakhs.
May I request it or day after tomorrow, Manu?
Day after tomorrow ಕೊಡಿ.
And file the synopsis to that extent.
They are not, sir. They are
You
not.
have to serve the copy also.
Please, kindly.
ಅದ್ರದ್ದೊಂದು ಕಾಪಿ.
Howdo copy
ಯಾವ್ದು ಕಾಪಿ ಕೊಡಂಗಿಲ್ಲ, Your Honor.
So there are marked documents, sir.
Some
ಅಲ್ಲ,
mark
marked
it
documents.
ಇರ್ಲಿ.
forensic problem agadi.
ಆಯ್ತು, ಇನ್ನು ನೋಡಮ್ಮ, ಇತ್ತೊಳಿ, ನಮ್ ತೊಳಿ, ಕೊಡಿ ನಮ್.
I'll give one second.
ಒಂದು ಇಟ್ಕೊಂಡು ನೀವು ಆರ್ಗ್ಯೂ ಮಾಡೋದು ಹೆಂಗ?
Last occasion
Lord,
only the court.
of permission, reason of 22, this compilation, my lord, kindly please to ask if at all there is any mistake in calculation. So there is, my lord's, a blunder of Himalayan proportions in terms of calculation. If my lords may kindly, my lords, peruse page number 22, my lords, which is a part of exhibit P13. Now, my lords, the.
But you are a very efficient lawyer, everything all right. Dhani is here.
Permission.
No,
I sought
You
his
whisper
permission.
whatever you want.
I sought his
Or you
permission.
take his permission and.
I sought his
No,
permission.
I said he
I
wants
sought
to
his
explain one
I have
particular.
great admiration for his advocacy
No, no,
also.
Please, please, please.
Please tomorrow, day after.
Please.
Day after.
I'll explain it day after.
ಅವತ್ತು ತೋರಿಸಿ.
Please.
ತೋರಿಸಿ. ಅವ್ರಿಗೆ ಕೊಡಿ. Take.
I'll give the presentation.
Take our copy. ಹೆಂಗ್ ಆರ್ಗ್ಯೂ
ನಾನು ಕೊಡ್ತೀನಿ.
ಹಿಂಗೆಲ್ಲ
ನಾನು ಕೊಡ್ತೀನಿ ಸರ್.
ಆರ್ಡರ್ ಅದ್ ನೀವು ಬೇಕಾದಷ್ಟು ಆರ್ಗ್ಯೂ ಮಾಡಿ, ಬಟ್ ನೀವು ಏನೆಲ್ಲ ಪೇಪರ್ಸ್ ನೋಡ್ತೀನಿ ಒಂದ್ ಕಪ್ ಕೊಡಿ.
ಕೊಡ್ತೀನಿ ಸರ್.
ಸೊ ದಟ್ ದೇ ವಿಲ್ ನೋ ವಿಲ್ ಬಿ ಆನ್ ದ ಸೇಮ್ ಪೇಜಸ್.
Mark documents ಕೊಡ್ಲಿ ಸರ್. I'll give it. I bought.
ಜನರಲಿ ಯು ಆರ್ ಮೆಗ್ನಾನಿಮಸ್.
I'll give it.
I am for the respondent, my lord.
My lord, WC matter, madam. WC.
Undertaking given to this honorable court is violated.
Lordship, I have filed a wakalat for accused, Your Lordship, on 13/9/2020. No, seek accommodation to file affidavit, Your Worship. Narayan V.H.
Appellate, my lord. My lord, in the short point, my lord, already disposal of matter, my lord. This is the tomorrow, my lord. Tomorrow. Illa the disposal of matter, some direction is there.
Please.
Tomorrow, my lord.
My lord, custody of child was sought by the grandparents, my lord, wherein they were having only son. He has died, please.
Serial number 18. Serial number 18 not count. But since there is urgency, in this matter, I have filed the application for vacating the entry order. What happened, my lord? The single judge has granted the stay for a period of 8 weeks on 19/7. That expires 19th of this month, my lord. For that, my lord, the Worship has granted the stay. Therefore, my lord, I am seeking, my lord, urgency. They have challenged the, my lord, entry order passed by the learned single judge.
My lords, there is another connected matter, my lords.
Madam, date maybe.
My lord, serial number 21. 21, my lord.
Lords, 22 notice 18. 22 the notice. 22 also
22
notice.
notice of 22 contempt the notice of. Yes.
Please.
22.
22 very date.
No. How?
It notice contempt. Please. Please. Illa stay, Lordship. Since there was a delay, Lordship did not granted any interim order. Please. Illa complaints yavu illa. How?
Notes, tomorrow notes, because on 19th, in the departmental inquiry, the evidence is, it is posted for evidence notes. On the same charge notes, 2 inquiries are being conducted. No notes. Notes, already one inquiry was pending notes.
No.
Please, on same charge notes.
Illa.
Notes tomorrow.
Really?
Notes.
14A, on the basis of 12-3 report, my lord, we have issued a 14. Adhan stop, adu idu agide, my lord.
Notes.
Close, what his
Not
contention, my lord, the deputy commissioner has initiated an inquiry. Anta. Later, my lord, in view of the 12-3 report, my lord, we have passed a 14A order. Now the local actor is conducting an inquiry. Our the contention is, since earlier, deputy commissioner has conducted an inquiry. Anta, that we already closed, my lord, in view of ಅದನ್ನ ಸ್ಟಾಪ್ ಮಾಡಿದ್ದಾರೆ ಮೇಡಮ್. ಕಾಂಪಿಟೆಂಟ್ ಅಂತಾರೆ. ಪ್ಲೀಸ್ ಮೇಡಮ್. ಹೌದು, ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅಲ್ಲ ಕ್ಲೋಸ್ ಅಂತಂದ್ರೆ ಮಿಲಾಡ್ ವಿ ನೋ ಕ್ಲೋಸ್ ಮೀನ್ಸ್ ವಿ ಆರ್ ನಾಟ್ ಕ್ಲೋಸ್ ದ ಮಿಲಾಡ್ exonerated in view of
first inquiry was in the final stage notes. At that time, they have passed entrustment order notes.
He is not exonerated in the first inquiry. Please madam. ಅಲ್ಲ ಅದ್ರ ಓನ್ಲಿ ನೋಟಿಸ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿದ್ದಾರೆ.
Examine notes. All the witnesses were examined. Please.
Please. if my lord has rightly said, if the deputy commission is not competent, then result. Yes.
Yes, because even the cross objections also will go. That ಇಲ್ಲ ಅದ್ರಲ್ಲಿ ಅವ್ರದ್ದು ಹೇಳಿದಿರ ತಾವು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಟಿವ್ಸ್ ಬಗ್ಗೆನೂ ಹೇಳಿದಿರಿ ಅಲ್ಲ ಬೇರೆ ಬರ್ತೀವಿ ಇಲ್ಲ ಐ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡ್. File necessary application. Mr. Jaykumar Patil appears in that 39.
It's okay. Inform
Yes.
41 with kind permission. 41.
Inform
41
Sir, 44. Still number 44.
I appear for the respondent in the matter.
Other one date ಕೊಟ್ಟಿರೋ ಒಂದು ಮೀಟಿಂಗ್ ಇದೆ ಇವತ್ತು ಪಾಟೀಲ್ ರೇ.
ಆಗ್ಬೋದು.
23.
They are ready to deposit around another 1 crore, which may be approximately 30%. They are saying that main contention is more than 57% hike.
Not 57%, 57 times.
Now they don't have that defense. 2009 acquisition Supreme Court approved at 560 per square feet. In our case, it is 2017 notification.
Now they are saying another 1 crore will deposit per acre.
That will not work out even the confirmed rate that is done.
Sir, we are not dismissing the appeal. It is required to be considered. They have certain difficulties. Sir, if they deposit another 1.5 crore, how much? It may be around 45%, 40%. 7.5 crore is the per acre. No?
This is the interim order by this honorable court. There is a
ಕೇಳ್ತಾ ಇದೆಯಾ ಸರ್?
ಹೌದು ಕೇಳುತ್ತೆ.
ಅದೇ ಇವಾಗ ಅವರು ಇನ್ನೊಂದು 1.5 ಕೋಟಿ ಕಟ್ಟಿದ್ರೆ ಸರಿ ಹೋಗುತ್ತೆ ಅಲ್ಲ?
Deposit. Anyway, we are.
Will consider. Will issue notice in your matters. In your matters also they will accept notice. Will consider on the.
1.5 ಕೋಟಿ ಈಗ ಆಸ್ ಇಟ್ ಈಸ್ ಅವರು 3 crores ಆಲ್ಮೋಸ್ಟ್ 3 crores ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು. 3.5 per acre 3.5 ಡಿಪಾಸಿಟ್ ಮಾಡಬೇಕು. ಉಳಿದವರಲ್ಲಿ ಡಿಪಾಸಿಟ್ ಮಾಡಿ ವಿಡ್ರಾನು ಆಗಿದೆ.
ASG is saying that he will deposit 1 crore now.
Apex court statistics ತಗೊಂಡ್ರು ಸಹಿತ it will not work out that way.
That is the
Depends on per acre.
Even going by that also it will not.
No, it is not a final one. It is only an interim stage.
Apex court decision is my lord.
ತಗೊಂಡ್ರು ಅಷ್ಟು ಬರಲ್ಲ ನೋಡಿದೆ ನಾನು.
A 560 is confirmed by the Apex court.
For the same acquisition.
No, it is 2009.
2009 acquisition for same purpose.
Same purpose.
Same project.
Having heard both the sides, we are of the.
Therefore, my lord, considering the same, this
So requiring deposit. inquiring body, the respondent shall deposit a sum of rupees, another additional sum of rupees per acre before the reference court. 8 weeks. First,
They have not filed modification application.
yeah, correct.
With kind permission. Serial number 41, my lord.
Yes.
There is appeal by the state, my lord. There is undertaking by the respondent saying that they will not precipitate the matter. But last date, my lord, it was not extended. 41, my lord. So it is a interim order extended. Their undertaking is there. They have given undertaking. They have given undertaking on 15/12/2021.
Senior council is in VC, my lords. VCL is there.
They have given undertaking.
Senior council.
Which council?
Ashok Harner.
So they have given undertaking on 15/12/2021. They will not precipitate the matter before the executing court. That was not extended in last date of hearing. This is a
Matter shall not be precipitated till next date of hearing. Call this matter on.
any date. Next. Please.
Number 12. Murtunja Helikeri.
My lord, I'm at serial number 33, party in person. I have come from Bangalore, my lord. Kindly have it tomorrow.
You'll stay back.
Yes, please.
Request, my lord. Reach or no, we'll have it tomorrow, but it may reach, may not reach also. Try your luck.
Please.
Next party in person.
Serial number 12, Lord. Appeared 1,50,000, Lordships. Remaining about day after tomorrow, we'll pay it to Lordships.
Call this matter day after tomorrow.
Please,
Lordship, serial number
Lord,
23.
his presence may be dispensed with the Lordships. Lord, one submission, Lordships. Lord, may I submission, Lordships? His presence may be dispensed with the Lordships day after tomorrow.
ಅವ್ರು ಬರೋದು ಬೇಡ ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಲೆ ಬರೋದು ಬೇಡ
Please, Lordship.
ಅಮೌಂಟ್ ಕೊಡ್ಲಿದ್ರೆ ಬರ್ಬೇಕು
Please.
On not paid on the 18th ಇದೆಲ್ಲ ಇದು
Murtunja Helikeri.
20th.
We'll hand over it.
Otherwise he has to come.
Day after tomorrow, we'll be
ಚೆಕ್ ಕೊಡಿ ಅವ್ರಿಗೆ ಎಲ್ಲಿದ್ದಾರೆ
ಮುಟ್ಟಿಸ್ತೇನೆ ಸ್ವಾಮಿ, ಅಲ್ಲಿ ಬಂದಿಲ್ಲ. He's not here, Lordship. I will hand over the check to you, Lordship.
20th 9.
Please, your Lordship.
19,
19, your Lordship.
20th.
But please, your Lordship. Please, your
Lordship, in serial number 23, your Lordship, there was a connected matter. List.
ಸರ್ ಇವ್ ಎಷ್ಟು ಮಾಡಿದ್ರೆ ಒಂದು ಎಷ್ಟು ಕೋಟಿ ತುಂಬಬೇಕಂತ ಮಾಡಿ ಗೊತ್ತಾಗಲಿಲ್ಲ.
ಒಂದು ನಿಮಿಷ ಇರಿ.
ಅವ್ರು ಹೋಗ್ತಾರೆ, ಇವರು ಸ್ಟೆನೋ ಹೋಗ್ತಾರೆ.
ನೋಟಿಸ್ ಆಗಿದೆ. ಅದು ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಬರ್ತದೆ. ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ ಅದು, ನೆಕ್ಸ್ಟ್ ಬರ್ತದೆ.
ರಾಮ ಅಲ್ಲ ಸ್ಟೆನೋ ಹೋಗ್ತಾರ್ರಿ. ಸ್ವಲ್ಪ 44 ಎಷ್ಟು ಕೋಟಿ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗಲಿಲ್ಲ.
ಏನ್ ಸರ್
44 ಎಷ್ಟು ಅಮೌಂಟ್ ಕಟ್ ಅಂದ್ರೆ ಗೊತ್ತಾಗಲಿಲ್ಲ ನನಗೆ, ಅದಕ್ಕೆ ಚೂರು ಅಮೌಂಟ್ ಎಷ್ಟು 44 ಅಮೌಂಟ್ ಎಷ್ಟು? 1 ಕೋಟಿ. another 1 crore. another 1
ನಿಮ್ದು ಎಷ್ಟು 33. ನಾಳೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ.
ಈಚ್ ಕೇಸ್ ಒನ್
ಟಾಪ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಇಲ್ಲ, ರೆಗ್ಯುಲರ್ ಬರುತ್ತೆ, ನಾಳೆ ರೀಚ್ ಆಗುತ್ತೆ.
We don't want to hear what should be very
12/20th. ಅದೇ ಚೆಕ್ ತಗೊಂಡ್ರ ನೀವು? ಇದ್ರಲ್ಲಿ
16.
ಜಗದೀಶ್ ಸೆಲ್ ನಂಬರ್ 16 ಅಲ್ಲಿ
ಸರ್ ಯಾವಾಗ ಅರ್ಜನ್ ಆಗಿದೆ ಅದು?
ಸೆಲ್ ನಂಬರ್ 16 ಅಲ್ಲಿ ಅವರು ವಕಾಲತ್ ಹಾಕಿದ್ರು ಅಂತ ಹೇಳಿ
ನಮ್ಮ ಹೆಸರು ಶೋ ಆಗಿಲ್ಲ ಅದರಲ್ಲಿ.
18 and 32. 18 ನೋಟಿಸ್ ಆದಂಗೆ ಆಯ್ತು
ಸರ್ ಹಂಗೆ 16 ಒಂದು ನೋಡ್ಬಿಡಿ ಸರ್. 16 ಯಾವಾಗ ಹೋಗಿದೆ ಸರ್? ಅಲ್ಲಿ ಇಟ್ಕೊಂಡಿದ್ದೀರಾ? ಹಿಂದಿದೆ ಸರ್
ಅಲ್ಲೇ. next week.
ಸರ್ 16 ಒಂದು ಹೇಳಿ.
16 next week.
16
next week. 32, 16, 10.
Sir, serial number 425.
Further. 32, 39. ಯಾವ್ದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆಯಲ್ಲ ಅದೆಲ್ಲ ಡಿಸ್ಮಿಸ್. ಹೌದು ಹೌದು, ಯಾವ್ದು ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆಯಲ್ಲ ಅದೆಲ್ಲ ಹೋಯ್ತು. ನಾನ್ ಕಂಪ್ಲೈನ್ಸ್ ಇದೆ ಅಲ್ರಿ ಸಬ್ಮಿಷನ್, ಅದು ನೀವು ಯಾರು ಇರ್ಲಿಲ್ಲ ಇಲ್ಲಿ ಮತ್ತೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು. ಒಂದು ಕಾಪಿ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಳ್ಳಿ ಅಂತ. 32 ರೀಚ್ ಆಗಿಲ್ಲಲ್ಲ ಡಿಸ್ಪೋಸಲ್ಗಲ್ಲ, ಅಲ್ಲ ಡಿಸ್ಪೋಸಲ್ ಇತ್ತಾನೆ ಅದು. 16, 10. ಅಯ್ಯೋ ಆಗ್ಲಿಲ್ಲ. ಎಂಟ್ರಿ ಮಾಡೋರ್ ಇದೆಯಾ ಅದರಲ್ಲಿ? ಹೇಳ್ತೀನಿ